YouTube, good morning. It was a long day yesterday, 12 hours, but I forgot we have a CCC meeting today at 10 o'clock. You think I'm going to let Mary Alice off that easy? Not a chance. Plus, sometimes Commissioner Roy thinks me broadcasting the meetings is literally putting them on the TV, so I like to make her feel like she's on the TV. I've never talked to her. I just like to make her feel like she's on the TV. All right, hello, Tao friends on Tao YouTube. Good morning. Roll the intro. Intro. Hold on. Intro. Oh, no. What do you mean? The intro, ladies and gentlemen, has been removed. Oh, no. I'm going to have to restore the towel intro. Don't worry about it. I'm here. I feel so bad. The towel intro has been removed. I was cleaning up my computer this morning. I removed the towel intro. Oh, no. Well, it's okay. We don't have a lot of time until 10 a.m. anyway. Hello. It's wonderful to see you. Don't worry. I forgot to announce this yesterday. Absolutely no worries. I apologize for forgetting to do that. There is a Massachusetts Cannabis Control Commission meeting today. That is a government regulatory agency at 10 a.m. Now, there's going to be a bunch of stuff that's going to be discussed at that government regulatory agency meeting. In particular, they're going to be talking about testing lab fraud and the summary suspension issued to Assured Testing Labs that was effective, I believe, July 1st or July 4th of 2025. Now, this has to do with total yeast and mold contamination, and in particular, the various types of testing methodologies that are deployed to test for the presence of total yeast and mold pursuant to 935 CMR 500.000 and 935 CMR 500.001. And that's a little bit of obscure pieces of information, but among the other sort of things that I juggle in my life, one of the things I do is I cover this regulatory agency, in particular related to its oversight of various industry actors. Now, I am tired. I broadcast for 12 hours yesterday. There was a lot going on in the Aidan Kearney case. To say there's a lot going on is an understatement. My brain's a little razzled, but we're here. I'm here. I have not eaten again this morning. That's okay. I'll eat after the CCC goes live. Thankfully, I don't have to talk that much today because they just talk. Sometimes they talk about Cape Cod potato chips. Sometimes they talk about petty personal fights. Sometimes they just talk. Okay, they present data. They just talk for hours, which is great because that means I can just listen and I don't have to talk. Anyway, that's going to start about 10 a.m. this morning, so thanks very much for tuning in. I know that I forgot to mention this yesterday because, in my defense, we went for 12 hours and I worked as hard as I possibly could while sitting in my chair yesterday, and I got a little tired. So I forgot to announce that I was going to cover this today, so I announced it with an hour to go because I wanted to troll Mary Alice, because Mary Alice is the press secretary or the communications chief for the CCC, and trolling Mary Alice is one of my life passions. You don't understand. You want to troll me with an official government promulgation? Okay, I'm going to troll the fuck out of you. And that's exactly what it's a form of petitioning the government. I don't know what to tell you. I don't think the founders necessarily envisioned trolling as a form of participatory democracy. But I say to you, ladies and gentlemen, that trolling is an unenumerated right under the First Amendment. And if I want to petition the government by trolling Mary Alice, that's what I'm going to do. Anyway, my name's Grant Smith Ellis. This woman, I'm certain I have just undermined her entire PR strategy. Well, it's kind of like Roblox going at that guy Schlepp. Roblox, if you haven't been following this Roblox drama, let me just tell you, they're going to find themselves under investigation by the federal department, or by the Department of Justice and other federal authorities. Let me tell you that right now, on a bipartisan basis. They banned this very nice guy, Schlepp. He was a victim of grooming on Roblox when he was a kid, and so he became this kind of powerhouse of a force where now Roblox, for the parents out there, we're going to take a slight aside because I just really want to talk about this story, and I'm very proud of Schlepp for what he's been doing. So Schlepp is this guy on Roblox, and what he kind of does is, if you're a parent out there, you've probably heard of Roblox, and it's this platform used by a lot of children. It's kind of cool because you can develop your own games for it, so it encourages children to learn how to interface. Not really MySpace, like HTML style interface, but it's like a rudimentary GUI that allows people to both. It's like an app mostly on tablets, and if you don't know, kids use tablets a lot these days. Okay, so the kids go on the tablet, they move the little character around. And it's your little, it's kind of like a Lego character, but it moves this little digital character around, and they have all this, have fun, and they collect coins, and it has something to do with, Italian, like this weird version of Italian language. They meme a lot on there. Basically, they like to meme. They play these games where they collect coins and then they spend them on like outfits and like various like Italian. Right now, the big thing is like Italian speaking. Like it's some like Italian language. I don't know. Anyway, that's not relevant. The point is, I want to talk about this for 5 minutes because Roblox is a great platform in the sense that it encourages younger people to learn how to interface with a GUI that teaches them how to develop games. So you have to think of Roblox as kind of like a platform. It's not like a game in and of itself. It is a platform where you can play games that are developed by people who use a preset sort of spectrum of resources or assets, as they're called, and they deploy them to facilitate like different types of games. The problem is that Roblox user base is very young and it's very susceptible to exploitation, and the company has a profit motive to look the other way. So there are these people like Schlep, and you'll see this all over the news. It's going to get bigger and bigger and bigger and bigger. There are these people like Schlep who got groomed on Roblox as kids, okay, and were victims. And then as they got older, they know how Roblox works. And adults really don't understand how Roblox works. A lot of these platforms are very niche. They're very like meta in the sense that if adults understood how they worked, kids wouldn't be interested in them, because part of how kids hide in plain sight these days when doing bad stuff is they prey on the fact that adults have no idea what they're doing. So anyway, Schlep is someone who goes on Roblox and kind of exposes all of this content. And let me just tell you right now that it is very impressive that Schlep has managed to fight this company single-handedly. He's just a user on Twitter and other social media. Schlep goes around on Roblox and exposes predators who set up games that violate Roblox's terms of service in order to facilitate preying on children. And you might be saying, oh my dear God, how is that even possible? Well, it's because it's like it's a check by Roblox. Like you create the game and then it gets reported, and then Roblox checks and balances it by reviewing it. Well, there's a bit of a problem here because there's examples, and I'm not going to put any of them up on the screen because they're disturbing. Even though they're digital images, they're disturbing. There are games that are designed to facilitate the sharing of personal information, to like literally like kind of bring children into like sexualized situations and then get them off platform to abuse them. Okay, that is very serious, and Schlep is the kind of person who understands the nuances of this because they were preyed on as a child, and now he goes and hunts the people who do this, the predators. Okay, now what Schlep does to do this is he has adults who, he's like 18 or 22 or something. He's an adult now, but he's a victim, and he's very sensitive to victims. He has adults who are over the age of 18 go onto Roblox and masquerade as children so that they can bait, it's called a honeypot, bait the predators. And then what Schlep does is, because Roblox doesn't always necessarily promptly effectuate reporting to law enforcement, Schlep brings in the FBI or the local law enforcement or whoever the fuck, and then they go in and arrest the predator. Schlep's investigations have led to the arrest of no less than 6 child predators. Okay, he's a boss. Okay, he's a fucking boss. Now, the really interesting thing about this is last week Roblox banned him from the platform and sent him a cease and desist, and then started a PR campaign calling him a vigilante. What was really going on? Oh, goodness. Well, what was really going on was that Roblox, according to some lawsuit documents, is aware of this problem. They try to work with the National Center for Missing and Exploited Children. They try to refer things to the FBI, ostensibly, but they don't really action the content proactively because it would drive users from the platform. That's what is alleged in testimony from a former Roblox engineer in a civil lawsuit. Okay? So Schlep gets banned from the platform. They send him a cease and desist. There's one, he's only like 22 or something. He's like 18 to 22. This one kid goes on social media, and I was talking to him like 4 days ago, and he's like, fuck it. Like, these people are covering something up. He starts petitioning the Congress. He starts petitioning the Roblox channels. He starts petitioning like people like journalists like me. All of us start covering this thing. It gets into Wired. It's on the 2 congressmen, a Republican and a Democrat, Ro Khanna and another congressman. Hello, you have fun on your run, Faith. Well, I'm going to broadcast a regulatory hearing at 10, and I'm talking about this really inspiring guy, Schlep. I don't want to put the images up on the screen because it's disturbing, Rightfully so, though. Like, parents should understand that if you put your children on Roblox without knowing what you're doing, you're exposing them to the potential of being able to access some of the games that Schlepp is trying to bring to public attention. So anyway, Schlepp starts this campaign, okay? It's like, this is a multi-billion-dollar company with a CEO who, like, went to President Trump's inauguration. Not that that's commentary on President Trump. I'm just saying this is a heavy-hitter company. He took him on single-handedly. Their PR department starts labeling him a vigilante. That causes a Streisand effect, wherein all these national publications and half the internet burns down Roblox, basically, and that's what's happening this morning. Okay, so Roblox tried to put, like, a crisis statement out yesterday, doubling down on the vigilante claims, and now the whole internet is just upset at Roblox, rightfully so. But a byproduct of this, which is why I think we're moving into a better era of humanity, a byproduct of this is the reason parents weren't actively monitoring Roblox is it's hard to understand what it is. It's kind of like talking to parents about, let me use an example, like your children who are 9 years old may be really interested, or 15 or whatever, in like Fulio versus like Young E. Nace, okay, down in Jacksonville. They may be really interested in Tukaville in O-Block out in Chicago, okay? They may be really interested in the stratification of the Bloods and the Crips into the GDs and the BDs. They may know everything about, like, King Von's ops or whatever, like specific social media posts. The reason this is happening is the same reason that Roblox is being able to permeate in the national consciousness, which is parents would rather their children just be passively consuming content that they don't understand, even if it's harmful, as long as they're quiet. Now, I'm not speaking about any parents. Listen, I have seen my own cousins. I've seen them fall victim to this. This is how I know about this. I was just at my father's funeral, celebration of life a few months ago, and this came up. I watched them, like, talking about this stuff and playing on Roblox. This is why I got so concerned. And so, anyway, we have this situation where it's very easy to let children consume content that looks ostensibly okay. Like, it looks like just music, or it looks like just a game on a tablet. But really, it's pernicious, okay? It's either gang culture in the music scene, or what's worse, and like murder-based gang culture. Like people who have bodies on them that make songs about it, that then children want to learn about because there's interesting sort of socio-political dynamics behind the songs, where if you like learn about Parkway Gardens and O-Block and all that stuff, you'll find out that it's not just a song, it's a whole culture represented in a motif that is a song, and these people have bodies on them and they brag about it. It's a little weird. I think it's all a federal op. Personally, I think that a lot of those hip-hop artists, even though they're hitters, are just federal agents or federal CIs, like 6ix9ine's a good example. But Roblox is just by analogy. I don't mean to get off topic here, and I'm just waiting for the meeting to start anyway. Roblox, and I don't want to talk about the testing lab fraud. You can listen to them talk about it. I'm so tired of talking about it. I don't know how much more you want me to say about it. The testing lab fraud, it's cascading across the country. But anyway, Roblox is really dangerous, and Schlepp got banned because he started bringing this attention to how the platform was exploiting parents' inability to understand the nuances of this game and the way it works. So Schlepp gets banned, starts this movement. It's now in every national publication. It's started to get to Congress. I'm sure the DOJ is going to investigate them. You know what the DOJ is going to find? They're going to find that this company made a conscious choice to not proactively use algorithmic filtering to target this kind of behavior, and instead enabled it because it was a passive way, negligence by omission, in my opinion, to facilitate shareholder profits. Okay? It's very simple. It's not really hard to understand. What's hard to understand is why they Streisand affected it. What you do is you shut the fuck up, and you say nothing about Schlepp doing that and let him keep reporting shit to the cops, and everybody's happy. He gets to report things to the cops and prevent these people from abusing your platform. The cops develop better processing mechanisms for dealing with these reports. The NEIMC can then liaise with you to develop proactive monitoring. Everybody wins, which means the only reason that Roblox did this, in my opinion, is because Schlepp was going to bring to the national attention, and now it's really happening, which is a rightfully deserved fate for Roblox, the fact that their platform is very susceptible to abuse because parents don't really understand it. Hello, Jesse. It's great to see you. I'm covering a regulatory hearing today, and I'm also talking about this guy, Schlepp. You should check out this story. You'll see it in Wired, New York Times. You'll see it everywhere right now. Roblox is burning down. If you're a parent and your children use Roblox, please pay attention to Schlepp, S-C-E-H-L-E-P. He's in literally every news article. It doesn't even matter. Democratic supporting, Republican supporting. There's going to be chaos for Roblox because of what Schlepp has uncovered. And it didn't have to go down this way. And the only reason I think Roblox targeted him is because Schlepp was not just getting these predators held accountable. He was starting to raise awareness to parents that Roblox is a platform that can be exploited. Any platform can be exploited, by the way. I don't want to make it like you could exploit Google if you were a predator. You could exploit Twitter. It's not whether if there's a predator out there, they're going to exploit any platform they can. But the issue is what the platform does to respond to it when they're made aware of how it's being done. Platforms understand their back-end software better than anyone else and the way the code functions. So you can make a conscious choice to drive people away from your platform by proactively monitoring for this. Habbo Hotel's a good example. Club Penguin's a good example. If you want to create a game that's going to attract a younger audience, you have a duty. I would say, I'm not a lawyer, this is not legal advice, I would say you have a common law and a statutory duty to the children, okay, under multiple different federal and state statutes. You have a common law duty to protect them. And if you're going to run, like Disney, as much as I don't really like their Musketeer Club thing and how that all played out and Diddy's involvement, whatever, that's scary. I think Disney does a far better job like developing these online web-based games for children than Roblox right now. And we need to have regulation of children's access to these platforms, and you can't expect children to regulate themselves. I don't want to go down the path of requiring people to upload IDs. Okay, that's very dangerous. I don't like how it worked out in Britain. But I'm very concerned that these companies are not going to regulate themselves. Just like in the cannabis industry, they're not going to regulate themselves. Some of them will. But one bad apple spoils the whole bunch. One bad platform like Roblox is going to attract so many children that if you have flaws in it that facilitate exploitation, and then your company's reaction to it is that you double down on preventing reform, you have to be regulated. I'm sorry. You potentially should be investigated by the Department of Justice. I'm sure they're already under investigation, in my opinion, based on the congressional referrals. But more so than anything else, you're going to get regulated, and you should be regulated. Our laws and our regulatory frameworks are not adapting to the developments in digital technology, and setting aside whether we think there's too much government regulation, whether the bureaucracy is corrupt, whatever. Fundamentally, we cannot just abandon the project of regulating companies because there's emergent technology that absolutely must be subject to regulatory oversight, and we'll talk about it in the context of testing lab fraud today, and it makes a perfect corollary. That are going to do whatever they want to drive up their profits unless we actively intervene as a society in different countries, different states, and regulate them. Okay, companies don't do things to protect vulnerable people unless you force them to. That's not big government. That's making sure that companies are accountable. And you might say, well, it's a free market. It's not a free market. Read Adam Smith, read The Wealth of Nations, in particular his analysis of wheat prices in the 1700s, and read the commentary afterwards. You will see that we have never been a free market. We are a regulated market. A free market would literally lead to oligopolies and monopolization in the name of market freedom. That's not what we have. We've never allowed one company to own the entire country. We've never allowed companies to kill people in the name of profits. We've never allowed people to sell tuberculotic beef in the name of profits. That's not big government. That's the foundational pillars of the safety net in our society to prevent corporate greed from undermining in this case, the safety of vulnerable children. So we must regulate this. And I'll go to Congress myself. I don't really want to, but I will go into government myself, if you really want me to fix some of this, because we must develop cogent and rapidly dynamic forms of legal and regulatory oversight related to these platforms. There's billions of children using this around the world. Okay, they're not really being watched. You cannot defer to the parents. It's not the 1980s. Okay, they have unfettered access to technology. The devices don't provide sufficient parental controls to ward off this happening. And in fact, no matter what parental controls you put in place, if you have a GUI client that the child is running as a piece of software on their computer or their tablet, you could have all the parental controls that you want. They're just going to bootstrap in the content that you're trying to prevent them from getting access to. The predators, that is, are going to bootstrap in the content that the children aren't supposed to be accessing by way of the files. Once you have a executable that has permission to run in the graphical user or in the operating environment, which is the tablet, for example, in this case, once the software has permission, it doesn't matter what parental controls you have in place. It's not going to check and balance the code of the software. The software, people like Roblox, the companies deploying them, have to proactively deploy parental controls. We must regulate them. We must force them to do it. If we do not do that, they're going to continue to facilitate behavior that threatens the safety of all of the children of the world, frankly, because these apps are very prolific, okay? Because it makes them a lot of money, a lot of ads, whatever. We have to regulate this. We have to do it right away. And Schlepp is the perfect example. And if you haven't seen this Schlepp story, just Google it. SCHLEP. Every single news publication. It's everywhere. This company is burning to the ground because of one man who they very, very ill-advised, in my opinion. They took a very ill-advised approach to him by attacking him and labeling him a vigilante, which has caused half the internet to expose what Roblox was doing. And now the very parents who never would have found out what this platform was enabling know everything about it, and they're angry. All right? So that's some justice. How about that? We'll see, Peggy. Oh, Jesse, very good. I'm so glad you're going to look more into this. And again, I'm not putting the images on screen because there's no way I can cover what Schlepp uncovered on Roblox without putting they're not real people. They're like avatars, but everything that Schlepp uncovered is really, really messed up. Like, it's like children being targeted by adults using like the Roblox platform, and some of the text they put is really scary, okay? And some of these games that are still on Roblox have been up for like 1,000 days or more. Anyway, testing lab fraud. So, we have a lot going on. I've talked about it before. I only had 20 minutes today. If you thought I was going to do a full overview of the testing lab fraud situation in 20 minutes, no. It's like an hour. But I'll tell you this. The Cannabis Control Commission is going to have a regulatory hearing today. You can see that live event hasn't started. Once it goes live, I'll just bring the coverage up. I have a screen ready to turn us over. And let me just tell you, this regulatory body, okay, and we'll play tile trivia at lunch. This regulatory body did a very similar thing with some companies, not related to child predation, but related to manipulated total yeast and mold testing. There was a release, okay, in the last few weeks of 7,000 or 6,800 or so batches of product that were tested by a laboratory called Assured. Okay, now Assured got its license summarily suspended on July 4, 2025, because they were deploying a type of PCR methodology. It's actually called microarray hybridization. Now, normally to test for pathogenic total yeast and mold concentrations or presence, you would use plating. And in the cannabis industry, as opposed to the agricultural industry, you culture the sample on something like a 3M Petri film for 72 hours, and then you test for the presence of total yeast and mold. However, because there's a rapid turnaround time demanded by a lot of clients, and because there's an incentive to help clients pass product that would otherwise fail, there are also alternative methodologies. Some work, some don't work. Some work for certain pathogens within the total yeast and mold framework. Some don't work at all for total yeast and mold. Some don't. Some have a black box process that I don't even think should have been accredited by the AOAC in terms of validity of the methodology's ability to render accurate total yeast and mold results. Nonetheless, 30,000 foot elevation perspective, we have a 10,000 CFUG colony forming units per gram limit for total yeast and for the presence of total yeast and mold in Massachusetts. In order to test for that, you can do plating, which is the industry standard, for 72 hours. Anyone doing it quicker than that, I get my eyebrows go up. You know what I'm saying? Especially 48 hours. It's not a valid result, in my opinion. Or you can use PCR. Okay, there are different types of PCR kits. Or you can use microarray hybridization, PCR. Okay. Now, Assured was using a form, according to the CCC, of microarray hybridization called Pathogen DX. Now, this is a black box process. You rent the machine from Pathogen DX, or you lease it. You put your sample in that you want to test as the lab that you get from the client into the machine. It interpolates the data. It takes data from the sample. You send it out to Pathogen DX, I think in Nevada. It's owned by this guy named Milan. I talked to him on email once, and then they interpolate the results.
They call the August 14th.
Right. Hold on, I can do this. You know what's fun, Tara? I can just pause the meeting. Anyway, so we're going to hear about how that in particular, Pathogen DX was potentially being manipulated because of the nature of how the testing methodology functions. And then also we're going to hear a lot today, or we're going to hear more in time, about how various other methodologies don't necessarily accurately detect the presence of total yeast and mold. However, it's also important to note that there are some accurate methodologies, and some people are trying to be honest actors. But so long as any labs are manipulating total yeast and mold testing, we have a problem. My name is Grant Smith-Ellis. I'm going to turn you over to the Cannabis Control Commission now. This is newly reappointed Chair Bruce Stebbins leading us off. Hello, and let's begin.
2025 meeting of the Cannabis Control Commission to order. This meeting is being held remote pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioners Concepcion, Roy, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a full agenda today that I will generally summarize. We will start with opening comments from commissioners and approval of 2 sets of minutes. Then the executive director will present the executive director and commission staff report before we proceed to staff license recommendations. There are 2 changes of ownership recommendations, 25 license renewal recommendations, 3 responsible vendor training renewal licenses, and 1 request. I believe that's it. And there are 3 items in the commission discussion and vote section today: tier relegations update, legal intervention discussion, and a social consumption public comment period memo. Obviously, I would anticipate we could take a break at around 12:30 for lunch. Certainly, if my colleagues or anyone from our team needs to take a break, please just raise your hand, let me know. With that, I will ask that commissioners wishing to comment or ask questions during any part of the meeting raise their hand to be recognized.
Acting Chair, I'm sorry, I missed that last part that you just said.
Go ahead, Commissioner Concepcion.
Okay, sure. So good morning, everyone. Good morning to my colleagues, staff, anyone who's joining us virtually. I wanted to start this meeting by first saying happy summer. This is probably our last meeting before we reconvene in the fall. But I wanted to make sure to acknowledge and recognize Commissioner and Acting Chair Stebbins and congratulating you on your reappointment. I wanted to thank Attorney General Campbell, my appointing authority, Treasurer Goldberg, and Governor Healy for your reappointment, because it's critical that we're able to continue this work. I think it's a testament to your work, Commissioner Stebbins, as well as the need for us to continue being productive and doing this work that is so vital to the industry here in the Commonwealth of Massachusetts. I think everyone knows we've been operating at a reduced number for quite some time now, and it's brought its own strains resource-wise as it goes to how commissioners operate in this space. But Chair Stebbins, you have stepped up to the challenge and you've ensured that we've remained steady and productive. And I think that I can speak for a lot of people in thanking you for that. I really look forward to continuing this work together and making sure that we get this work done. I know there's a lot on the agenda today. We're talking about a number of different things, but a continued conversation around social consumption in particular that I know a lot of people are looking forward to. There's a lot of eyes. There's a lot of work that's gone into this. So I also want to commend the working group as well, former Commissioner Camargo, as well as you, Acting Chair. And I just look forward to the conversation conversation. I always like whenever we're talking policy, whenever we're doing the work that is spelled out by the law as regulators. So I look forward to the conversation, and thank you.
Thank you, Commissioner Concepcion. Commissioner Roy.
Thank you, Acting Chair. Good morning to you and my colleagues and the entire team and to everyone listening. I want to echo the sentiments of Commissioner Concepcion and start by congratulating Acting Chair Stebbins, and you've gone where no other person has gone before with this. So congratulations on your reappointment, and we were so excited to get the news yesterday. And I just want to thank you as Acting Chair for your leadership to help ensure and promote public health, public safety, welfare, and fairness in the industry to make sure that and ensure that it's healthy and it's vibrant. I also want to thank you for your collaboration and your support. We've worked together on so many different initiatives, and I'll just a couple, micro businesses, making sure that's a more lucrative license type. I know we've done so many tours together, and we worked for the First in the Nations. We worked jointly together on the First in the Nations driver's education for cannabis impairment. And I just want to also thank you for your support for different initiatives I've worked on, most recently Administrative Order number 5 to bring accessibility, consistency, and transparency around certificates of analysis. So I want to thank you for your support on that, and just that your leadership and your collaboration and your friendship as well. So I just want to acknowledge that and congratulate you. And just very briefly, I just want to thank Alternative Compassion Services, which is co-located adult use and medical use in Hull. They had a ribbon cutting over the last couple weeks for their adult use, and it was attended by numerous local officials. So I want to thank them for inviting me to be part of that special day. And I also want to thank Carolyn Pino from STEM Haverhill, who invited me to be her very first guest on her new podcast, Freshly Guarded. So I just want to thank her as well. So looking forward to today's meeting. I know there's a lot of topics, but I'll end it the way I started it. And congratulations, Acting Chair Stebbins.
Commissioners, thank you very much. Humbled by your very kind words, but certainly have thoroughly enjoyed the opportunity to work with both of you, as well as humbled by the opportunity to work with the incredible team here at the CCC. A lot of good work is going on. There's certainly more to do. This is an industry that continues to evolve and change and has both opportunities and challenges in front of it. So I'm looking forward to the opportunity to collaborate with you both, at a time when we're down a person or two, but the work continues, and I greatly appreciate all the time and effort that all of you are putting into the work as well. For me, just a couple of updates. Actually, one came across last night. I want to acknowledge one of our licensees, Devin Alexander from Rolling Relief, who was recognized, I think, by the Boston Business Journal for being a leader in the 40 under 40 recognition program that they have. Had the chance to visit with Devin on Monday. So I had the chance to visit Hidden Wonders, a new dispensary that just opened in Plymouth. Enjoyed stopping in, meeting their team. They had very complimentary words about has been working with them to get them ready for their opening, and they're having their grand opening later this month. Monday, had the opportunity to visit Essex County, the North Shore, tour Levia, the infused seltzer manufacturer. Great to tour their facility and visit with their team. Excited to hear about their plans and the opportunities that they see in the marketplace. Had a chance to participate in that tour and also participate in a licensee roundtable. Thanks to the Cannabis Business Association, Dave O'Brien, for pulling the roundtable together. Great discussion with the licensees, the opportunity to share with them what is going on at the CCC, what we're working on. They raised issues including accounts receivables, HCAs, descheduling, agent registration, medical program deverticalization. What's interesting to me is there's always back and forth with commissioners, but at the same time, it's always great to see the conversations that happen between licensees during those roundtables. So again, my thanks to Levia for hosting me for the tour, and Dave O'Brien, the CBA, for hosting the roundtable. After the roundtable was over, Mr. O'Brien and I toured a SEP-owned dispensary, Terpene Journey in Swampscott. Ownership explained their efforts that they use to try to educate consumers about terpenes across every product. They also allow customers to search products by categories such as whether the product is coming from an SEP-owned firm, whether it's coming from a local licensee, and other categories. So a really unique approach to how they're pulling in, educating, and capturing their customer base. As Commissioner Roy just mentioned, they offered a shout out to the commission for, again, requiring the COAs to be updated in a metric. So thank you, Commissioner Roy. They shared that it helped them with avoiding delays and getting their products out on the shelves when they arrive. Also had the chance this week, along with the ED, to visit with one of our CAB members, retired Chief Carmichael, this week. Great to visit with him. We discussed social consumption. We discussed delivery to restricted communities. So greatly appreciate his interest in thoughts on these issues and many others. So again, thank you to my colleagues for your kind words, and thanks to our incredible team. Looking forward to continuing our work together. With that, I will move on to minutes of approval. Thank you to our secretary, Commissioner Concepcion. We have 2 sets of minutes up for approval. The June 12th, 2025 meeting and the June 17th, 2025 public meeting. Those were all included in your board packets. I would seek a motion to approve the June 12th, 2025 meeting minutes. Do I have such a motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy?
Second.
Okay, motion been made and seconded. Any further comments, questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye, 3 in favor, none opposed. Next, I'll seek a motion to approve the June 17th, 2025 public meeting minutes. Do I have such a motion, Commissioner Roy?
So moved.
Do I have a second, Commissioner Concepcion?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion?
Aye.
Commissioner Roy?
Oh, aye, sorry.
No worries. And Commissioner Stebbins votes aye, 3 in favor, none opposed. All right, thank you both. Next item on the agenda, we'll move on to the Executive Director and Commission Staff Report. We have a number of items under his report, so I will turn it over to the Executive Director. Good morning.
Thank you, Mr. Acting Chair. I'm going to leave it on this slide for the moment, and I can see it for the folks who are managing this. Just a quick primer. As the chair mentioned, there's a significant amount of materials under the ED report today. First, on behalf of myself and all staff, I want to echo Commissioner Concepcion and Commissioner Roy in expressing our congratulations to Acting Chair Stebbins on reappointment to a new 5-year term. We look forward to working with the acting chair and the board on the many exciting initiatives underway at the commission, and we're very happy to have clarity as we move forward into September on a lot of work that has been done over the summer. If we can move to the next slide. Thank you. And so looking ahead, I'd just like to point out on this summary slide, I note in an effort to schedule out a variety of periodic updates to commissioners, for items under delegated authority, the September 11th ED report is currently intended to update budget information from myself and the CFAO, including a closeout of the FY25 budget and a revised spending plan for FY26 based on the final approved budget. Additionally, recruitment and retention updates will include the demographic report and an update on the current hiring freeze for myself and the CPO. There are many periodic reports that I'm looking to set up for a regular cadence at public meetings under this ED report mechanism, so you can also anticipate a draft 6-month schedule coming shortly. For today's report, I'm going to highlight the topics identified on the agenda, as we'll have a variety of speakers and presenters. The slides, if not viewable to the audience for any reason, are uploaded to the website on the agenda page to help the viewer follow along with these materials. For the items listed on the left of the screen related to today's report, I have a few initial comments for context, and just due to handing it off to the first presenter, I'm going to go in reverse order as they're listed on the screen here. So in reverse order, you'll receive updated licensing data per our regularly scheduled reporting from the Director of Licensing, and then the first update for host community municipal equity progress under Chapter 180 from the Director of Investigations, which will become a regular update until we reach full compliance. We'll have 2 reports regarding activities under delegated authority, which will also become periodic reporting items for future ED reports. First, a summary of petitions for changes to regulations from General Counsel, and then a summary of waiver requests of regulations from Enforcement Counsel. The acting chair will also discuss a future agenda item regarding the delegations themselves, whereas today's reports are related specifically to the presentation of data. 2-factor authentication for the medical IT platform MMJOS from the Chief of Staff, who manages the Constituent Services and Medical Program, will summarize any impacts to service providers, and the CTIO will be available for any questions on the IT security aspect of this change. But first today, we'll start with an update that was mentioned at our July 10th meeting and was planned for an initial discussion at today's meeting, the Public Health and Safety Advisories portal. The Director of Digital and Creative Services, Anne-Marie Burt, will review the creation of the portal and walk through the user interface. Please note, for items not related to the portal itself, you may direct those questions to me and I'll ensure that they are routed to the proper staff member. I'd like to summarize a few points about the most recent Public Health and Safety Advisory before the Director reviews the portal itself. The PHSA was issued on August 6th related to an enforcement action which identified 544 lab samples that previously failed total yeast and mold testing. An incredible amount of work from our investigations and enforcement team working with our data team led to the information that is within the portal. The portal contains products that went through the supply chain to be sold to consumers and patients that individuals can now cross-reference to determine if they purchase potentially contaminated marijuana or marijuana products. Separately, significant effort was undertaken by INE to issue administrative holds requiring licensees, MEs, MTCs, and delivery operators specifically to either dispose or transfer the affected product back to the originating cultivator or manufacturing licensee, or maintain the product in its inventory during the Commission's enforcement action investigation. As such, those licensees are required to notify the Commission of its intended actions within 10 business days of the effective date of the administrative holds and update the Commission accordingly should the proposed actions change, Communications with licensees and industry representatives on next steps for those products that were still on shelves has been clear and concise, and I appreciate the collaboration that we had with these licensees and industry representatives to handle such a significant effort. The portal is an important compliance tool to transparently communicate with the public when the Commission has identified public health and safety concerns through its enforcement actions. With that summary, I'll ask that Director Burt provide you with an overview of the portal, and then she can answer any questions on the portal, and I can help direct any questions that are not specific to the portal itself. Director Burt, please take it away.
Thank you. Good morning, and thank you all for having me. It's great to see you. As introduced, I am Anne-Marie Burt, Director of Digital and Creative Services, and I will be presenting this morning on the Commission's new Public Health and Safety Advisories portal hosted on the Commission's website. Slide, please. The Public Health and Safety Advisories portal, of which you see a screenshot on the right of this slide, was launched on Wednesday, August 6th at the URL listed here just prior to the public release of the latest Public Health and Safety Advisory of the same date. The content strategy of the portal begins with an email sign-up form for users to be added to the Commission's distribution list of future Public Health and Safety Advisory email notices. There is then a call-out block with information for consumers and patients, specifically links to the Commission's Understanding Labels flyer and video, explaining where to find the batch number and testing date on a Massachusetts marijuana product label, and what to do if you possess an affected product or have experienced an adverse health reaction. Below the consumer and patient information block, there are links to all public health and safety advisories the Commission has posted up to this date, which is then followed by a list of affected marijuana products. This list also includes advanced filtering options based on the data provided and a search field to easily determine if a product is included as well as options to extract the data in multiple file formats. Slide, please. The slide shows a close-up of the user interface of the marijuana products list, the data provided for each product, and the options for advanced filtering and searching of the contents of the list. This display was based on the user interface of the newly automated licensing tracker development infrastructure that was launched back in June, providing familiarity and an intuitive interface for our users to easily navigate the list and filtering systems used on our website. Slide, please. The Public Health and Safety Advisories portal, of which we have also provided a short URL of masscannabiscontrol.com/PHSA, can also be found in the following locations. Within the slider on the Commission's homepage, linked in the footer of the website, which appears on every page on our site, via a button included at the end of the notice that was published on August 6th of last week, an icon and link on the frequently viewed resources page within our public resources section, and buttons added to the top of the news page and enforcement announcements page linking to the portal. And that concludes the introduction to our new Public Health and Safety Advisories portal. At this time, we are happy to answer any questions that you may have.
Thank you, Director. Invite my colleagues if they have any questions for Director Burt. Commissioner Roy?
Thank you, Acting Chair. Thank you, Director Burt, for your presentation. Having this functionality is critically important, especially in light of recent events. So I want to thank you and the data team and everybody involved to make this a reality. And I just want to, there was some questions when it was first rolled out, and I don't know if this question would be more appropriate for the ED or you, Director Burt, but looking at the product name column, so I see it here. Was that part of the initial rollout? Because I know folks were looking for that, and I'm just glad to see that it's there so folks can easily identify if their products were part of this advisory. And secondly, I had spoken to, had a nice conversation with Executive Director yesterday about tying this to our product catalog, because sometimes if you see the actual picture, and I think it drives us to the product catalog, but not to the product, and maybe this is something aspirational where you could click on that product name and it would bring you to the picture of it in our product catalog. So I just wanted to ask about that, specifically that column. I don't know who wants to take that.
Sure, Director, if you'd like. Thank you, Acting Chair. I apologize. I believe the Director can take the product catalog question, and I will respond on the licensee information in the data. Director Burt, if you could address the product catalog.
Sure, thank you. And we did make an update to the product catalog page today with a call out block that links back to the advisory just to be able to create a user pathway from one to the other. But as far as the integration of the pictures and product details, we'll need to look into that with our vendor.
Thank you. And I believe, and Commissioner Roy, feel free to jump in if I'm not answering your question. As it relates to the information within the portal, certainly it is not forward facing with sort of licensee information specifically as it relates to, you know, the point of sale, and that is intentional. But was your question more about the product itself?
Yeah. Yes, I just want to be clear. I was not advocating for that. It was more the product. I think people were looking, in addition to a package label or a batch number, the product name. And I think when it first rolled out, there was a little bit of confusion. So I just, if you could, I wasn't sure if when it was immediately rolled out, was that column included, or was that responsive to feedback we got?
Thank you. And through the Acting Chair, I think ultimately, you know, the information that's in there right now, as was shown on the slide, there's some of the information related specifically to each product, but perhaps the CIE or DOI could answer more specifically on that type of information as it relates to the product.
And I saw Paul's screen open. Acting Chair.
CIO?
I was just available on the product catalog conversation.
Okay. Director Binkowski?
Thank you, Mr. Chairman. Yes, to my knowledge, the product name column was always in the portal. We did receive some feedback regarding the brand name, in that possibly would make it easier for users to filter that. The brand name for certain products is within the naming convention, but that is specific to licensees. But the product name was always one of the columns, along with testing date, sale date, kind of type of product to help consumers or patients identify the product.
Thank you, Director. Commissioner Roy, anything else?
Yeah, thank you, Acting Chair, and thank you all for your answers. And just as a commentary, with the product catalog, and this isn't necessarily about the portal, but I have difficulty using the product catalog. So respectfully, maybe we can have a meeting with Metric to make it more consumer and user friendly. What I tried to do last night is I cut and paste the package label, and I went over to the product catalog and it wouldn't let me paste it in. And so I tried to do my own work based on this advisory and go to look at these products and and it doesn't. It's not compatible. So I think there's a little more work to do to make it more consumer and patient friendly and user friendly, especially when we have these advisories. So I think they need to talk to each other where they're really not right now. I mean, we're driving people there with a click, but once you're there, it's very difficult, as I experienced last evening.
Thank you. To the acting chair, we're happy to take that feedback and come back to the board with any potential adjustments.
Great, thank you.
Thank you, Edie. Thank you, Commissioner Roy. Just a couple of comments to Director Burt and to the ED. You know, like that we have stood this up, and thank Director Burt for pulling this all together. I know it's not an easy task. I think it is going to be extremely helpful, not only for our licensees, but consumers to access information kind of right at their fingertips. I know this hasn't been up very long, but Director Burt, have we had any traffic to the page at this point? I mean, have anybody, short of this discussion today, to kind of highlight its, you know, its presence, you know, anybody kind of jumping right to this and seeing the functionality of it? What kind of traffic are we driving?
Yes, I actually do have analytics of the portal from the day it was launched up until yesterday afternoon. And I can drop these numbers in the chat as well, so that you don't have to take notes while I'm speaking. But we've had about a little over 6,100 views and 2,550 sessions, which is averaging about 3.32 views per user at an average session duration of just over 4 minutes. We've had 25 downloads of the Understanding Labels flyer, as well as 933 views started of the video, of which 142 actually watched the entirety all of the way through. We've had 44 signups for the Advisories email notice list, and the portal is currently our 7th most viewed page in the past month, with the notice being the 3rd. And the majority of users who view the August 6th notice continue on to the portal, whereas the reverse is also true in that the majority of users who view the portal then also view the August 6th notice.
Can you restate what that first number was? The number of folks that have, I think you described them, they've gone to the page?
Yes, that is, as of yesterday afternoon, it was 6,186 views. And we have an average, each user views the page about 3 times. So technically that was 2,550 unique user visits over the past week.
Wow. Those are some impressive figures for only being out for a week, but thank you, Director Burr. Appreciate you having those numbers.
Thank you.
Commissioner Concepcion, any questions?
I do not have any questions. Thank you so much, Director Burt. This is really great work.
Thank you, Commissioner.
Thank you, Director. All right, ED, we'll turn it back to you.
Thank you, Mr. Acting Chair. If we could go to the next slide. This is a summary of information that the Chief of Staff and CTIO will review for you.
Okay.
Good morning, Mr. Chairman, if I may.
Go ahead, Chief of Staff. Nice to see you. Good morning.
Nice to see you. So just a quick update on two-factor authentication. So in June, the medical use of marijuana online system, MMJOS, began rolling out two-factor authentication for certifying healthcare provider accounts. To enhance the security of the system, MMJOS now requires providers to confirm their email address and provide mobile phone numbers for login purposes. As part of this process, the Commission asks that certifying healthcare providers review all information in their MMJOS account and make updates as necessary, including but not limited to names, addresses, contact information, and practice area. As a reminder to our certifying healthcare providers under 935 CMR 501, providers are required to update the Commission within 5 business days of any change of their information. If there are any certifying healthcare providers who are listening and may have questions, please contact the Medical Use of Marijuana Program at commission@cccmass.com, or they can give us a call at 833-869-6820, excuse me. And that's also on our website.
Hey, thank you, Chief of Staff. CTIO, anything you want to add before I open it up for questions?
Nope, Andrew covered it very well. Thank you, Chief of Staff.
Okay, questions, Commissioner Roy, do you have questions?
No, I just want to thank CTIO and Chief of Staff for their work. I know our Chief of Staff has been highly focused on the medical program, and I've had the pleasure to work with him and Commissioner Concepcion in our working group to make improvements and modernization to those regulations. And obviously, I want to thank CTIO for all of his work and his team around cybersecurity and making sure that we have sensitive information right in this portal. And we want to make sure that we do everything we can so there's no breach and keep it secure. So I just want to thank them for their efforts.
Thank you, Commissioner. Commissioner Concepcion, any questions?
No questions.
Okay, thank you. All right, Mr. Executive Director, back to you.
Thank you very much. If we can move to the next slide, I'm going to be handing this particular item listed on the agenda over to the General Counsel. I just point out we have 2 back-to-back kind of updates of delegated authority here. If we could, unless there's any clarifying questions on this, sort of save questions for the petitions update on data from the GC and the waivers update from the EC, and then have Q&A combined at the end of that, if appropriate. Certainly, if there's any clarifying questions for the GC, please feel free to go through the acting chair. But with that, through the acting chair, I would hand this particular presentation over to the GC.
Good morning. Thank you, ED, and thank you, acting chair and commissioners. It's good to be here. As you'll recall, I was here before you at the last regular public meeting talking about the petitions for regulatory change process. And the thrust of that presentation was to talk about just the process to follow to make such a petition. There were some follow-up questions at that time regarding process and numbers, and so wanted to follow up with you all to give you that information. So that's the purpose of today's presentation. I'll do a quick recap of the process part of it, but then go into more of the what we do once we receive the petition, and then share some numbers with you. Before I get started here with the presentation, I do want to just throw a recognition and attribution to my friends and colleagues in the Enforcement Council, to Enforcement Council and Barbara Cooney, who put together a very similar looking presentation to mine here, We did borrow the format from their presentation pretty liberally, so any likenesses there, I want to give full attribution to the structure and the format to that team. But why don't I get going here? We start off here just in terms of the statutory framework with Chapter 30A. Under Chapter 30A, agencies are required to make provisions for and allow for interested persons to petition agencies to request changes to their regulations. And so we, pursuant to that, each agency shall prescribe by regulation the procedure for the submission, consideration, and disposition of such petitions. If you go to the next slide, we have done that in our regs, so 935 CMR 500-830, and then its counterpart in the medical regs, 935 CMR 501-830, are our regs for allowing individuals to petition the agency for changes to our regulations. At my last presentation, I went through the requirements here in a step-by-step fashion to highlight for folks what they need to do to make a petition. Part of that was to try to educate the public just about the process, and what we have been seeing is most, if not all, of our petitions were being sent to one or more commissioners and not through the process that we had set up. So we wanted to really make it clear for people that are interested in making petitions of the process that we have for this purpose. So I won't go through the whole process here again, but the gist of it here is that the request must be in writing. It must indicate the petitioner's specific interest in regulation. Specifically state the request for whatever they're looking for, and then give the reasons and the background behind the request and any citation to authority and any arguments they'd like to present. And then, so when we go to the next slide here. So in terms of the review process, next slide, please. We asked that petitions be sent to the email address listed here on the slide, commission@cccmass.com, with all the requirements that I just highlighted and that are contained in the regulation. And then once we do receive that petition, we have recently updated our SOPs in this area, and this presentation here outlines the revised SOPs that will provide for a standardized review process of these petitions as they come in. So essentially, the legal division will acknowledge receipt once a petition is received, and then we'll conduct a review to make sure that it conforms to the requirements of our regs. We'll then inform the petitioner if their submission does not conform to the regulatory requirements, and then we'll work with the petitioner to help them submit a petition that does comply with our requirements. And then once that is complete, we will then conduct our initial legal analysis of the petition so that we can then make a recommendation to the executive director. Next slide, please. And then following our review, so we do make a recommendation to the ED. The recommendations are either one, that no regulatory change is needed, two, that there's a determination that there's an additional need for information or investigation. Sometimes this is done through formation of a working group. Alternatively, there might be a determination that a regulatory change is warranted, and a recommendation to that effect is made to the ED to be presented to the commission, or just as a catch-all, any other action that's consistent with our regulations. So those are the recommendations that we make, one of them to the executive director following our review of the petition. And then upon receipt of the feedback and direction from the ED, the legal division then takes appropriate action to work with appropriate personnel to implement the recommendation, to respond further to the petitioner, and then ultimately, if called for, and if that is the recommendation, for the presentation of materials to the commissioners for their consideration. Next slide, please. So moving on here, the most common outcomes of petitions are either an approval, that's straightforward. Legal division reviews the request, determines that it is appropriate and meets all the various regulatory requirements, and then that would then go through the regular process for promulgation after it's presented to the commission for their decision. Alternatively, we may, after review, decide that a denial is appropriate. It usually happens if it's outside of the commission's jurisdiction, or if the petition calls for something that is plainly illegal. If the recommendation is for a denial, we often will submit that petition nonetheless, because there might be a portion of it that needs further investigation. We may submit that to a regulatory working group for future discussion and potentially future incorporation into a future regulatory package. And then alternatively, the requester may withdraw their petition, and we would close it out on our end. Next slide, please. And then finally, I just wanted to leave you with just a snapshot of the numbers. This was part of the request from the last presentation. So what I've done here is I've broken out the requests by year. So we've, since the delegation was made back in 2020, we have received 13 total petitions. As you can see from the slide here, broken down by year: 1 in 2020, 1 in 2021, 5 each in 2022 and 23, and then 1 in 24. To date in 25, we have not received any. So again, the total here is 13 for that period. So that is the end of my my slide deck here, and I'm happy to answer questions after EC Gooden gives his presentation, or whatever the board sees fit.
Thank you, JC. Colleagues, if it's okay, let's proceed with Enforcement Counsel's presentation, and then we can have questions and discussion of both the petition process and the waiver process, if that's fine.
Acting Chair?
Commissioner Roy?
Yeah, actually, I have questions specifically for petitions that I'd would like to ask before we move on to waivers, because I think they're two different animals, if I may.
We're going to come back to petition questions with the GC. I'm hoping we can, if you'll allow me to just let Enforcement Counsel do his quick presentation on waivers. I see them as kind of inextricably linked, so I think having presentations on both would work, and then we can certainly bring it back to questions. I know you have some. I certainly have some, even some that I've added from the presentation that we just heard, but
okay, thanks.
It's okay to proceed that way. Enforcement Counsel.
Great, thank you, Acting Chair, and good morning. Good morning, Commissioners. Good morning, Acting Chair. So it just wanted to start off by, yes, similar to General Counsel, acknowledging that Barbara Cooney, one of our enforcement paralegals, did a lot of work to help prepare for this presentation. And she's also going to be available to assist me with answering any of your questions as well. So just want to make sure that I'm recognizing Barbara there and all of her work with this. So next slide, please. So we have just a brief overview of the agenda here. It follows a similar sort of format to General Counsel's presentation. So I will go over the kind of regulatory basis, establishing the waiver process, our internal processes and how we actually go about reviewing waivers, as well as the potential outcomes for a waiver request. I'll briefly note petitions as well as part of that. Then I'll go into some of the specific metrics, and then we'll follow with a Q&A portion. So next slide, please. And so just kicking off into the waiver process overview. Next slide, please. So here I just want to note and draw your attention to 935 CMR 500-850 and the corresponding medical regulation 501-850. So just noting at the outset that both of these sections establish in their first subsection that the commission may delegate its authority to the executive director to waive regulatory requirements promulgated pursuant to the corresponding statutes, and the commission has done so earlier on in its existence. I do want to also just, as preparing for this, I found just a couple of interesting thoughts or quotes from former commissioners in the beginning of the commission's existence, just kind of providing some context to the waiver process and what the intent was in incorporating this specific process into commission regulations. So at the December 11th, 2017 meeting, Commissioner Doyle, when describing the waiver process, she noted that one thing the commission should have in mind is that there is a waiver process being built into the regulations. So if someone finds that a particular requirement of the regulations is problematic for them to be able to actually effectualize their business, the waiver process is here to attempt to accommodate for some of those particular circumstances. And she was noting as well that particularly in that instance where the commission was given such a short amount of time to stand up the regulations, that they were not privy to all of the information that was going to come in over the following months and years. So in essence, noting that where the commission is promulgating new regulations in a new industry, that there needed to be some flexibility to account for how those regulations would impact particular small businesses and farmers, she noted in particular. Similarly, a few years later, the former chairman, Chair Hoffman, noted at the commission's September 17th, 2021 meeting that when he was discussing amendments or the regulatory change process, he noted that it is sometimes time-consuming amending regulations, and waivers are intended to be done in a one-off manner to address unique hardships by allowing licensees to suggest an alternative that still satisfies the spirit of the regulations rather than addressing changes of general applicability. So I think that's important to note here as well, just because waivers really are not an opportunity, unlike the petition process, to actually try to effectuate changes in the regulations. It is a process by which individual licensees can seek to get a special accommodation, in essence, or waive a certain regulation, and allows for the substitution of an alternative requirement in that place that still satisfies the overall spirit of the regulations. I will note here as well that alternative security provisions, or ASPs, which are waivers of specific security requirements that are promulgated under 500-110 and 501-110. Those follow a separate process. I know we've discussed it in the past at public meeting, but those are reviewed and assessed by our investigations team, and they do follow a distinct process than waivers. Next slide, please. So here is just an excerpt of our regulatory language. This is important because it identifies the four prongs by which all waiver requests are analyzed. So the first prong is that compliance would cause an undue hardship to the requester. And I'll note here, as I was stating in the last slide, that the intent here is really that the undue hardship is unique or particular to the individual requester, and not that it is an undue hardship or general feedback regarding generally applicable regulations. The second prong is that, if applicable, that there is the implementation of compensating features acceptable to the commission. So that goes to the substitution of new requirements or conditions that would still uphold the overall spirit of the regulatory language that they are seeking to waive. C, or the third prong, is that non-compliance with the regulatory requirement would not jeopardize the health, safety, or welfare of any registered qualifying patient or the public. And D, the granting of a waiver would not constitute the waiver of any statutory requirement. So as a regulatory agency, we do not have the authority to overrule or waive statutory requirements promulgated by the enacted by the legislature and the governor. So that is an important prong for us to keep in mind as well. Next slide, please. So just an overview of what we do when we receive a waiver request. So the waivers are received through our enforcement general mailbox. They were formerly received by the licensing team, but we recently made a change to the form directing requesters to submit those forms through the enforcement mailbox. Each request is assigned to a member of the Enforcement Council team who will perform a review in accordance with those 4 prongs that I identified on the previous slide. That recommendation is then provided to the Chief of Investigations and Enforcement, who will review and advances that over to the Executive Director, who will review that recommendation and make a determination. The EC staff will then provide that determination to the requester. And I will note here that an adverse decision, as identified in our regulations, does not provide or entitle an applicant or licensee to a hearing or judicial review of that decision. Again, because this is really intended to be somewhat of a special accommodation for licensees where the regulations are affecting them in a unique or particular way, this does not afford a hearing right, unlike some other actions that the commission may take. So just a note at the end here too, that our average processing time for waiver requests between 2020 and 2024 is 62 days. I will note that that is an average, so some requests take a bit longer, some requests are dealt with much quicker, but it really depends on kind of the complexity of the actual request that is received, the particular circumstances that are at issue there as well. And oftentimes too, we will see requests that have multiple regulations that they are seeking to waive, which then adds to that complexity as well. So I just want to note that this is not a process by which somebody takes a quick look at a waiver request and is able to approve or disapprove it in a matter of days. In some instances that is the case, but oftentimes it takes us roughly 2 to 3 months to actually process this, coordinate with appropriate staff as needed. Oftentimes we have to discuss these requests with investigation staff to ensure that appropriate public health, safety, and welfare considerations are taken into account before we actually offer a recommendation. Next slide, please. Thank you. So these are the common outcomes of waiver requests. So just starting off, waivers may be approved, and the language that is contained underneath is very similar to language that is contained on the actual notices that are provided to requesters, although it is slightly different here for legibility, readability for these purposes. So if a waiver is approved, the regulatory requirement is waived. The waiver only applies to that specific requester, and it may be subject to certain conditions if applicable. And I will say oftentimes when we are approving these, in certain instances, we will add conditions to tailor what that actual waiver looks like. So requesters are instructed to keep a copy of the approval notice for their records. We will also keep a record of the approval notice and circulate that or share that with appropriate teams within the agency as well, so that everybody is on the same page with the new requirements for the requester there. For denials, that is when the commission reviews the request, determines that a denial is warranted because one or more of the 4 prongs were not met. In instances of denial, the regulatory requirement remains in full effect, and the requester is expected to follow the regulations as written. We do note with denials that to the extent that requester is seeking a general change in policy, so in instances where a requester is making an argument that all similarly situated licensees would have the same issue, and we'll get to some specifics later on in the presentation. We will often deny those because those are more appropriate for the general regulatory process through Chapter 30A, because those would be approvals or regulatory changes of general applicability. So we will oftentimes include this language as an advisement to requesters, and then internally we will also share that request with general counsel and his office, as well as the executive director, just for awareness that there are requests for changes to regulations so that they can note that for their purposes. The third potential outcome is a withdrawal. I will say that the majority of withdrawals that we have received were earlier on in the Commission's tenure, right around the time of the COVID-19 pandemic, and a lot of those specific requests were addressed via administrative orders. So I will say withdrawals are fewer and farther between nowadays. And then the final option really is administrative closure. So we will utilize administrative closures when we review the request and we determine that the requested waiver is not properly considered under this process. So, for example, that would be if somebody is seeking a waiver and their understanding of the regulation is not in line with what the Commission's understanding is. So, for example, or more simply put, when the actual request is not prohibited or the requested relief is not prohibited by the regulations. So we had, for example, a recent closure related to the wasting protocols and the use of machine or mechanical grinding methods. Our regulations require that the marijuana be ground up, but it does not specify the means by which they need to do that. So there are several different options that requester could have utilized, and we were able to respond to them with the administrative closure and provide additional guidance so that they could still operate compliantly with our regulations. Next slide, please. So with that, I will get into some of our kind of high-level metrics here about waivers from 2020 until the present, and give you just a little bit of insight in terms of the commonly received waiver requests. Next slide, please. So here we'll see just kind of an overall chart identifying waivers that were denied, approved, administratively closed, and withdrawn. So just to add some numbers to or context to this slide as well. So during this time period from 2020 to 2024, we received a total of 418 total waivers. So you'll see that in line with kind of the words or sentiments of the prior commissioners that I noted, most of these are denied, withdrawn, or administratively closed. We've only approved 23% of the total waiver requests that we received over this period of time. And just to add some numbers to each one of these categories here too, of the 418, there were 216 denials, 98 approvals, 27 administrative closures, and 77 withdrawals. Next slide, please. Here are the results by calendar year, and these slides are also available to all of you and available to the public as well, obviously. So I would definitely invite you to kind of take a look at this more closely. But this also shows one thing I want to point out as well is that, again, similar to what the commissioners identified in the early days, these waivers, we saw more of them in the early days of the commission, and the total number of waivers has really dropped down over the years. I'm kind of speculating here, but I think based on kind of the longevity of the industry and when folks are actually operating within the industry, there may be waivers that are required when they are starting their business or when there are regulatory changes. But in general, we have found that there are fewer waivers, most likely because folks that are operating within the industry are able to comply with the existing regulations and do not need to seek those special accommodations. You can also see the average processing time. I will note as well in the 2020 processing time, that was 53 days. A lot of those requests were withdrawn, so that may have lowered the actual processing time as well. Because I know during that time, there was really 1 or 2 people that were reviewing waivers. So I'll give credit to our Chief of Staff, Andrew Carter, who used to be an associate enforcement counsel and processed a lot of those requests. But you can see that our processing time has gone up and then gone back down again. We're always trying to find improvements where we can be more responsive to these requests. Next slide, please. So we just want to use this slide as well to give you a brief update of the numbers that we have this year. And I'll note it is 14 days after we pulled these specific numbers. So some of the in-process requests may have moved along. But so far this year, we've received 27 requests. Of those 27, 8 have been denied, 2 have been approved, 6 have been administratively closed, and we have 11 in process as of 7:30. Next slide, please. And so here I just want to provide a brief overview of some common adult use waivers and alternative security provisions, and then we'll get into the medical ones on the next slide. I just want to note that I'm including waivers and alternative security provisions here because in the earlier days, they have both of those were handled by the Enforcement Council team. The alternative security provisions were transferred over to investigations team a couple of years ago because they have a closer handle or work more closely with licensees, particularly regarding their security requirements. So for our numbers, some of them are mixed together for the earlier years, but I just want to provide this context nonetheless. So you'll see here that generally we receive a lot related to application requirements, specifically community outreach meetings and authorizations for fingerprints. We also receive a lot for general operational requirements for marijuana establishments, particularly agents in a vehicle and transportation between marijuana establishments. We also receive a decent amount of waiver requests related to fees, as well as those security requirements. So those would be handled under the alternative security provision process. I will note as well on these slides that some of the main or primary topics that we've seen requests for were subsequently addressed by regulatory updates. So regarding community outreach meetings and authorization to obtain a full set of fingerprints, I believe most of those were around COVID as well. So we have been able to deal with some of the more common waiver requests, either through regulatory changes or other administrative actions taken by the board. And next slide, please. And this is my last slide for the presentation, so we can get into questions after this. But similarly to the adult use common waiver requests, here for common medical use waiver requests, we did have quite a lot of requests related to registration of certifying nurse practitioners, as well as written certifications of debilitating medical conditions related to clinical visits and telehealth. Again, both of those areas have been subsequently addressed by the commission, either through a regulatory amendment where we allowed attestations by the actual certifying nurse practitioner who does not need a supervising physician in accordance with the Board of Registration and Nursing regulations. So we were able to update that, and we have seen a significant drop off in those requests, as well as requests relative to telehealth. And then just finally noting that general operational requirements for medical marijuana treatment centers, we've received some related to responsible vendor training. And just a quick update on a previous slide, and thank you to Barbara for providing this information. Of the 11 that were in process as of July 30th, 4 of those have moved on and are either being considered or have been finalized, and those determinations have been sent to requesters. So with that, I will conclude and open it up for questions.
Thank you, Enforcement Council, and thank you, GC, for the 2 presentations. Commissioner Roy, go ahead.
Thank you, Acting Chair, and thank you, EC Gooden, and General Counsel. Thank you so much. My questions primarily around the petition process. Let me just start with, on our website, we have a forms and templates page. I see the third one down is a general waiver request form. So I'm wondering if why there isn't one for petition, and if so, maybe we would contemplate adding that a form and template around petitions, because if you go to the regulations, the requirements for the petition, the information required is laid out in 500-830, 1A through E. So I'll stop with this first question. I have a few more, but wondering if that's something, this way there's uniformity. I see sometimes we have to go back to the petitioner because it's not filled out in accordance with what we need. So I'm wondering if we would consider adding that to the forms and templates page. Whoever wants to take it.
Yeah, let's answer, excuse me, let's answer the question. GC or ED, I don't know which one of you would like to address that.
If I may, Acting Chair.
Go ahead, General Counsel.
In response to the question, we're happy to take a look at the feasibility of adding a form, so that's certainly something that we can look at and circle back on.
Great, thank you.
Go ahead, keep going, Commissioner Roy. I know you have
Yes.
other questions.
I do, and I just want to, based on our last discussion around petitions, I did receive feedback from constituents that in light of the delegation from the previous commissioners to the executive director, and I've been consistent on this for many years, I would like to claw back that, the board should claw back that delegation, since what is a petitioner asking for? They're asking for an adoption, an amendment, or repeal of any regulation. And so it's been explained to me by constituents that it doesn't percolate up to the board. In my 4 years, I haven't seen one come across our desk. And they feel they've lost faith in the process, and they feel it's a bridge to nowhere. And so I know we're going to revisit this in September, but I just want to say for the record today, I firmly believe that the commissioners need to claw back this delegation, because how do we know if the staff and the executive director, with all due respect, may say, no, we don't think this is right for a regulatory change, but the board may feel otherwise, and we're not given that opportunity. So I just want to say for the record, I look forward to next steps in this conversation in September. I believe, Acting Chair, I think you're going to bring it up for a vote, but I'm hearing from constituents they've just lost faith in the process.
Thank you, Commissioner. Appreciate your comments. Commissioner Concepcion, do you have any questions?
I do. I first thank you both for the presentation. I've made a few notes to myself just because it was a lot of information, and I wanted to make sure that I was able to just kind of keep track of everything. And Commissioner Roy, you bring up such a good point. I made note of the fact that when we're going through the petitions, there were 13 total, 12 of which was during my tenure here on the CCC. And I do not recall ever having a petition brought before the board and us having a conversation. And I know in our last conversation, there was mention around delivery. And it's interesting because I have taken a considerable amount of time here as a commissioner at the Cannabis Control Commission, working around the delivery license types, making sure that I was aware of any sort of information prior to arriving. My predecessor, Britta McBride, who was in the public safety seat, was actually one of the people who really had their hands on that delivery license and the 2 license types. So I took it upon myself to make sure that I was informed, I understood, and I also was meeting with, at that point, prospective licensees and now current licensees. And I did not get information around that petition. I think that I was informed through the licensees themselves, and I've heard similar feelings that you have heard as well, Commissioner Roy, in terms of frustration around how that process is done, and the information not making it to the board level. So I was interested to hear about that 12 number, and just knowing that, maybe it was said to us during conversations internally in passing, but we have not looked through these petitions. I wanted to, Attorney Gooden, thank you. It's funny, I would write down questions and you would answer my question before I had the opportunity to ask it. So, I was thinking about that number, the processing days. You cover this, because I said, okay, in 2020, there was 168 requests and there was a 53-day processing time, and that was a shorter amount of time, but you got ahead of me on that. So I thank you for that. I guess I also wanted to ask you, we went through the common waivers, that list, and you referenced it yourself that, it fluctuates because we have regulatory changes, we have other things that happen. So I just wanted to know, is this list current? Is it, I would assume that there are some changes because of the changes that we've had on the regulatory side of things.
Yes, Acting Chair, if I may.
Go ahead, Enforcement Counsel, of course.
Thank you. And thank you, Commissioner. First off, I'm glad that I got ahead of some of your questions. That's always the goal. So happy that we were able to accomplish that. So with regard to the common waiver request, so since this is the first time that I'm appearing before the board and providing this overview, we wanted to focus our review on kind of the overall universe of waiver requests that we've received. So this is pulling from that 400 some odd waivers in total. Again, I'm going to thank Barbara here because she is listening and helping along here as well. So the most common waiver requests that we still receive are fees or waivers related to fees. And I will note too that some fees are explicitly removed from that waiver process, or we note in our regulations that some fees cannot be waived, but there are certain reductions or eliminations of the total fee for certain categories of licensees or applicants as well. So I do want to note that. But yes, to answer your question more specifically, these are kind of historical common waiver requests that the board has addressed some of them through regulatory or other administrative action. But as we are moving forward and providing subsequent updates, I do intend to keep track of this and update what the main areas of waiver requests are for the board too, so that you have that information moving forward.
Thank you. And I have one more follow-up, Acting Chair, if I may.
Of course.
I wanted to make sure I understand when we're saying administratively closed, can you flesh that out a bit?
Yeah, of course. So the administrative closure process is where, again, we will identify, if through our review, we've identified that the requested relief is not prohibited by the regulations, then we will, in essence, provide a recommendation to the Chief of Investigations and Enforcement, and then through her to the Executive Director, that a waiver is not necessary here, and we can really accomplish or address the request by providing more information to the requester. So we'll still go through, provide a notice, etc. I will say in the earlier days, we would simply send an email to the requester saying, please be advised that this has been administratively closed. So we're not specifically approving or denying your request. We are just closing this out internally, and we're providing you more information to allow you to do what you are requesting to do. So in essence, the actions that they are proposing are not prohibited by our regulations, and we'll give them a little bit more information. I will say to me personally, and I know others on the team have sometimes, but not oftentimes, had follow-up meetings with requesters to explain the process, because I will say that our the regulatory process, or what's outlined in the regulations rather, is not always clear. So for example, we identified that a waiver request may be submitted, and the first prong is that an undue hardship will be caused to requester. Again, it doesn't specify that the undue hardship has to be unique or particular to the request, but in practice and the intent of that regulation is to really account for those edge cases. So oftentimes, if we've had follow-up conversations or communications with requesters, we will go into explaining those aspects. But I hope that answers your question related to administrative closures too. It's just kind of a different way that we deal with it. So we're not giving a firm approve or deny, but saying, there appears to be maybe a misunderstanding or something along those lines, and then we'll close it out. Also, too, just want to note as well that sometimes we've had requests for a fee waiver, and then the requester has subsequently paid the fee. So we would administratively close it in essence as moot at that point. Or if there is we've received requests for like the extension of a license and waiving prorated fees, et cetera, and then the license is renewed before the waiver is actually processed. Sometimes that is because the actual request comes in so close to the actual meeting, like a matter of a couple of days in some instances, and we're just not able to process it in that time. So the actual underlying issue becomes moot, and we administratively close it as under those bases as well.
Okay. That it's helpful, but it just sounds, because at one point, if we're saying that they're resolved, so we administratively close them, that's one thing. So in essence, I'm thinking through this as you're speaking, and I said, well, that's, essentially an approval, because we're saying that a waiver is no longer needed. But now so it's not just that, we're also saying that sometimes the applicant, whoever is seeking the waiver, has decided to continue paying the fee in spite of submitting the waiver.
Yeah, so in essence, the factual bases for the waiver request may have changed. Also, if there's a regulatory requirement that is updated by the board that changes the actual substance of the waiver request. In other instances too, there's just other means for the licensee to achieve compliance with the regulation that they're seeking to waive. Like that, or they've misinterpreted the regulation, similar to that waste requirement request that we received that I noted. So again, in that instance, they read the regulations to require some means of mechanical grinding of marijuana waste. And we've often seen licensees utilize different options for that. So I'm aware of licensees using, like, tearing up marijuana fan leaves by hand and mixing that with inert material using scissors. I've even heard of licensees piling up marijuana waste and using a lawnmower to run over it. So they're not using a mechanical grinder in the sense of like a commercial grinder that our product manufacturers would use, but they're using other commercially available equipment. So that, in essence, becomes a compliance determination as opposed to a waiver. I'll note too that we're at times cautious of approving certain waivers because that exempts that licensee from that underlying regulatory requirement. And we will add conditions as necessary to make sure that the actual request is tailored to what actions the licensee is seeking to do or take, so that we're not overbroad in waiving a generally applicable regulation. Oftentimes those may have larger consequences, and we want to make sure that these are tailored to address the specific circumstances that are being requested.
I can try one more question.
Of course, go ahead.
Because I want to make sure I understand this completely. So I want to go back to the 2020 numbers. And we said that there were 168 requests. The review processing day was 53 days. And you mentioned that it was due to a significant amount being administratively closed. Is that review an easier review or a quicker review? And that led to a lower ratio? It's a lower or higher ratio, but just a quicker turnaround time in terms of the review process.
Yeah, absolutely, Commissioner. So just one point of clarification there. So there was 36% of that 168 or 61 of the requests were received in 2020 were actually withdrawn. There were only 3 that were administratively closed. So in instances where those are withdrawn, that is because the requester themselves actually said, we do not need this, or we are not seeking this anymore. And Mega indicated too, I think the majority of those withdrawn requests were related to areas like conducting an in-person community outreach meeting or things of that nature that were addressed by the board through administrative orders that flowed from the governor's emergency declaration regarding the COVID-19 pandemic.
That makes sense. Thank you.
Okay, thank you. Back to you, Commissioner Roy. Go ahead.
Thank you, and great questions, Commissioner Concepcion. EC Gooden, I just have a question on the process. Who in the commission, who in I&E makes the recommendation, yay or nay? Who on our team does that due diligence review of the waiver? Oh, I think you're on mute.
Hear me now?
I hear you now. Yep.
Yes, okay. I've had some audio issues recently, so if I'm speaking at any point today, please let me know if my audio cuts out. But yes, Commissioner Roy, so happy to go through that. So in essence, each request is received through our enforcement mailbox now. Those particular requests are assigned to an associate enforcement counsel or our first assistant enforcement counsel for an initial review. One of those attorneys then performs the underlying review. They're also supported, I will say too, by both of our enforcement paralegals. We will perform that due diligence review. We will also go back, identify if there are any historic waivers we have considered to see if the facts are substantially similar, so we're not acting arbitrarily or capriciously there. We will also perform a legal analysis related to the undue hardship requirement and the additional prongs, speak with any other interested stakeholders within the commission to make sure that we're considering all facets of the actual request. And like I mentioned earlier, we want to try to consider any unintended consequences of granting a waiver and also ensuring that we are not regulating through the waiver process. So we are tailoring it to the specific individuals that are requesting those waivers. After the Associate Enforcement Counsel performs their initial review, that is then reviewed by either myself or our first Assistant Enforcement Counsel, Jacob Nielsen. Obviously, he won't review it if he performed the initial review, so that we have that quality control metric there, but either one of us will review that actual request. That will then be advanced to the Chief of Investigations and Enforcement. And if there are any particular changes or revisions that the chief is identifying, we will be in communication with the chief to incorporate any of those changes too. She has an overall view of the implementation, investigation, enforcement, licensing processes. So she's able to kind of identify any blind spots there through her review. That is then advanced to the executive director, who will act on that recommendation. And the executive director has the options to approve the recommendation as written, in which case we will communicate that that determination to the licensee. He can also reject our recommendation, and we can go back and reconsider what our recommendation is, incorporating any feedback. He also has the options for asking for additional information or follow up as part of that process as well. So to summarize there, it is received by the Enforcement Counsel team. One of the Associate Enforcement Counsels will review it with support from our enforcement paralegals. Their recommendation will be reviewed by myself or our first Assistant Enforcement Counsel. That recommendation is advanced to the CIE and then ultimately decided by the Executive Director.
Go ahead, Commissioner.
Thank you, EC Gooden. That was very helpful because I personally didn't know that's the trajectory of these waivers and how they are triaged. So I really appreciate that explanation. On one of your slides and your slides were great. Thank you so much. On the waiver outcomes, I just would like to recommend an edit, because these slides are public materials. They're memorialized. And I just want, so the public isn't confused, it says under approval and denial, the slide that says waiver outcomes, approval says the commission reviewed the request. Now that might be misleading to some, thinking the board, us. So if we could put commission enforcement team or investigations and enforcement, I think we need to qualify, and even under denial, because folks may think that it went right to the board and we are doing this. And I just don't want folks to get confused on that. So since these are public materials, I just respectfully recommending a change that explains it a little clearer to folks on that slide.
Acting Chair, if I may.
Of course, go ahead.
Thank you. And thank you, Commissioner Roy. I think that's a good suggestion. We can add some clarifying language in there. I think as written here and how I was considering that is the commission through its executive director in accordance with that delegation of authority. So as I mentioned earlier on in the presentation as well, under 500-850 and 501-850, the board may delegate this responsibility or this action to the executive director, which it did previously. So we can add that in there. And also, I think one thing that I know has been considered or discussed is references to the agency, as in the executive director and the staff, versus the commission as the board. So yeah, I think that could be helpful to add in. The commission acting through its executive director will approve or something along those lines. But happy to work with Director Giancola to make sure that those edits are reflected there. And thank you for the clarification.
And thank you. I appreciate that.
Mm-hmm.
Acting Chair, I just have one last.
Of course, go ahead, Commissioner.
Yep. Thank you. And my final questions are for our general counsel regarding petitions. And I know this is going to come back at our September 11th meeting. And I'm requesting, EC Gooden had some metrics, if you will, that were very helpful. So general counsel, I'm wondering if we could have in September, prior to our vote, the following information. Number one, how many petitions were denied? How many were approved and how many withdrawn? Of that, number two, how many were SEP, EEA, or DBEs? And I see there were 13 in total through 2024. I'm wondering if I don't think we've received any in 2025, but just double checking on that. And the subject matter of the petition. So how many were approved, how many were denied, how many withdrawn, how many were SEP, EEA, DBE, the subject of the petition, and if we've received any in this calendar year. Thank you in advance so much. Thank you.
Thank you, Commissioner. I think if I heard the presentation from the GC right, there have been no petitions yet in 2025.
If I may, I can share that is correct. Yes.
Okay. Thank you, Commissioner. I just have some questions, and these will kind of go back and forth again between the petition process and the waiver process. Help me understand just functionally, operationally, why somebody would withdraw their petition. Is that a result of a conversation between our team and the petitioner, or the individual seeking the waiver? Somebody goes through the effort of filing a petition or filing the waiver, and then subsequently they're taking the step of withdrawing it. I'm just interested in how that, and sorry to get a little granular here, but how that step actually functions. GC,
sure,
I'll invite you, and then I'll ask you to see the same thing.
Sure, thank you, Acting Chair. I think for this, it's important to point out the difference between petitions and waiver requests. Petition requests they're not they're not something that are subject to or kind of invite immediate responses. They are something that are subject to the regulatory process. Obviously, we only have a certain number of regulatory rounds in a given year, so they drag on for a longer period of time, and I can't really speculate as to what goes on in that period of time from the requester's perspective. But for them, circumstances may change by the time actions are taken. So it's hard to tell what may drive a withdrawal. But I will note that contrary to the waiver process, which is, I think, it lends itself to quicker turnaround. The petition process, by its very nature, it is a more drawn out process.
BC, do you want to talk about withdrawals from the waiver perspective?
Absolutely, Acting Chair. So regarding withdrawals for waivers, I mean, similar to the General Counsel, I can't speculate to all instances of withdrawal. Like I noted, we have seen a lot in instances where the Commission has subsequently acted to address the underlying issue. I will say that over the course of the Commission's review of waiver requests, we have seen withdrawals dip down as well. So excuse me, I'll just pull up my notes from that as well to give you a little bit of context there. So back in 2020, we had 61 withdrawals out of the 168 requests that we received. In 2021, which I mean, we'll all recall was still during the COVID pandemic, we had 20, which out of a total of 76 requests, which represents 27%. But after that, in 2022, 2023, and 2024, we had 7, 3, and 2 withdrawals, respectively. So we have seen that overall number drops off, but I can't necessarily speculate to in every instance why those were withdrawn.
Okay, thank you both.
Mm-hmm.
Appreciate the thoughts on this. And I thank my colleagues for the points they brought up. I think what's for me, obviously, it's prescribed, GC, as you made in your presentation, that we make a petition process available. And Enforcement Council, I think you brought it up. You brought up Chair Hoffman's comments back in 2021 in terms of the petition process, the regulatory process, and the waiver process. And obviously, from the numbers you've shared and how quickly you've been able to process a waiver, you would look at that timeline and say, wow, that's incredibly much faster than going through the regulatory process. And I think what we witnessed, and commissioners were aware of before we made changes to the 2-agent in the car for delivery requirement, is that people were filing a waiver seeking that, and the justification that they kept coming back to was it is an undue hardship. Now, I'll tap into your thoughts or your perspective on this, but obviously an undue hardship is something that's more unique. Somebody who's feeling a hardship based on compliance that every other licensee has to, have with our regulations isn't necessarily undue or unique. But, again, because we saw a flurry of, I think, a heavy number of those that came through around the 2-agent rule. Is there some language? Is there some guidance that we can give or should be giving to licensees when they file a waiver, just to say, to kind of pull that out a little bit further and say, an undue hardship, yes, it's a financial obligation of complying with our regs, but it's not unique to you. Do you have any thoughts about how we can kind of parse that out for future waiver applicants to maybe offer them a little bit more clarity about that?
Acting Chair, I apologize. Was that question directed at me or General Counsel here?
I'm sorry, it was directed at you because it was more around the waiver process, and what we saw was a number of waivers around, the 2-driver requirement, as opposed to, again, what we've talked about is the petition process can be a little longer exercise, but just thoughts on that in terms of how we might be able to offer some folks more clarity before they go through the work and the process of applying for a waiver.
Absolutely, Acting Chair. So I will note that you're correct that, like I said, it's really more geared towards addressing unique or particular challenges faced by individual licensees. So for example, like we have, just to provide a little bit more context for the board, also for the public here, like we've had instances where folks are seeking a waiver because their facility burned down. That is obviously unique and particular to that individual licensee and doesn't offer kind of a general request for relief that any similarly situated licensee would be able to also avail themselves of. So that does go back to that consciousness that we do not want to regulate through the waiver process. I will note that we have recently updated the general waiver request form. So now the specific, and I posted this language, sorry, it only captured part of that. But I will note that the general waiver request form, I'll just post a link so that it's easier and you can review in its entirety. But this form was just updated in May of this year. And when soliciting information regarding why the requester is facing an undue hardship, we've now specified that the commission evaluates claims of undue hardship on a case-by-case basis, considering in the facts and circumstances presented for each requester. So we're trying to clarify that language or that expectation a little bit through the form here. I'm hopeful that this presentation is providing some helpful information to folks that may be seeking waivers. And there may be other options that we can work internally to propose to try to clarify this process a bit as well. But I definitely welcome input from other folks within the agency, as well as folks within investigations and enforcement team to try to come up with some additional solutions as well. But as I noted, we have made some relatively recent changes to the form to try to address some of that confusion, because we had seen quite a lot of requests come in with those general requests for relief that ought to be more properly addressed by the petition process. And like I noted, when we are denying those, we will filter those through internally so that at least the general counsel's office and the executive director are aware of the overall themes of those requests.
Okay. Thank you, C. I appreciate that. This is good discussion to have. I want to thank you both for the presentations. I got to give a shout out probably to the author of the presentations, Barbara. So Barbara, if you're listening, both of these gentlemen did not try to steal privileges and accolades for your authorship. And I do want to bring those back, as it's been mentioned, to our September meeting, but I thought it was important for us to have this conversation first to kind of look through the data and the metrics to have a better understanding of both processes. And I thank you, GC and EC and Barbara, for helping us do that. It's interesting to me, the petition process, obviously codified in statute, needs to be adopted by, every agency that has a regulatory process. But certainly, for Commissioner Roy, from your comments, it's disconcerting when you hear people might be frustrated with that process. Obviously, I think there's a general understanding that the regulatory process, because of all the requirements, can sometimes take a little bit longer than the waiver process. And I hope we can continue to kind of educate and help folks understand the distinctions between the two. I do want to, though, suggest, the petition process is available to licensees and eligible folks to apply for the petition. But at the same time, I think we need to, as commissioners, recognize the fact that because we have made ourselves, I think, so visible to the public, so visible to stakeholder groups that we work with, that we do hear, again, outside of a formal petition process, we do hear informally where folks encourage us to make regulatory change. So, it's, I think Commissioner Roy, going back to the changes we, heard were, necessary around micro business, that came from, a lot of our just working with outside groups, industry stakeholders, local officials. So we kind of hear all of these potential changes, kind of coming through us through multiple sources. So that's helpful to have. So my hope here, hang on just a second, Commissioner, I see you have your hand up. My hope here was to walk through the information, walk through the process, walk through, some of the metrics that we've discussed today, give us some time as commissioners to have some follow-up with staff, or to digest what was in the presentation and have further discussions about the process and the procedures and the delegation at our September 11th meeting. But thank you both, and again, thanks to Barbara for good work. Commissioner Roy, and then I want to give the ED a chance to kind of help wrap this up as part of this being under his report. Commissioner Roy, go ahead.
Thank you, Acting Chair, and I do appreciate your comments, and I do agree with you to a certain degree. Yes, we absolutely do hear directly from licensees, from stakeholders, constituents, but sometimes it's a matter of timeliness. And you use the micro business example where we did hear from micro businesses. We toured them. We heard the challenges of not being able to have an additional license type unless you, destruction of plants, put yourself out of business to get another license. So we did hear that, but the timeliness of it was, I personally know of a micro business 2 miles from my house that couldn't wait for us to open the regs for chapter 180 to make these changes, and subsequently they went out of business. So that's what I mean about the importance of the petition process. It could be a timeliness issue where they cannot wait for us to go through our regulatory changes, rounds, promulgation, and their business ultimately goes under. So yes, we do hear from them, but it also exemplifies the importance of the petition process and the importance of it getting up to the board for consideration and review. Thank you.
Thank you, Commissioner. Fair points. Appreciate that. ED, go ahead.
Thank you, Mr. Acting Chair. I just want to summarize a few things and then the action items as we move forward here. So I just want to highlight as well, I think all commissioners did this to a certain extent, but obviously the report and the data within the waiver information is important. And so what we'll be doing is scheduling the periodic updates of the waiver data, waiver request data at future meetings periodically, most likely quarterly. Potentially, we'll find a cadence that works. This is data that is obviously relevant to you all. Should we find trends in that data that may be parsed out and needed for you all as policymakers? And we'll be prepared as staff for discussion at a future agenda when the AC places that on to discuss the delegation of petitions. We'll obviously act accordingly. I just want to point out a few things that I noted within the discussion. Obviously, Commissioner Concepcion's point that these were not brought to board meetings previously. I think we also referenced the fact that there have been none in 2025. So we are talking about a past practice. Happy to discuss ways, should the board want to change that process or want to keep it the same, to optimize either way. And so look forward to having that discussion. And finally, just for the public benefit here, because we actually have another conversation that somewhat overlaps with this later on in the agenda, which is of ways for folks to get to commissioners on suggestions of updating regulations. We also are coming up on a discussion later on today regarding a formal comment period as regulations are open. So just want to highlight as well, there are many ways that we have this type of interaction and potential consideration. And so I think obviously optimizing that in this discussion will be something I look forward to doing with the board at a future meeting. And then I just want to highlight what I have here for some data requests that we'll come back with as well, specifically on the petition items. Within the 13 requests between 2020 and 2024, the request was how many were approved, denied, removed in that 13, what was the subject of the 13 requests, and if they were from licensees, the nature of the licensee, such as SCP or DB status. And so that is what we will try to have as well for that discussion. And if I missed anything, please feel free to shoot me a message and I'll make sure it gets on the list.
Thank you, Ed. Just real quick, I think there was SCP, economic empowerment, and DB, that kind of breakdown that Commissioner Roy was looking for. And again, appreciate your thoughts in terms of perhaps a regular cadence of, oversight of in topic matter related to waiver requests that have come in. So appreciate that suggestion as well. Commissioner Roy, did you have something else?
No, I'm good. I just want to thank everyone. This was a very healthy discussion to have, and I want to thank everybody that got the information put together to present to us, and I look forward to picking up the petition discussion in September. So thank you all.
Thank you. Thank you, Enforcement Council. Thank you, GC. Certainly another shout out to Barbara. Thank you for making these two presentations look great. I'll turn it back to the ED for the next item under his commission and staff report.
Thank you very much, Mr. Acting Chair. If we could advance a slide, I am seeing a slide for medical use waivers. Perfect. And I would also like to have the DOI Binkowski is going to go through some quick data on this, and then we can answer some questions on the host community municipal equity.
All right, so just to give everyone an update about this. What we're looking at here is we're going to get an update here on this new section of the regulations that has to do, or a new section of state law that requires local cities and towns to take into consideration the local ownership and equity status of businesses seeking to operate cannabis companies in the Commonwealth. You have to get a local level permit before you can go through the state level process, a local level host community agreement it's called. And basically under 94G3A1I, which was a section of the law that got heavily interpolated via two cases. Well, one case that I think is very interesting, which was Cambridge v. Revolutionary Clinics 2. And then also it came up a little bit in Bass versus the City of Taunton, which was before Justice Englander and Justice Dickoff, respectively, of the appellate court. But anyway, so the point of that is that this section of the law is permits, or actually mandates now, due to updates of from Chapter 180 of the Acts of 2022, mandates local cities and towns to take into consideration small businesses. It's kind of like a small business impact requirement when issuing local cannabis permits, and it's meant to ward off consolidation of the industry by large market forces. How do I know? I help write the fucking law. Anyway, so they're going to talk about it. And why do I monitor this stuff so closely? Because I help write the fucking law, and you're going to implement the law that I help fucking write. You better be right about my words, and so that's why I monitor it. All right, let's go.
Process.
Good morning, everyone. Thank you for having me.
Good morning,
if we could go to the next slide, please. So this is the first update. As Executive Director Ahern noted, this will be an update moving forward as we continue through this process. We do have updated numbers as of this morning, so just to walk through these. Host community municipal equity is that all our host communities are required to adopt certain bylaws, ordinances, or local laws to promote and encourage equity within their host communities. Beginning July 2nd, we identified the submissions that were made within the Mass CIP, which is our portal. At that time, up until July 2nd, only 12 host communities had submitted their submission packet regarding their equity policies and practices to the Commission. So starting July 2nd, my team issued 172 item is the 172 notices to host communities, notifying them that they had an outstanding requirement to submit their policies, laws, bylaws, or ordinances to the commission. So 172 notices were issued to those host communities that had not submitted anything to us. Those were all sent out throughout the month of July. So all host communities that did not submit anything to us have received notice of that outstanding requirement. As of today, 3 have been accepted. So 3 submissions from Cambridge, Lee, and Shrewsbury have been accepted as being acceptable, demonstrating that they meet minimal municipal equity requirements. So congratulations to them. Currently, we have 26 that have been received by the commission. So we have 2 more since these slides were updated. Out of those 26, 9 have been reviewed and are ready to be followed up with the municipality. That follow-up will either be notifying them that it is acceptable or giving them a determination notice that we've identified either non-compliance or require additional information to assess their compliance. And then the remaining, I think that's 17, still need to be reviewed. So at this time, since we've begun sending this out, municipalities have been communicating with the team, letting us know they'll be submitting them. There have been a few who have submitted them just directly to us in an email, and we've directed them back to the CIP. So I would expect this number to go up. So we're continuing to work with our stakeholders and municipalities. I wanted to thank Director Williams from the equity team, as well as Director Giancola from the government affairs team for being involved early in this process as well, just in terms of providing information on host communities, any feedback received from the equity participants, as well as just getting municipal contacts as well to make sure that we're reaching out to the applicable stakeholders as well. And if there's any questions.
Thank you, Director, for this update. Thanks to Cambridge, Lee, and Shrewsbury for kind of being the first through the door and getting approval. Greatly appreciate that. Commissioners, any questions? Okay. Commissioner Roy, go ahead.
I'm good, thank you. Just want to thank our DOI for her presentation. Thank you.
Thank you, Commissioner.
And happy to have this as kind of an ongoing topic to get updates on at future meetings. So thank you for that. All right.
I had a quick question.
Go ahead, Commissioner.
And I just wanted to understand the time frame. So we started reviewing at one point, and just how long have we been undergoing the reviews?
Sure. So we opened up this application in the CIP last year. I think it was last June. The application became, it's called an application just because that's how the CIP works, but it's a submission. They're required to make a submission. It was open last year. We did get initially 12 that submitted between last summer and this spring, and our policies and procedures were still being developed, as well as we needed some legal interpretation as well. So we did review those initial 12 that were submitted and wanted to then notify those municipalities that haven't submitted anything to us. So out of those 12, the 3, Cambridge, Lee, and Shrewsbury, were part of that original 12. The remaining 9 have been reviewed and will be followed up with. And then since we've begun issuing these notices, out of the 172, we have 157 we're still waiting on submissions, but some of those municipalities have been communicating with my team, letting us know that they'll be submitting them or have follow-up questions related to it.
And we are sending out additional notices to those outstanding municipalities?
So all municipalities received their outstanding notices. So all host communities, all those outstanding notices were issued during the month of July to put them on notice that they need to make a submission to us. We're now waiting for 157 of them to make that submission through the CIP so we can review it.
Okay, Acting Chair, I'm
Of course.
speaking.
Go ahead.
I just want to make so. Are we sending additional notices? Is that the plan if we're still waiting for municipalities to submit their application?
At this time, not for the ones that we're waiting for because they've received their outstanding notice this month. For those that we've received, so the 26 that are that have been received and haven't heard back from us yet. 9 of them have been reviewed, so they'll be getting either a notification that it's been accepted or a determination notice that says we need additional information or we've identified non-compliance. And then for the other 17, they need to be reviewed to receive additional notice on whether it's acceptable or not.
So I'm wondering if there's a plan, if there's still a number of outstanding municipalities, months from now, in spite of receiving notices.
Absolutely. So the notice does give municipalities 30 days, and most of the municipalities have responded in terms of their plans, whether it be taken up by their, respective select boards, et cetera. But we are also putting out another bullet. We're going to put out a bulletin to also remind municipalities that of this regulatory requirement, but also just walking through where they should be submitting this information.
Okay. Thank you. I look forward to having these updates on a regular basis, like you mentioned, Acting Chair. Thank you.
Thank you.
Thank you. Commissioner Roy, go ahead.
Thank you, Acting Chair. My question is for Cambridge, Lee, and Shrewsbury, who have complied, are these public documents, their plans?
I would defer that question to the legal department. It's in
Probably
the CIP.
Yeah, they're probably
But
business
yes, for
permitting ordinances.
the transparency, they do have this information on their website. So some of the information that was provided to us is on their website.
Just to clarify this is a little complicated. What Commissioner Roy is asking is, did the cities and towns that complied with this new requirement, did they kind of promulgate things that would indicate they did it? Now, I think this is, I don't know if this is one of the deputy general counsels or whatever it is, but I'm sorry, I just don't know who this person is. But they, what they're saying is, so first of all, it's a little complicated. When you implement this requirement under 94G 3A1I, what you're really doing, it's more than just 3A1I, but that's a general sort of subject heading 3A. What you're really, 94G 3A, what you're really doing is you're altering your business permitting ordinance for the local cities and towns, right? So it's not just, you're not just telling people like we're going to take the status into consideration of you as a small business when permitting you. It's you have to change your business permitting ordinance because it dictates how the town manager, or as an example, files things or sends them to the city council or the mayor. And so they have to do all this they have to do like legislative promulgation on the town level or city level to make this update. And then the Commissioner Roy saying, okay, how are they letting people know about this? Well, okay, first of all, I'm not trying to be redundant or pedantic here, but like a promulgation of a business permitting ordinance is a very obscure thing. It is a public document, but most people aren't paying attention to it. So Commissioner Roy is saying you can't just rely on the fact that they're updating their business permitting ordinance. Are they promulgating it in a way that their compliance plan that they've sent to us is publicly noticed? And that's what the general, or I don't know if this is the deputy general counsel or one of the lawyers, that's what she's answering. Good question, and I'm sure the answer will be on point. I told you, don't mess with my law. You better interpret it and regulatorily implement it. You better implement it in a valid regulatory way. Or I'm not the only one who wrote it. I just helped. I'm a tap.
Link to their plans, that
Good
might
idea.
help other communities comply, because it might be, a daunting undertaking. There's a lot to it. It's quite meaty. So to have examples up on our website for other communities, best practices to see, that might help them. So I'm looking at it as if these are public documents, it might be a tool for the other communities to look at and to use.
Yeah, certainly I would defer to general counsel if just in terms of what is a public document, and certainly happy to work with Anne Marie's team to identify anything else that needs to go on the municipal tracker.
Thank you. Commissioner Roy, GC, go ahead if you want to respond.
Just very briefly, without having seen the documents, I can't really, make a legal determination on whether they're public or not. I will say that the general presumption is that such records would be public. So I imagine at least some of these would be publicly available, and so for the purpose that you just mentioned, Commissioner, I think I think much, if not all, of these documents would be available to do so.
Commissioner Roy, go ahead.
Yeah, thank you, General Counsel. And at minimum, if they do have it on their website, we could link to their website. And I'm thinking this would help prospective licensees, right? So looking at communities that have these standards already established might be helpful, not only to other communities, but prospective licensees, social equity businesses. So I just think it's a tool. And if they already have it on their public platforms and websites, us linking over might be helpful.
Good suggestion. Thank you, Commissioner. Okay. No other questions. Director Benkatsky, thank you. Look forward to seeing you at future meetings on this topic. I'll turn it back to the ED to continue with his report.
Thank you very much, Mr. Acting Chair. And I believe if we go to the next slide, we're getting into the regular licensing data updates that you're getting regularly. And happy to take any questions after that. And then we will be completing the ED report. I believe we have Director Coble.
Hello, everyone.
Good morning, Director. I beat that by 2 minutes. Good morning.
Good morning. I know I was about to say good afternoon, and I was like, no, it's still morning. All right. I don't know if we're on the next slide. I see licensing data updates. Okay, there we go. All right. So as you can see, we have 6 applications awaiting first review, 19 applications awaiting supplemental review, and there, as you can see, is the number of certified active patients. Next slide. So on this slide, I want to highlight that we have added another 5 licensees that received commenced operations since the previous public meeting presentation. And overall, this represents a 10% increase since August of 2024. Next slide. Our pizza tracker is about, the same. Again, is just showing the licensing process, the applications, lifetime through the licensing process. Commissioner Roy, oh, sorry, I was gonna say speak to your request, but you go ahead.
Go ahead, Commissioner.
Back to Chair. Sorry to interrupt you, Director Koval. I just want to thank you because I saw this slide in that column with the active commence ops. I want to thank you so much. This truly gives the commission a real-time understanding of how many are commence ops. So I asked for that. You delivered. I just thank you so much. I was really excited to see that. Thank you.
You are very welcome. And I have to thank our data team because they actually help put this information together. So I was going to say, per your request, Commissioner Roy, and with data's assistance, we put this column together. So big shout out to them as well. Specifically, I'm not sure exactly who on that team, but the whole team. So again, I was going to highlight that column that this shows out of the total commenced ops, how many are active. Any questions? If not, we can move on to the next.
But Commissioner Concepcion, go ahead.
Thank you. Not necessarily a question, more of a comment. Director Koval, thank you for this. And Commissioner Wright, I echo your sentiments. This is really helpful. I know we have a conversation that will be publicly and with the board around the exclusivity period. And it's really helpful to see, who's commenced, who's actually actively operating right now, and all the other numbers to the pipeline. So I've just made notes, and I know I will continue to do so, particularly as it relates to the delivery license types. So thank you so much.
You're very welcome. Okay, next slide. So for both, the next 2 slides are the cultivator related slides. There really hasn't been any change to highlight here. So it's just the more of the same information that was presented last month.
Okay. Commissioner Roy.
Commissioner Roy?
Director Koval, on this slide, I know it's been brought to our attention that some folks have self-relegated, and I know later in the meeting we're going to have a tier relegation discussion and vote. Is that reflected in here? Like in those, and then if so, is there some slide in the future on relegations so we know we're at some point, like we have right now, we've only had self relegations, but down the road maybe a relegation slide.
So down the road, we could definitely work on putting something together. I mean, it would technically be reflected in here, but not in a granular way where you could pinpoint it. You would have to just essentially look at the number, the total canopy footage, and if it went down compared to the last month, it might signify that either there was a tier relegation or a shutdown or something. But yeah, you wouldn't readily be able to tell specific to tier relegation. So that's something, as you know, based on the further discussion that we're going to have later today, we can work on putting together for future public meetings.
And if I may follow up.
Of course, go ahead.
Yeah, thank you, Chair. And Director Cobalt, not on this slide, but in our board packet, I don't know if you're going to go through it. There was a slide it's like the 60th slide. It was way down. And it just, I had never seen this slide before because it was cultivation applications. And I always talk about how much canopy, right? And we have over 3 million that's active. And then in the queue, we have, you know, over 1 million in the queue, but this cultivation applications showed a total of 12.3 million current prospective square feet of canopy, and I had never seen that number before, and quite frankly, I almost fell off my seat because it said cultivation applications through August 14th of 2025. So I don't know if you're going to go over that slide, but I was shocked by what I saw on it because
So that is a slide that's included in every meeting packet, but just to explain, that slide encompasses all applications. So it could be that, you know, I started an application tier 11 5 years ago, and then I kind of just, it fell off, but it would be reflected in that number because it's just taking all of them. Not necessarily, that doesn't mean though that all of them are going to go to the process of getting to licensure. So some people might just start an application and it's kind of left there. So I don't know if that helps a little bit.
it does. I guess, so we're counting even ones that have been withdrawn, like so they started the process and they could have withdrawn their application?
Not the withdrawn ones, but what I'm saying is, you know, some people may start an application and just leave it open, you know, indefinitely. You know, they might decide to pick up process on it, you know, 4 years down the road. So it's hard for us to ascertain if this is someone that's actually going to complete the licensing process, or if they're just going through it very slowly, or if they are deciding no longer to complete it.
So the slide that you're on now, that you're presenting, doesn't incorporate that? I thought it did. Like the slide you're on.
So the one that I'm on incorporated, this represents the people that have already received a license. So whether provisional, final, commence ops. The slide that I believe you're referring to is speaking to the applications. So any application that's been started but it hasn't even reached provisional.
Okay, so, and I'm sorry, I'm truly trying to understand this. So I put that other slide in the chat, which has the over 12.3 million. So the slide that you're on now doesn't have pending applications?
Ones that have received an actual license, so they have at least provisional.
That's really helpful because I never saw the over 12. I guess I never realized it, that they were like, if you include the pending applications, that's over 12 million square feet of canopy. If you even though some folks have been maybe 5 years or whatever, but I was shocked when I saw that number. So thank you so much for that explanation.
You're very welcome. You're very welcome. Next slide. This slide shows us the difference between indoor and outdoor cultivators. And again, not much change has occurred here since last month. So there isn't anything really to flag or to, you know, pinpoint. If there are no questions, we can move on to the next. All right, so HCAs. So I will highlight that we are now at 1,087 total number applications received with HCAs. And again, just a reminder that as now we are into essentially the second year of reviewing HCAs, this number incorporates resubmissions in the sense that someone that could have been deemed approved last year will resubmit this year for their renewal, but we still have to do a full review. We cannot just assume that it's still the same HCA that was submitted last year. So this number would encompass that as well. The number of compliant HCAs has risen by another 60, so the total is now 873. And the number of compliant towns has risen from 141 the last public meeting to 156. So that is quite a positive trend, you know. So we're happy to see that. Soon we're going to run out of space for the towns. I think we may designate its own slide for future purposes. Any questions on this slide?
Commissioner Concepcion, go ahead.
I have a thought and I will throw it out there. This is phenomenal, the fact that the list has risen to this number, considering how far we've come. I wonder if at this point it might make more sense to do the reverse and have a list of towns that have no compliant HCAs.
So we actually spoke to legal, and I'll invite legal to jump in here as well. You know, we discussed that. I know Commissioner Roy had previously asked that as well. So I don't know if Kajal, you want to speak to that, or just kind of your thoughts on it.
Thank you, if I may, Chair. Yes. So we have discussed this in the past, Commissioner Concepcion, and due to concerns about just the nature of updates to the list and it not being entirely updated, there is a concern about sharing that information in a public document in this format. So we, as legal, has advised not to publish such a list, just given the potential for it to be either not up to date or not inclusive.
Acting Chair, if I may.
Of course.
Doesn't that apply to the current circumstances with the number of compliant HCA towns?
If I may, Acting Chair.
Of course.
The consequences here, I think, are a little bit different than, you know, listing compliant towns versus listing non-compliant towns. So there's a difference in, you know, how that information can be used or misused. So again, there is a concern there about the nature of publicly publicizing such a list.
Do you mind expanding on that? What do you mean by that?
Yeah, if I may, simply put, if there is a town that is mistakenly included in a list as being non-compliant, or if the information just isn't updated, that can, you know, lead to some negative consequences. It could lead to potential liability for the commission, which you know, we're obviously cognizant of and want to be very careful about.
I guess I'm having, because couldn't the same be said by their omission from the current list?
Yeah.
I think, again, if I may, I can share, it is a different thing to not have a name included in a list of compliant municipalities than it is to mistakenly either include a municipality on a list of non-compliant municipalities. That information, you know, can be updated in a subsequent meeting, but there are concerns about just the nature of signaling out municipalities that, you know, have not yet that don't yet have a compliant HCA.
Acting Chair.
Of course. Go ahead, Commissioner.
I feel like we're saying something that can be rectified by putting a timestamp on when the information was collected and saying at this date, when this information was collected, this is what we had.
She's a lawyer.
Sure, if I may. I mean, that there are, I think we can talk offline about this, so that there are there are pending legal actions, and we're going to be talking about that shortly this afternoon. Which again, publicizing a list may either come into, or it may implicate the lawsuit, and the commission is trying to be mindful of not taking any action that might impact the lawsuit and again cause liability for the commission.
Commissioner Concepcion, are you all set?
I'll wait until Commissioner Roy asks her
Okay.
question.
Okay, Commissioner Roy, go ahead.
Thank you, Acting Chair. My question is to the General Counsel. So Commissioner Concepcion and myself were part of the HCA working group, and we discussed this at length. And the intent of the working group, and we discussed it as a board in public meeting, was to disclose. As a matter of fact, I put the regulation in the chat, 500-180-D4. If you look at C, identification of a host community, lack of good compliance standing in a form manner determined by the commission. So we discussed this at length and we voted on this, and this was the intent of not only the working group, but the board. So, and we have it in regulation. So I just wanted to flag that this was discussed at length.
Thank you, Commissioner. I appreciate that. What intrigues me, and this goes back to the slide, the 156 towns even that we identify. Just looking through that list, it appears to me that there are some communities on that list who have provided compliant HCAs, perhaps with newer licensees, but we're certainly well aware of some situations where they have not, or still in the process, or we're still waiting for them to provide a compliant HCA with respect to some other licensees. So even looking at that list of 156, and Director Kofel, please correct me if I'm wrong, there are some communities in there that may have some compliant HCAs, but not others.
You're correct. Yes,
So,
that's correct.
Okay. All right. Thank you. Commissioner Concepcion, go ahead.
Thank you, Acting Chair. And what you said is exactly how I understand it. So the list of those with 0 compliant HCAs, that makes it more significant. I don't think my thinking is aligned with our General Counsel in this instance. We can definitely have another conversation about it, but I think there's more utility at this point to having a list of those who have 0 compliant HCAs up until this point.
Oh.
Thank you, Commissioner.
And Commissioner Roy, thank you very much for talking about all the work and conversations and everything that went into those regulations and how we got to this point. You're spot on. This is entirely the intent of the way that we've drafted our regulations.
Thank you, Commissioner. Certainly invite commissioners. Sounds like the GC is offer for invitation maybe to talk about this offline and to revisit it at another public meeting, but greatly appreciate the conversation. Commissioner Concepcion.
And one last question, Director Koval or anyone who's on the line now, can you tell us the number of the towns with non-compliant HCAs?
I could not right now. I would have to reassess the numbers. I do not have the number readily available, but I could get it.
Well, I can do a simple thing. What is the total amount of towns that are online right now that are yes towns?
Online, I'm gonna ask. I see Matt is online. If he could assist with that answer. We may need to get back to you to give you that number.
Okay, because obviously what I would do is just the math, going through the towns, deducting the amount of towns we have here as compliant. But thank you.
Thank you, Commissioner. Director is.
Okay, see Commissioner Roy has her hand up.
Oh, sorry, Commissioner.
I do. Thank you, Extra.
Slipped off
Thank you,
my
Director.
screen. Apologize.
Yeah, thank
Go ahead.
you. That's okay. Thank you, Director Koval. I just have a suggestion for government affairs and for licensing and for legal. You know, we have the municipal tracker. Maybe it's just a matter of color coding. Okay, like, you know, the ones with a compliant, fully compliant could, you know, be in red. The ones with half, some not purple, and the ones with none blue. Just simply color coding it so it's not a negative standalone list. And, you know, and time, like Commissioner Concepcion said, timestamp it, like as of this date. And then I have a key at the bottom, like, you know, if you're in red, you're fully compliant. I'm just throwing out colors. If you're purple, you got some arms, some aren't. And if you're blue, you got none. And this helps for prospective licensees as well to look at which towns are more willing to negotiate and be in compliance with Chapter 180. So just a thought, instead of a standalone negative list, we could just do color coding.
Love that idea.
Yeah, I agree.
GC, go ahead. I see you have your hand.
Thank you, Acting Chair. And just to respond, we can certainly look into that suggestion. So happy to think about that further and have further discussions about this. I, as you know, was not part of the working group, so don't have the benefit of the discussions that were had there. I am told that discussions did focus on the municipal equity portion of the statute. So I would like to take the chance to circle back and just learn more about the conversation and then take the appropriate action.
Thank you, GC. Fair enough. Commissioner Concepcion, go ahead.
Thank you. Just a point of clarity. There were two separate groups. One was municipal equity. That is true. And that was former Chair O'Brien and myself on that working group. But the HCA working group with its own working group as well. And that was with Commissioner Roy and myself. And that's where this was mapped out.
If I may, Acting Chair.
Go ahead, ED.
The Director of Government Affairs and Policy has added that 214 municipalities have some form of zoning in place and who have shared information with the Commission. I do think to a few different things I'd like to add to this conversation. One, I note, and we will obviously debrief as we always do on questions, as I did on an earlier item, requests. I would say, generally speaking, we are looking at a lot of manual work that we're trying to manage for a variety of different staff with things related to information on the website, information that we pull out of our IT infrastructure. We've discussed that in the past as it relates to our goals. So I think just to reiterate the General Counsel's point there, we will absolutely take a look at the presentation of this data, the appropriateness of flipping the script on it, or other ways to present that data. Not all of that can be done immediately given the IT infrastructure issues that we've highlighted in the past. And I think, you know, taking 214 plus 167 on the screen is certainly a way to look at it, as Commissioner Concepcion mentioned. But, you know, I'm a little uncomfortable as a former municipal official here with the back of the napkin math on this, but certainly am fully understanding the intent here, the points that have been made, and making sure that we reanalyze this for the next update.
Thank you. Commissioner Concepcion, go ahead.
Thank you, Executive Director. And I realize that this is a longer conversation, but we've identified a portion of our regulations that we are not complying with necessarily with the information that's being presented. You know, identification of a host community's lack of good compliance, standing in a form and manner determined by the Commission. I think this is a Commission conversation. I welcome, you know, more conversations with staff, but I think ultimately it makes sense for us as a Commission, as a unit, to discuss this and decide on what is the implementation that matches the intent of our regulations. Thank you.
Thank you, Commissioner.
Certainly.
Oh,
If
go
I
ahead,
may
Director
add really
Koval.
quick to the discussion of, 214, I would caution against subtracting 156 from 214, because we are not guaranteed that all those 214 municipalities have a licensee currently functioning. So they may get pulled into a list of non-compliance where, they have no reason to be on the list because they don't have an active license within their municipality. So yeah, definitely to Edie's point, we need to do a little bit further digging on the data end, which will take some time given our limited resources. So, okay. Any other questions on this slide?
I don't see any. Can go to I think your last one.
Yes, it is my last one. Okay, so here I would just like to highlight that we received another 94 extensions since last month. So again, we see this, they're consistently being used month to month. I believe we stay at around the 100 mark for every month, 100, 120 that we receive monthly. And the average number of days always hovers around 90 that are requested.
Thank you for that slide.
I think Commissioner Roy has a question.
Oh, sorry, Commissioner. Go ahead.
No, that's okay. Thank you, Acting Chair. Director Koval, my question is on the extensions. And I see we received a healthy amount of requests for 1,998. So now I think we had discussions a few months back about the clock's now running out.
Correct.
And have any licensees had to wind down operations as a result of this? And are there any recommendations to the board so we don't see mass closures or, folks going out of compliance because they just can't get that HCA?
So not yet, but that 600-day mark is approaching. And again, I will invite my colleague from legal team, Kajal. We have flagged it to, that we potentially may have someone coming up in a few months. So that's something we'll discuss internally and bring back to the board once it gets closer to that deadline.
Thank you, Director. Commissioner, did you have a follow-up?
I do, and it's in regards to tying in an earlier conversation about waivers. So I know that a petition is to amend and change a regulation, and it's in statute that they have to have a host community agreement. So I understand we couldn't just do that. But is the waiver, if we don't have an additional timeline for extensions, is that something that they could apply through a waiver to ask for additional time? If we are unable to do anything collectively here, is that afforded to them, the waiver process?
I would invite enforcement counsel to opine on here, as that would be for his team. Of course, they would have to show undue hardship regarding their request, but I'm not sure how enforcement counsel would see this matter.
Enforcement counsel, I invite you in. Certainly understand it's kind of a last-minute question, but I'll give you opportunity to offer your thoughts.
Yeah, thank you, Acting Chair. And thank you, Commissioner Roy and Director Koval for the lead in here. So I would say, Commissioner, to answer your question, it's difficult to say without seeing the actual request for the licensee, and also whether this would relate to specific regulatory requirements. So as mentioned earlier, each request is reviewed and addressed on a case-by-case basis based on the specific facts and circumstances that are presented there. I would say in terms of overall waivers, you kind of hit the nail on the head initially that those agreements are required pursuant to statute. So based on the criteria that I discussed earlier, we would not be able to waive that. If there were specific requests related to individual regulatory requirements, I imagine those may be considered, but it's difficult to speak to the hypothetical. So I don't want to give you a firm yes or no, but what I can say is that any request for waiver would be reviewed in the normal course, and we would be able to provide our recommendation that way. But I can't guarantee success or failure one way or the other there.
Thank you.
Thank you, Commissioner. All right, Director, does that do it for you?
It does. Unless
right.
there are any more questions, I can take off.
Appreciate your
Thank you.
willingness to put that offer out there, but thank you for the updates and
Thank
the
you
reports.
for having me.
Thank you, Olivia.
Edie, I think that concludes your commission and staff report.
Yes, thank you very much.
Okay. What I'm going to suggest, we're just shy of 12:30. What I would suggest is we take a lunch break and reconvene here at 1 o'clock when we'll jump into our licensing work and then other topics for commission discussion and votes. But thank you, commissioners, and see everybody back here at 1 o'clock.
All right, you heard it. All right, so we're in recess until 1 o'clock, ladies and gentlemen. 1 o'clock recess with the Cannabis Control Commission. My name is Grant Smith-Ellis. Good to see you. Let's play some towel trivia. Would you like to play some towel trivia? How are you all doing? It's great to see you, Nancy. Hello, Steph. Colleen Henry, I saw you in the chat. Hello, Peggy. Hello, H-Towel. I saw you in there earlier. Sheffield Flannel was hanging out. So yeah, let's play some towel trivia. Let's be little towels. Towel Mom was cooking on Twitter this morning. Did you know it was Towel Mom's birthday yesterday? Did everyone say happy birthday to Towel Mom, ladies and gentlemen? Did everyone say happy birthday to Towel Mom? Make sure to do that. But here's what we're going to do. We're going to play some towel trivia while the CCC is doing its thing. We'll play some towel trivia. All right? We like towel trivia. I like towel trivia. All right, so there we go. Oh, wrong one. Okay, let's play some towel trivia. Peggy, that's a good psychological agent for you. If you can't fool people, if you can't baffle them with brilliance, dazzle them with bullshit. If you can't baffle them with bullshit, dazzle them with brilliance. If you can't dazzle them with brilliance, baffle them with bullshit. And that's what Kate Peter does, the latter. Only certain people can baffle people with brilliance. I wouldn't know anything about that. All right. My name is Grant Smith-Ellis. Hello, Tanya. Hello, Steph. Hello, Bossy Texas Chick. We got a few things to do, ladies and gentlemen. First, let's see what Towel Mom is up to on Twitter this morning. Twitter was a flutter. All right? Twitter was a flutter. Twitter's always a flutter. You're a Twitter. How dare you call me a Twitter? I'm a towel. All right, here we go. What was Towel Mom up to on Twitter? Trivia Centers Grant. Trivia Centers Grant, but I'd begrudgingly accept it. Can't always be fun in games. I accept it, but I don't have to like it. Bossy Texas Chicken Bella. Hello, I'm a towel. All right, let's take a look. What did Towel Mom have to say on the Twitter? Twitter was a flutter. All right. Oh, she didn't even get that many. She didn't get that many. What is it? She didn't get that many retweets. All right, I'll give her a retweet. All right, hold on. We'll do the post together. Before we play towel trivia, we can always just pause the CCC for a few minutes before they come back. Before we do towel trivia, let's compose a special birthday post for Towel Mom. All right? Get a little picture of Towel Mom. All right, hold on. Hold on, ready? There's Towel Mom's tweet. Ready? Okay, there's Towel Mom's tweet. We're going to bring it up on the screen. This is my Towel Mom. It was her birthday yesterday. So, I am going to get a picture of her. I think I have one. I have multiple pictures of Towel Mom, but which specific picture I'm going to use is up for debate. So there's Towel Mom's post. Now, did you know it was Towel Mom's birthday yesterday? Did everyone go on Twitter and say happy birthday to Towel Mom? That's Towel Mom. She is Towel. Now, here's what I'm going to do for Towel Mom. All right, we're going to go over to which window here? We're going to go over to this one. All right, we're going to go over there. And I am going to get a picture of Towel Mom. Now, did you know Towel Mom was Patriots cheerleader? It's true. Wendy Murphy, New England Patriots cheerleader. All right, so I'm going to write a special post for Towel Mom. All right, I'm going to make a special post for Towel Mom. Now, you might be saying, your mom was not a Patriots cheerleader. Yes, she was. How dare you? I would know if my mom is a Towel Mom. You know what I'm saying? My mom, Towel Mom, I would know. You know what I'm saying? You know what I'm saying? A little bit. All right, so watch me work. All right? No, I don't want that. Here's what I'm going to do. Watch this. Watch this, little towels. Ready for this? We're going to make a nice picture for Towel Mom. All right, Towel Mom. It was Towel Mom's birthday. Make a nice little picture for her, and we're going to tweet it. All right? Hold on one second. Why are you being problematic? You are bothering me. I am upset. All right, there we go. Now, I'm going to show you how I'm going to tweet it. Now, I even found a picture of Towel Mom as a Patriots cheerleader. Now, my mom was also a baton twirler for Boston College when Doug Flutie was there, and then she went to be a Patriots cheerleader, and then Joe Testaverde threw a football and hit her colleague in the nose, and then the colleague sued, and so they got rid of Patriots cheerleaders, and that was the year before the Pats played, Refrigerator Perry and the Bears in the Super Bowl in '86. So my mom wasn't allowed to go to the Super Bowl because the Patriots got rid of all their cheerleaders after Joe Testaverde. No, not Joe Testaverde. It was Joe Namath, I want to say, threw a football and it hit one of the cheerleaders in the nose, and then she sued. So Towel Mom has, seen a lot. She's been through a lot. She's Towel Mom. And you might be saying, Towel, I'm well aware that your Towel Mom is a Towel Mom. I know. I don't think she necessarily loves that she has come to be identified as a Towel Mom, but she's Towel Mom. You know what I'm saying? Towel Mom is Towel Mom. All right, here we go. We're going to do a nice little post for Towel Mom. You ready for this? All right, we can make a little collage of Towel Mom. How about that? All right, hold on. Let me make a Towel Mom collage. All right, hold on. I got that picture of Towel Mom. I bet I have other pictures of Towel Mom. Hold on here. I'm a towel. All right, so there's a good one. Hold on. All right, come on now. All right, here we go. All right, so that's good. All right, now I got to find some other pictures of Towel Mom. Hold on, I'm working on this. I know we wanted to play trivia, but can you really blame me? When I'm getting a picture of Towel Mom? All right, so here we go. Got the picture of Towel Mom for Towel Mom's birthday. All right, I'm going to bring it up on your screen in a second. You just have to download it and prepare it for posting on Twitter. All right, Twitter is a flood. Actually, I got an idea. I'm gonna need the little towel. Hold on. I'm gonna need the towel. Oh, I like smart women. What do you want to do? What do you want me to say? Some people are legs men. Some people like faces. I like brains, intelligence. Okay. Watch this. Okay. Now, what if we have the towel actually flipped? Okay. Watch this. Flip horizontal. Okay, now watch. You can't see what I'm doing, but I'm preparing this special picture for Towel Mom. All right, so that's me. I'm a little towel. And you wait till you see this. I put myself on the picture. I just got to get a little speech bubble here for the towel because he's got to say happy birthday, Towel Mom. You know what I'm saying? Some people make birthday cakes. Some people make cards. Nope, I make social media posts and retweet my Towel Mom with an image of her as a Patriots cheerleader and then a speech bubble of me as a towel saying happy birthday, Towel Mom. Listen, if you can't get with it, you just can't get with it. All right, happy birthday, Towel Mom. All right, there you go. Haven't you always wanted to do that in your life? Make a birthday card that says happy birthday, Towel Mom with a picture of your mom as a Patriots cheerleader. I mean, it's just one of those things that's on everybody's, bucket list. You know what I'm saying? I'm a towel. I'm a little towel. If Noelle were here, I'd be like, I'm just a little towel. You know what I'm saying? And Noelle would be like, I got what Grant was saying. He's a little towel. All right, here we go. I'm just kind of floating there. Well, I guess towels do kind of float. You know what I'm saying? Little towel float. Little floating on air towel. He's floating. He's just high above it all. You know what I'm saying? Keeping an eye on the world going by his window. All right. Yeah, even the women in the chat, I agree. All the women in the chat are wonderful. All the towels in the chat, and the men in the chat can be wonderful too. We'll all be wonderful together because I'm a towel. All right, so here's what we do. I go over to this post by Towel Mom. All right, now let me just close this. Let me get it ready for you. All right, hold on one second. So I'm going to prepare the post. I made a nice image for Towel Mom. I'm going to quote it. All right, ready for this? And we're going to work on the post together. Then we're going to play some towel tricks. Long-form public affairs programming. CCC today. And you might be saying I'm learning a lot about the government. Well, good for you. That's exactly what I want you to do. I'm tricking you into learning about the government. Made you learn. All right, here we go. I got my picture. I got it. Okay, everybody ready? Hold on a second. Okay, we're ready. You ready? Towel Mom birthday card about to show up. There it is. Now I got to make this a little bit more centered so you can see me write the post. But there it is, little towels. See, it says happy birthday, Towel Mom. You see what I'm saying? How great is that, little towels? So now we go over here. Ladies, gentlemen, and fellow towel moms, it is my honor during the birthday week for Towel Mom to say happy birthday to the aforementioned Towel Mom. If you can't tell, she doesn't exactly love that I call her Towel Mom, and I'm hilarious. She is now 27 years young. I am so proud of her. There you go, ladies and gentlemen. How did I do? Is that a good picture of Towel Mom? All right, now hold on one second. Hold on one second. All right, now let me just make sure. There we go, little towels. You see the full picture in the post? I'm going to post it in a second so we can take a look. Let me just make sure it's shorter than 240 characters. All right, little towels. No, is it? No, it's longer than 280. All right, hold on. I have to do some editing. She is 27 years young. Okay, is that short enough? No, it's not. It is my honor during this birthday week for Towel Mom to say happy birthday to Towel Mom. We got to get rid of aforementioned. To Towel Mom. That was just enough. If you can't tell, she doesn't exactly love that I call Towel Mom, and I'm hilarious. She is 27 years young. I am so proud of her. Here we go. Everybody ready for the post? I have made the post. That is wonderful. Now, would you like to see the image of Towel Mom? I'll make it a little bit clearer for you. There it is. That's Towel Mom. Okay? Is everybody pleased to see Towel Mom? She was a cheerleader for the Patriots. And then I made a little image that says, happy birthday, Towel Mom. I know I'm endearing and hilarious. Look at that. Look at that. Look at it. I worked hard on that. I know you all want to play trivia, but I just want to show you that. We can play 20 minutes of trivia before the CCC starts up again. Okay, isn't that such a nice picture of Towel Mom? We do animals of the day. Now we do places of the day. We're doing Towel Moms of the day. All right, let's do it. Let's do some towel trivia. All right. Might even take my glasses off for this. How about that? How about that? All right. I can see so much better now. I was a little blinded by the glasses there. That's ironic. I wasn't blinded by the light. I was blinded by my glasses. What a great picture of Towel Mom. I know. I'm hilarious. All right, here we go. Towel trivia. You know the rule. It's informal. The way that it works is if I get the question right on the you're going to see a question come up on your screen. If I get the question right, ladies and gentlemen, and by the way, this is your towel trivia announcement. So if your name is Allie, Rue, Bossy Texas Chickabella, various other people, Peggy, Steph, Colleen Henry, feel free to play some towel trivia until the CCC starts up again at 1 p.m. Now, the way towel trivia works is if you're new to the game, feel free to just join in. We welcome new towel friends, and I enjoy learning. The way that it works is pretty simple, towel friends. What we do is we're going to put a question up on the screen. You are going to see 4 answers. Put 1, 2, 3, or 4 in the chat based on what you think the right answer is. Now, if I get the question right, all right, I get a point. Okay? If you get the question right as well, and you're the first one in the chat on my phone to get the question right, you get a point. After the first person, you get half a point. Here's where it gets fun, though. If I get it wrong, and you get it right first, 2 points for you. If you get it right after that, 1 point. If we're in a double bonus round, which I will announce ahead of time, and you get it right, then guess what? You get, ladies and gentlemen, you get 4 points if you're the first one to get it right. And if you are get it right subsequent to that, you get 2 points. All right, you get no points for getting it wrong. Now, if you would like to see our current standings, if you would like to know our current champion, it is technically Bossy Texas Chickabella, because I'm an automatron according to Bossy Texas Chickabella, so I don't count as a human. And as a result, this is the scores right now. Okay, so we have Bossy Texas Chickabella technically wearing the crown because I'm an automatron. And then these were the scores from last round. I'll bring up your scores from this round in a second as well. This is my document that I've had open since May 5th. It has every one of our rounds. So there you go. You can see the current scores. All right. That's who we have on the board from last round. We'll do another round today, obviously, but I'm just getting you all caught up. So Towel was in first. Bossy Texas Chickabella were really in first, though. Then Allie, Steph, Nancy, Peggy, Ola, Cynthia, Tatabug, who hates commies and is a super Tatabug, Francesca, Solo, Bunny, Chris, Paula, and Jack D65. Grant, you comp, your scores dope. That was my mom, Judy. That was Towel Mom. It's her birthday. She's W. Murphy Law, Wendy Murphy on Twitter. Twitter's all a flutter. All right, here we go. Here we go, little towels. Who's ready for towel trivia? We are going to do a fun first round. It's going to be the show Happy Days. Who likes the show Happy Days? It makes me happy to talk about happy days. Who has found happiness in their life? I think I have. I want to make everyone feel happy. I think we all deserve to have this level of happiness. So my goal is to spread it to the entire world so that everyone feels happy and we can just work on making the world a better place. I'm a towel. Little fluffy towel. All right, so the first category of the day is Happy Days. The TV show Happy Days. All right, so let me get the scoreboard all ready. Let me get your scores prepared. All right, this is round 21 of Towel Trivia, ladies and gentlemen, round 21. And the date is 8/14/25. All righty, ladies and gentlemen, the TV show Happy Days. That is our first category. Everybody ready? First question. Hold on, I might have to make the answers a little more clear. I'll do it. What animated character assists a former cop in his search for his daughter? Oh, no, sorry. Quit, ladies and gentlemen, quit. That was a false start. We have had a false start. I forgot to type days. The TV show Happy is not really a thing. We have had a false start. I repeat, do not answer the first question. I meant to type Happy Days. I typed Happy. I'm a little towel. All right, everybody, false start. Everybody back up. Everybody back up. The TV show Happy Days, ladies and gentlemen. The TV show Happy Days. Here we go. The first question is, which establishment served as a central hangout for the characters? Is it Arnold's Drive-In, Patty's Diner, the Peach Pit, or the Max? Is it Arnold's Drive-In, Patty's Diner, the Peach Pit, or the Max? That was an establishment that served as the central hangout for the characters in Happy Days. Show me Arnold's Drive-In. Towel got it right. Bossy Texas Chicabella got it right. Nancy, of course, got it right. I knew you were going to like Happy Days, Nancy. Steph is Super Towel got it right. Steph's Canadian, British, and German. Jill, it's great to see you. Jill got a point. And Solo is here. Great to see you, my friend. You are a Super Towel. Solo nailed it. Now, by the way, this is just a first round of Towel Trivia, so if you're just tuning in, don't feel like people have 50 points or anything. We are just getting our first points up on the board. Judy, hold on. Let me turn my stream on to see if I can hear myself okay, all right? Oh, Judy, you might just need to restart your stream. My audio's coming across okay on my phone. But yeah, so I'm just giving people a little bit of a second to, we're just doing the first question, so. All right, here we go. Next question. Who portrayed the character known as the Fonz? Was it Marion Ross, Donnie Most, Ron Howard, or Harry Winkler? Who portrayed the character known as the Fonz? Arthur Fonzarelli. Was it Marion Ross, Donnie Most, Ronnie Howard, or Harry Winkler? It was Harry Winkler. Come on, he hasn't jumped the shark just yet, ladies and gentlemen. It was Harry Winkler. Steph was the first one to get it right. Ladies and gentlemen, Steph was the first one to get it right. Steph knew her Harry Winkler. Steph, have you always been a Harry Winkler fan, or was it after he jumped the shack? You know, because sometimes jumping the shack isn't safe, you know what I'm saying? Bossy Texas Chicabella get half a point. Jill gets half a point. Nancy gets half a point. Solo gets half a point. Peggy gets half a point. Everybody's nailing the Happy Days category. We are all having happy days. I wish I could play the theme song. I like the Happy Days theme song. The jokes are pretty funny. Harry Winkler riding that shack might have been the stupidest thing I've ever seen. All right, next question. All right, next question. Which decade does the series primarily depict? Is it the 1930s, the 1960s, the 1980s, the 1970s. So again, which decade does this series primarily depict? The 1950s, the 1960s, the 1980s, or the 1970s? Show me the 1950s. Nailed it. I'm a cultured towel. You know, I'm cultured. I'm sorry, it was not the 50s. Nancy from the 508, ladies and gentlemen, picks up the full point. Jill Young-Smith picks up half a point. Oh no, Elijah Towell's here. Everyone ready, folks? Elijah Towell's a genius. I'm so excited to have Elijah Towell. Hello, it's great to see you. Peggy Towell, really good guess. Unfortunately, it was the 50s, not the 60s. And Solo comes in, absolutely nails it, grabs half a point. We might get started a little bit late on the CCC, by the way. We'll play Towel Trivia. We'll play 3 rounds before we start up the CCC. For those of you just tuning in who watch a lot of CCC but don't watch Towel Trivia, have fun. Join the game. It's something we do on stream no matter what's going on during the day, usually, if I'm in the mood. All right, next question, little towels. What was the name of Richie Cunningham's younger sister? Was it Pinky, Chachi, Joni, Nancy? What was the name of Richie Cunningham's younger sister? Was it Pinky, Chachi, Joni, or Nancy? Now, I think Chachi was the older sister, or was Joni the older sister? Oh, it's so hard. I'm going to go with Joni. It was Joni, ladies and gentlemen. Towel got it again. Number 3, Jill Young-Smith gets the full point. Nancy from the 508 gets half a point. Bossy Texas Chicabella, half a point. Elijah Towell, half a point. Told you they were going to come on strong. Steph Towell, half a point. Solo, half a point. Excellent job. Excellent job. Steph Towell, you managed to get it right. Next question. What device did the characters commonly use to communicate in the series? A walkie-talkie, a telegraph, a fax machine, or a telephone booth? Which device did the characters commonly use to communicate in the series Happy Days? A walkie-talkie, a telegraph, a fax machine, or a telephone booth? Some of you are going to be insulted by this question. They clearly used a fax machine, you know what I'm saying? That was the way to do it back in the day. It was a telephone booth. Jill Young-Smith gets the full point. Bossy Texas Chicabella, half a point. Nancy Towell, half a point. Elijah Towell, half a point. Steph and Solo, half a point. Great job, Steph and Solo. All right, everybody, that was question 5. One more question in this round. They used something called Airtel, Steph, which was an early version of a fax machine. But yeah, basically, they had faxes in the 60s, but it was mostly for government. Like, Airtel was very expensive. And most people would not have had it in their home. But the government had it. How do you think Back to the Future was made, just so you know? They made Back to the Future because a lot of that technology, the military already had it. They just let Hollywood talk about it a little bit. You know what I'm saying? Yeah, in the 50s. Yeah, they had fax machines in the 50s and 60s. It was just called Airtel. Both, the 50s and 60s. I think it was invented, you know, I'd say, like, I've seen FBI documents via Airtel as early as, like, 45 to 48. It was kind of like SIGINT, Signals Intelligence, that came out of World War II, Airtel, and that was the early fax machine. But it was only for the government, basically. Some companies used it. You had to go to an Airtel location. Murder by Maestro was telling me it was very expensive. Next question. What musical act performed the show's theme song during its original airing? Was it Pratt and McLean, the Monkees, the Supremes, the Beach Boys? What musical act performed the show's theme song during its original airing? Pratt and McLean, the Monkees, the Supremes, or the Beach Boys? Monday, Tuesday, happy days. Wednesday, Thursday, happy days. I'm going with the Beach Boys. No, it was Pratt and McLean. Nancy from the 508, that was the only one I got wrong, picks up 2 points. Bossy Texas Chicabella, pick up a point. I go by Steph, picking up a point. Good guess, Elijah Towell. Jill Young-Smith, picking up a full point. That was a good one. I feel like I like that song. It could have been the Monkees. Good guess, Solo. I thought it was the Monkees too at first, but it was Pratt and McLean. All right, let's check our scores. Oh, we have a two-way tie up at the top of the leaderboard. For the first time, I believe she is wearing the crown. Oh my goodness, ladies and gentlemen. I have an announcement for you. And we have a ferocious competition, even though it's a small field today, which we like because it makes it more manageable for Little Towel. There's your scores. There, no, those aren't them. There they are. Check and look at it, ladies and gentlemen. In first place, I think for the first time ever, wearing the crown heading into round 2. You know her as Nancy Towell. She is Nancy Towell. She has 5 points, ladies and gentlemen, and she's wearing the crown heading into round 2 of Towel Trivia today. Excellent job, Nancy Towell. Tied in first place, you know him as Little Towel. He's an automatron. He counts, but his scores don't. His name is Towel. He has 5 points. Now, here we go. We have Jill. We have Jill in second place, ladies and gentlemen. Excellent job, Jill. Right behind Towel and Nancy Towell with 4.5 points. Excellent job, Jill Towell, keeping Nancy Towell and Towel honest up there at the top of the leaderboard. Nancy Towell says goals. Excellent job, Nancy Towell. I'm very proud of you. In second place, as mentioned, we have Jill, 4.5. Jill, you are right up there. You're battling, holding on that podium spot. In third place, Bossy Texas Chickabella. They are from Texas. They are bosses. They are chicks, and one of them is named Bella. They have 3.5 points. They are on the podium, third place. Now, right tied with Bossy Texas Chickabella, she's half Canadian, she's half German, she's half English. Her name is Steph Towell. She has 3.5 points. Serendipitously enough, they are both in third place. Bossy Texas Chickabella, Steph, and all the British people and the Canadian people and the German people together combined, they're in third place. In fourth place, doing excellent, kicking butt, taking names, it is Solo. Excellent job, Solo Towel. 2.5 points in fourth place behind Nancy and Towel, who are in first, behind Jill, who is in second, behind Bossy Texas Chick, who is in third, tied with Steph. And as a reminder, Nancy and Towel have 5 points, Jill has 4.5, Bossy Texas Chick and Bella and Steph have 3.5, and Solo in fourth place has 2.5. Excellent job, Solo. We are all very proud. Elijah Towell joined the game a few questions late, coming in fifth place. We all know Elijah Towell is a persistent threat, though. Very intelligent, genius Towell. 1.5 points. And then in sixth place, the position of honor. She loves Peep Towel. Peep Towel loves her. Her name's Peggy Towell. Peep Towel's wishing her luck. Hold on. Peep Towel, is there anything you would like to say to Peggy Towell? Oh, look at Peep Towel. Look at him. He's here. He would like to say, Peggy Towell, you got this, and being in the position of honor is very important. Anything else, Peep Towel? You hate the communists? I also hate the communists. Thank you, Peep Towel. Peep Towel is thrilled that you're all doing well, and he wants Peggy to know he hates the commies. All right. Hello, Faith. You jump live anytime you want. We're playing Towel Trivia, and not much happens after that point. So, but yes, God bless you, Faith. Thank you for well wishes to Towel Mom. All right, next Towel Trivia category. Next Towel Trivia category is going to be an ad about I do my own stunts. No. Let's see. What is it going to be? What is it going to be? What is it going to be? Ooh, I was thinking about another TV show. Then I was thinking about Happy Days. Then I was thinking about what was I thinking about? I was thinking about TV shows. I was thinking about Happy Days. Thinking about songs. Let's do the Scooby-Doo cartoons from the 1960s. Sorry about that. Scooby-Doo cartoons from the 1960s. All right, here we go. Next category. Scooby-Doo cartoons from the 1960s. Let's do it. First question. Oh, sorry about that. Which group solves mysteries in the animated series? Is it the Sleuth Squad, Mysteries Inc., the Investigators, or the Mystery Crew? Which group solves mysteries in the animated series? Is it the Sleuth Squad, Mystery Inc., the Investigators, the Mystery Crew? I think it's Mystery Inc. Got it, Little Towels. Got it. Little Towel. Who else knew it was Mystery Inc.? No, Nancy, that was a good guess. You knew it was Mystery, but it was Mystery Inc. We'll give some time for people to get caught up. No, I know. Oh, a lot of people guessing the Mystery Crew. I mean, it's an attractive answer because it has the word mystery in it. Some people might have lagged a little bit on the stream. I'll give them a little bit of time. Nobody except for Towel got this one, ladies and gentlemen. I'm not saying it was a very easy question, but nobody outside of Little Towel got this one. So I'm going to give Bossy Tex Chickabella, I'm going to give them a few minutes, but that's all right. Heading into the next round. Here we go. Oh, you have a great time, Solo. Thank you for being with us. Have a good time at your doctor's appointment. What type of creature often appears as a villain in the show? A zombie, a robot, a dragon, or a ghost? What type of creature often appears as a villain in the show? A zombie, a robot, a dragon, or a ghost? It's a ghost. Ghosts are very, very common.
ED, how are you?
Hold on one second. Let me pause this meeting so we don't have to listen to it while we finish our round. All right, I've paused the meeting. We're going to play one more round of Towel Trivia. The answer was ghost. Oh, good guesses again. Oh, no. I understand, Bossy Texas Chickabella. Elijah Towel was the only one to get that right. 2.5 points. Oh, there was definitely a mummy in some of the Scooby-Doo episodes. Don't get me wrong about that. Next question. Last round before we go back to the CCC. Which character frequently serves as the comic relief in the series? Which character frequently serves as the comic relief in the series? Daphne Blake, Velma Dinkley, Fred Jones, Shaggy Rogers. Which character frequently serves as the comic relief? Daphne Blake, Velma Dinkley, Fred Jones, Shaggy Rogers. Show me Shaggy. Oh, good guess, Steph. Fred is the attractive one. He's not really comic relief. Jill Towel knew that it was Shaggy. Shaggy likes to get a laugh. Oh, good guess, Nancy Towel. Good guess. But it was Shaggy. I got Adberked. Give me a second. All right, I'm back. Next question. Steph was like, I meant for. What is the name of the vehicle used by the characters in Scooby-Doo? The Phantom Mobile, the Scooby Van, the Mystery Machine, or the Ghost Cruiser? What is the name of the vehicle used by the characters in Scooby-Doo? The Phantom Mobile, the Scooby Van, the Mystery Machine, or the Ghost Cruiser? It is the Mystery Machine. Everybody knows the lean green Mystery Machine. Steph Towel was the first one to get it right, ladies and gentlemen. Jill gets half a point. Nancy, half a point. He looks like Fred and he is comic relief. That's funny. And he is kind of comic relief. I agree, Steph Towel. All right, next question. Last round before we go back to the meeting. In which year did the original series debut? Was it 1973, 1967, 1971, 1969? In what year did the original Scooby-Doo series debut? Was it 73, 67, 71, or 69? I want to say it ran 67 through 79. No, 69 was the starting year. Oh, I got screwed. Ladies and gentlemen, I got screwed. It was 1969. A fine year. Elijah Towel picking up 2 points. Fine year to be alive, ladies and gentlemen. Fine year. Let's go. Next question. What is the name of the ghostly antagonist often associated with the Scooby-Doo show? Is it the Phantom Shadow, the Creeper, the Headless Horseman, or the Space Kook? What is the name of the ghostly antagonist often associated with the show? The Phantom Shadow, the Creeper, the Headless Horseman, or the Space Kook? It's either 3 or 4. I'm going with 3. It was the Phantom Shadow. That was just subjective. That's a very subjective question. All right, so hold on. I need to figure out what answers for Steph guessed 3. That was wrong. Elijah Towell was the first one to get it right. 2 points. Nancy from the 508, half a point. All right, excellent job. That was a tough question. All right, that was the end of that round, ladies and gentlemen. Now let's play our towel trivia song. Let us listen to our towel trivia song before we go into our scores and then back to the CCC meeting. Oh no, Bossy Texas Chicken Bella left right when I needed that link, because hold on, I'll find it. I have the link to the towel trivia playlist. Just give me a second. All right, let me find it. Towel trivia, female vocals. All right, I'll find it. I shall find it. All right. But yes, before we go back to the CCC meeting, there's one thing I like to do. I really like the towel trivia song. Sorry. Oh, showing an ad. All right. All right. Towel trivia. Here we go. Let's see if it still works. I might have to switch to her new playlist. Hold on. Yep, it's here. All right, we get to listen to it. My favorite song in the entire world. I'll get Peep Towel. Give me 1 second. Let me get Peep Towel for you. All right, Peep Towel will be right back. Peep Towel's here. And then we are going to watch the CCC. We'll play more towel trivia in a few hours when they take their next break. All right, take it away, Bossy Texas Chicken Bella on piano.
Well, I stumbled on this channel one day. Grant Smith Ellis show from Boston way. Smoke cigars and towel is his sign.
Oh, hold on. I don't like the male version. I like the other one. Give me 1 second.
Welcome to it.
Oh, no. I don't like that one. Where's this one? Oh, I have to click this. Hold on. Hold on. I want the one with the peep. There we go.
Welcome to Grant's Towel Trivia. All you knowledge junkies, but grab your inch and your towel. More fun than a barrel of monkeys. Grant and his cigar is on the screen with a smile. He's got lots of questions, so we'll be here a while. All of us contribute in our own special way, and it doesn't matter who wins at the end of the day. We're the top community and we won't stop. Steph is at the top, she never does flop. Ollie, Ruth, and Nancy are sprinting towards the finish line. Kitty's 1993 is not too far behind. Tater, Bug, and Dewdrops are smart and so kind. For one family, we're family. Ruth and Captain know their stuff. Jeff's waiting on the clue. Claudia's got the answers, but Bunny does too. Lydia's sharp as a tack. Deb Potter's on the ball. Sometimes we grumble when our scores get called. Now Harvard Yard keeps guessing answers that ain't up on the board. Don't ask me how, but she just scored. Bossy Texas Chicken Bell are in last place again. They're always at the bottom, but one day they will win. Ooh, that's alright. That's what they don't let you in. Every day's a new adventure in Towel Trivia Town. KR's not guilty, but that won't get us down. From the brightest to the struggling, we all play Here's to all the players and the hosts so fine in this little slice of heaven where we all do shine. Town trivia time. Town trivia. Welcome to the Grant Smith Ellis Show. When you know you know. Ooh, 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 Towel Pride.
Pete Towel is excited. We love it. And thank you, Bossy Texas Chick. I'm slowly learning to click the album art. All right, before we return to the CCC, after 2 rounds of Towel Trivia, we love it, Colleen Henry. It's one of my favorite songs. After 2 rounds of Towel Trivia, we have Towel, the Automatron. He counts his score dozen, up at first place with 9 points. In second place, holding on strong, ladies and gentlemen, we have a 2-way tie between Nancy Towell and Elijah Towell. I told you Elijah Towell was going to shoot right up on that board. 6.5 points each in second place. In third place, right behind Elijah Towell and Nancy Towell, Jill Towell, 6 points. So we have a podium of Towell in first, Nancy Towell and Elijah Towell tied in second, and Jill Towell in third. Right outside the podium position, we have Steph Towell in fourth, serendipitously enough, with 4.5 points. She's half German, half Canadian, and half British. Right behind Steph in fourth, in fifth place, she's a boss. She knows Bella. She's from Texas. She's a chick. Bossy Texas chick Bella, 3.5 points. The composer and the piano player behind that great song was Bella. In sixth place, right behind Bossy Texas Chickabella, Solo's at the doctor. We're wishing them well on their trip. Solo is at 2.5 points. Sixth position. Excellent job, my dear friend. And in seventh place, the position of honor, she is Peep Towel's biggest fan. Peep Towel loves her very much. Peep Towel says, go Peggy, screw the damn commies. And also, he loves you all. Peep Towel says Peggy Towel is in the position of honors. Half a point, ladies and gentlemen. All right, so a new adventure, damn right. Let us go back to the CCC meeting. Thank you very much for your indulgence, ladies and gentlemen. Well, I played some Towel Trivia. All right, so we got the Cannabis Control Commission meeting. We're going to start right up. We didn't miss any of it, not one little second of it, ladies and gentlemen. Do you know how I know that? Because I paused it right as they got back from break. Let's go.
So, hoping to not fall asleep if I eat too much here. Hey, Paul, can you send the public meeting link to Gnome, please?
Okay, I'll write it back in and see if it works.
Thank you.
Okay. Commissioner Roy, welcome back.
Thank you, Acting Chair.
Commissioner Concepcion, are you back with us?
I am here. I just have to be off camera for a little bit, but I'm here.
Okay. All right, let's see. The other person that we definitely need for this section is our friend Christine. Christine, are you with us? I see you there. You're okay.
Okay.
Awesome. All right. We can move right into our licensing work. And Christine, invite you in. We'll tackle first. We have a few changes of ownership to consider.
We'll only do this speed thing.
Good
for
afternoon,
a
Acting Chair
second.
and Commissioners. The licensee here is Thank you. The licensee here is Commonwealth Alternative Care Inc., and they are seeking a change of ownership and control of 1 adult use license and 1 MTC license, and are requesting to add 5 individuals and 2 entities. Commission staff has reviewed the application for compliance with applicable laws and regulations, and are presenting it for the Commission's review and vote.
Okay. Any questions on this change of ownership for Commonwealth Alternative Care Inc.? Seeing none, I would seek a motion to approve the change of ownership for Commonwealth Alternative Care Inc. Do I have such a motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye. 3 in favor, none opposed. Okay, Christine, the next one.
The licensee here is Leaflux Group Inc., and they are seeking a change of ownership and control of 1 adult use license, and are requesting to add 1 individual and 2 entities. Commission staff has reviewed the application for compliance with applicable laws and regulations, and are presenting it for the Commission's review and vote.
Okay. Any questions on this change of ownership? Seeing none, I would seek a motion to approve the change of ownership for Leaflux Group Inc. Do I have such a motion, Commissioner Roy?
So moved.
Do I have a second, Commissioner Concepcion?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion.
Aye.
Commissioner Roy.
Aye.
And Commissioner Stebbins votes aye. 3 in favor, none opposed. All right, Christine, we'll move down to renewals.
There are 22 adult use and 3 MTC renewal recommendations for the Commission's consideration.
Okay, I did not receive any proposed conditions, but I'll just double check with my colleagues. Anybody had any proposed conditions that I might have missed for these renewals? Okay, seeing none, I will seek a motion to approve the renewal licenses for renewals listed as 1 through 25 in the board packet. Do I have such a motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy?
Second.
Motion made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion.
Aye.
Commissioner Roy.
Aye.
And Commissioner Stebbins votes aye. 3 in favor, none opposed. All right, Christine, you're breaking some land speed records here. Why don't we move down to staff recommendations on responsible vendor training renewals?
First, we have the applicant here is ACTA LLC. They are seeking to be renewed for an additional 2-year certification to provide delivery core curriculum training in the responsible vendor training program. Since their original certification date, they have provided instruction for 12 marijuana establishment and medical marijuana treatment center agents. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Any questions, commissioners? Okay, if not, I would seek a motion to approve the renewal of a responsible vendor training license for ACTA LLC, number DCCR 794121. Do I have such a motion, Commissioner Roy?
So moved.
Do I have a second, Commissioner Concepcion?
Second.
Motion made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion.
Aye.
Commissioner Roy.
Aye.
And Commissioner Stebbins votes aye. 3 in favor, none opposed. Okay, Christine, the next one.
The applicant here is Bartuca Consulting LLC. They are seeking to be renewed for an additional 2-year certification to provide delivery core curriculum training in the responsible vendor training program. Since their original certification date, they have provided instruction for 16 marijuana establishment and medical marijuana treatment center agents. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Any questions on this, commissioners? If not, I would seek a motion to approve the renewal of a responsible vendor training license for Bartuca Consulting LLC, number DCCR 794126. Do I have such a motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy?
Second.
Motion made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion.
Aye.
Commissioner Roy.
Aye.
And Commissioner Stebbins votes aye. 3 in favor, none opposed. All right, and Christine, the last one.
Applicant here is Grass Ceiling LLC. They are seeking to be renewed for an additional 2-year certification to provide delivery core curriculum training in the responsible vendor training program. Since their original certification date, they have provided instruction for 27 marijuana establishment and medical marijuana treatment center agents. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Commissioners, any questions on this renewal? Okay, seeing none, I would seek a motion to approve the renewal for responsible vendor training licensee Grass Ceiling LLC, number DCCR 794125. Do I have such a motion, Commissioner Concepcion.
So moved.
Do I have a second, Commissioner Roy?
Second.
Motion made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion.
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye. 3 in favor, none opposed. All right. And Christine, I think, sorry we had to make you wait a whole extra half hour, but thanks for getting us through these. Anything you'd like to say now that we've wrapped up this portion?
I just want to say thank you. It's been a pleasure, and thank you to the whole licensing team for really pulling this together.
Thanks, Christine. Greatly appreciate it. All right, commissioners, we will now move on to item number 7, which is enforcement actions. And I'll invite back in our enforcement counsel, Tim Gooden, and our first assistant enforcement counsel, Jacob Nielsen.
Thank you, Acting Chair. And I will also note as well that I believe our Chief of Investigations and Enforcement, Khaleesi Jones, is also here with us as well. So I just want to start off. Good afternoon, Acting Chair and Commissioners. For your consideration this afternoon is a proposed final order and stipulated agreement that follows the issuance of a summary suspension order to Assured Testing Laboratories, LLC, license number IL281360, that was issued on June 30th, 2025, and became effective at midnight on July 4th. This agreement is the culmination of investigative and enforcement efforts relative to this matter. And much of the facts as presented by the Commission in this agreement are similar to and will follow those established in the underlying summary suspension order. So just to I will briefly summarize the facts here. Through the department's investigation, the department found that from April 1st of 2024 through April 15th of 2025, Assured engaged in a practice of reporting testing results in a non-compliant manner. The department's investigation initially focused on total yeast and mold compliance testing results. Through that investigation, the department found that the licensee did not report the measured value in metric for approximately 7,000 lab samples, which received results between 0 to 10,000 colony forming units, or CFUs. And further, they did not report failing test results, so those results in excess of the Commission's established limit of 10,000 CFUs for 544 lab samples during that time period. The Commission has since, and as discussed earlier today, we have since issued a public health advisory relative to those 544 samples and have identified packages that stemmed from those test samples on the corresponding public health advisory page. The department also found that Assured's non-compliant reporting extended to some other areas of compliance testing, notably microbial component testing, pesticides, potency, and heavy metals. In that vein, there were 2 periods, one June 2024, and then again December 2024 to February 2025, where Assured reported that certain compliance samples passed pesticide and mycotoxin testing before those tests were actually completed and test results were obtained. However, I will note that those samples subsequently passed the required compliance testing, but they were not reported at the time of the initial test. Based on the department's investigation, it appears that the non-compliant reporting practices stemmed from an SOP that Assured has since amended and no longer uses. The final order and stipulated agreement that is before you for consideration provides a more detailed outline of the stipulated facts of record as well as the Commission's findings. So I just want to note that the summary suspension order, as indicated before, has remained in place since July 4th of this year and continues to remain in place based on the terms of the proposed order. Following the imposition of that order, the licensee, through their counsel, proposed terms to settle this matter, which resulted in further negotiation and ultimately the proposed agreement that is before you today. So pursuant to this agreement, Assured has stipulated to the facts of record and applicable law as laid out by the Commission. However, they are neither admitting to nor denying the Commission's specific findings. So I will now briefly summarize those findings. Through its investigation, the department and the agency found the following violations. Violation number 1, the licensee did not report test results for marijuana lab samples indicating contamination to the Commission in violation of General Laws, Chapter 94G, Section 15, subsection A, Clause 3. As well as regulations 935 CMR 500-160 sub 4 clause B in the corresponding medical regulation 935 CMR 500-160 sub 4 clause B. The second violation is that the licensee reported testing results of marijuana lab samples to the Commission in violation of our regulations, specifically 935 CMR 500-450 subsection 2 and the corresponding medical regulation 935 CMR 500-450 subsection 2. For the third violation, or the Commission's third finding is a violation of failure to comply with the Commission's statute and regulations by implementing and following a standard operating procedure that was inconsistent with the Commission's independent testing laboratory reporting requirements and reanalysis processes, which is in violation of 935 CMR 500-450 subsection 3, as well as the corresponding medical site 935 CMR 501-450 subsection 3. The statutory requirement in General Laws, Chapter 94G, Section 15, subsection A, Clause 3, as well as Commission regulations contained in 935 CMR 500-160, subsection 4, Clause B, and subsection 13, Clause A, as well as the medical regulations 935 CMR 501-160, subsection 4, Clause B, and subsection 13, Clause A. And the fourth and final finding of the Commission is that the licensee's conduct posed a threat to the public health, safety, and welfare in violation of 935 CMR 500-450, subsection 15. Through this proposed agreement, we have stipulated 2 remedies, which I will now summarize for you. I would like to note that the parties have jointly agreed to resolve this matter through payment of a fine as well as affirmative relief and continued suspension, which are proposed for the board's consideration today. The terms and conditions are summarized as follows. The licensee has agreed to pay a $300,000 monetary penalty, which is payable in 3 installments over the course of 180 days. There will be the summary suspension order that was imposed on June 30th and effective July 4th will be lifted on September 15th, 2025, with an opportunity to lift the suspension earlier on or after August 21st, 2025, subject to the conditions identified in the stipulated agreement. There will be a 12-month suspension of the current owner and CEO. During that period of time, an interim CEO will be appointed, subject to the terms proposed in the agreement. There is also a 24-month probationary period for the licensee, during which time they will be subject to certain additional required reporting requirements. And in addition, Assured has also agreed to the following affirmative relief. First, they will cease all alleged non-compliant operations. Further, they will contract with an independent auditor who will be providing quarterly reports on certain testing information and data to the commission. They will submit revised SOPs to the commission. They will hire an internal quality control manager. Prior to the lifting of the suspension, they will also notify the commission of any personnel changes that they are effectuating during this time. During the probationary period, they will submit bi-weekly reports to the commission relative to certain testing data. And finally, they will also enroll their staff and management in continuing education, notably relative to ISO or International Standards Organization requirements that are imposed through regulation, as well as certain ethics trainings. So I would like to note at this point that the agreed to monetary penalty, I just want to clarify one piece. The quality control manager does not need to be hired prior to the lifting of the suspension, but according to the terms of the agreement, there is a period of time for them to hire, for the licensee to hire that internal quality control manager. So I would like to note at this time that the agreed to monetary penalty, if approved, will be deposited in the Marijuana Regulation Fund pursuant to General Laws, Chapter 94G, Section 14A. This fund is subject to appropriation by the legislature, and funds are used in part to fund the Commission and the Massachusetts Department of Agricultural Resources to implement and enforce applicable marijuana laws. But in addition to that funding, it also is used to fund public and behavioral health initiatives, public safety, municipal police training, funding the Prevention and Wellness Trust Fund, as well as programming for restorative justice, jail diversion, workforce development, industry-specific technical assistance, and mentoring services for economically disadvantaged persons in communities disproportionately harmed or impacted by high rates of arrest and incarceration for marijuana offenses. A further 15% of the Marijuana Regulation Fund is transferred to the Cannabis Social Equity Trust Fund, which is established by statute, and those funds are used to encourage full participation in the marijuana industry by entrepreneurs in communities disproportionately harmed by marijuana prohibition and enforcement. Before concluding and making myself and my colleagues available for any questions, I do want to specifically thank and recognize the efforts by folks within our organization that led to, that contributed to the underlying investigation, as well as the agreement that's before you today. So notably, I want to thank our Chief of Investigations and Enforcement, Noam Khaleesi Jones, Interim Director of Testing, Timothy Barwise, Investigations Manager, Ryan Basting, as well as Investigator Kerry Lewis, Laboratory and Testing Analyst, Cody Chandoa Lee, Project Coordinator, Juliana Kazuski, as well as members of my team, First Assistant Enforcement Counsel, Jacob Nielsen, Associate Enforcement Counsel, Tisa Chikwezi, and Enforcement Paralegal, Amanda Dupuy. I also want to take a moment to thank the other investigators, testing, enforcement, and IT and data teams that also contributed to this. It really is quite an extensive list of folks, so I apologize for not naming everybody specifically, but please know that you have my gratitude and appreciation for all the work you did on this. And I would also be remiss if I did not thank those members of the public who came forward to report certain observations to us through this process as well. So without that collaboration and support from the members of the public as well, the commission is not, those efforts really help the commission to effectively monitor and assure compliance of all licensees, not just in this particular instance. So with that, enforcement staff recommend ratification of this agreement as an appropriate resolution of the violations outlined before you. Taken as a whole, the agreed to fine, periods of suspension, as well as affirmative relief are intended to assure future compliance moving forward and represents and ought to represent a deterrence to future violations by this licensee and others in the industry who may consider or conduct matters in the same or similar manner. I will note that if additional actions are discovered or found by the commission too, we would take additional actions in those instances. Also, this agreement reinforces the commission's commitment to ensuring that marijuana sold to the public is safe and meets our required testing protocols, as well as upholding the obligations of our licensees to the public. Resolution of this matter is appropriate where a short has cooperated with the commission and has continued and has committed and agreed to operating within this heightened oversight. Thank you for your time and attention. I'm available to answer any questions, as well as First Assistant Enforcement Counsel Jacob Nielsen and Chief of Investigation Enforcement Noam Khaleesi Jones.
Thank you, Enforcement Counsel. I'm happy to recognize you, ED, or Chief Jones, if there's anything you want to add before we jump into questions.
I'll defer to Chief Jones if there is anything that you would like to add, but I'm ready for the Q&A from commissioners if she is.
Chief, if you have anything you'd like to add.
Yes, if I may, Acting Chair, I just want to echo what EC Gooden said here today. Just want to thank you, the team, for everyone that was involved and the collaboration from other departments related to this enforcement action or this matter that's before the board. We truly appreciate all the time that was dedicated and put into ensuring that we got to this point. So thank you so much.
Thank you, Chief. Happy to turn it over to my colleagues if they have any questions. Go ahead, Commissioner Roy.
Acting Chair, thank you, EC Gooden. Thank you for this presentation, and to the entire team that you mentioned, everyone involved to get it to this place before us today. My question is specifically in the document, number 59E. If I may ask the question around that, I'm going to read from the document. Respondent did not report the failing heavy metal result for at least one marijuana lab sample that produced a numerical value for arsenic that was above 200 parts per billion. So my question, and I don't know if you're able to provide this to us, what was the numerical value and what was the product type?
Enforcement Counsel.
Thank you, Acting Chair, and thank you, Commissioner. Commissioner, I do not have that information directly in front of me, but we would be happy to follow up with you on those specifics.
Okay, if I may, Acting Chair.
Go ahead.
Yeah, thank you, EC Gooden. I'd be highly curious to learn that information. And the reason I bring it up is because Massachusetts has some of the strictest testing protocols in the country, and we have rigorous testing standards around analytes, specifically heavy metals, and the big four are arsenic, lead, cadmium, and mercury. And the reason we have these is that it can be highly toxic, a carcinogen to folks. And there are health considerations. Cannabis plants can accumulate heavy metal from soil, water, fertilizers, even equipment during cultivation and processing. Health concerns, heavy metals contamination in cannabis products can pose serious health risks to consumers, especially when inhaled, which necessitates the need for rigorous testing. So my question, I would love to learn that information. What was the numerical value and what was the product type? Because it can be even more concerning if it's inhalation. And so also my other question is around the affirmative relief that I see they have ISO training, and will there be any specific training around heavy metals?
Enforcement Counsel.
Thank you, Acting Chair. Commissioner Roy, the relative to specific training on heavy metals, this ISO training is ISO auditor competency training. I cannot tell you specifically if that is going to cover heavy metals or the specific requirements in Massachusetts, but the regulations and testing protocols are clear in this matter, and we will ensure future compliance through our investigative efforts. Also, just relative to your question about specific details that are not contained within this proposed agreement, as well as the summary suspension order, I would also defer to the general counsel because this matter is still active and may result in further 30A action depending on the outcome of this matter today. So just to preserve the nature of the board as the final arbiters, I would defer to general counsel on any further advice relative to that.
Acting Chair, if I may.
GC, go ahead.
Thank you. And yes, just to reiterate what DC just said, I'm going to caution against asking questions that go into facts of the investigation that are not disclosed in the agreement for 30A reasons. So I'll leave it at that, but I do want to make sure that we are mindful of requirements under 30A.
Commissioner, go ahead.
I'm not sure if I'm able to ask this in light of that, but for the 544 products that were above the action limits, just because folks in the public are asking, what do we say to the public with those 544? What was the prescribed protocol for those products?
Yeah, same advice as I just previously gave. I'm going to ask the board and EC to keep questions and responses to information that is disclosed, already disclosed or contained in the agreement. Again, the issue here is pursuant to 30A. Should this agreement not be ratified, then the board will be called upon to adjudicate this matter. And so it is important that the board retain its impartiality and not be privy to information that's not already public.
Acting Chair.
Oh,
I'm sorry.
Enforcement Counsel and then Commissioner Roy.
I'm sorry, I'll defer. I believe Executive Director Ahern who was speaking up as well.
Thank you very much. And through the acting chair, I was actually going to ask EC with that feedback from GC, which I think is a good reminder for us all as well, that the 544 is certainly within the SSO. So if there was something sort of specific to that and information that we've shared, that there might be some information not restricted by 30A that could be shared specific to Commissioner Roy's question on the 544.
Yes, absolutely, and I can respond generally to your inquiry, Commissioner. And this also, calls back to the discussion earlier today relative to the Public Health Advisory Portal and the Public Health Advisory that was issued as well. So with respect to the, so in general, first off, I would just want to say that the Commission, as articulated previously, the Commission has developed that portal as a general resource. So it will be utilized for to identify products for past public health advisories, such as those issued in January or February of earlier this year, but also moving forward as a resource for the public. So in this instance, the Commission utilized our seed to sale tracking system to identify products that stemmed from those 544 failed test samples. I do want to note that this process was somewhat labor and time intensive, which goes toward that the difference in timing there. That labor and time intensive nature was due to the nature of the tracking system generally and how child packages are created and then tracked from the initial batch and test sample. So in essence, each test sample can result potentially in hundreds or potentially even thousands of child packages as they go through. So our team did a lot of work, particularly the data team, as well as members of our investigations team, to track those down so they can be identified on the Public Health Advisory portal. So once those packages were identified, particularly those that were being marketed or available to consumers, we noted them through that portal, and that, like I said, will be used for future advisories as well, or a similar sort of process. As well, concurrently, the agency has issued administrative holds to dispensing or retail licensees to halt the further sale of affected products.
Commissioner, are you okay? Do you have other questions?
No, that's very, very helpful. Thank you, ED, for flagging that. That was already publicly available. Thank you, EC Gooden, for explaining it to the public who might not have been aware. So I appreciate that.
Thank you. Commissioner Concepcion, do you have questions?
I don't have a question. I just had a comment because I did really want to recognize and acknowledge the team for the amount of work that went into this in such a short time frame. You know, just reading through the information, and in our meeting in preparation for the conversation, it was just really evident that there was a lot of work. So I just wanted to thank you all for everything that you guys have put into this to get it to this point. I had questions, but after going through our own review, I don't have any at this time because we were pretty thorough in the breakdown in terms of what's before us today. So thank you.
Thank you, Commissioner. Commissioner Roy, go ahead.
Thank you. I have a general question, not directly related to the stipulated agreement, just general question about our regulations. If a sample fails and they ask for it to be reanalyzed, it must be reanalyzed by the same ITL. And if it passes from that original ITL, then it needs to go to a second ITL. So my question is, with the 72 hours, the notification to the commission upon failure, who is that incumbent upon? Is it incumbent upon just the ITL, or is it incumbent upon the cultivator or product manufacturer as well to notify the commission within that time frame of the failure?
So Commissioner Tim, do you mind if I take this question?
Go ahead.
Sure. Thank you, Commissioner Roy, for that question. So it's actually both, Commissioner. The statute requires the reporting of any results of contamination within 72 hours, but then our regulations with respect to failing test results goes further than that and requires the notice to the commission to be both from the ITL and from the marijuana establishment that sent it. So it's a dual requirement.
Commissioner Roy, go ahead.
In light of that, and thank you, Attorney Nielsen, for that explanation, which I did know the answer, but it was for the public to hear as well. So I do appreciate that. So in light of current facts, I'm wondering if the commission should send a friendly reminder to our product manufacturers and our cultivators that it is also incumbent upon them to notify the commission upon an initial failure.
You directing that question to staff or ED or GC?
Yeah, well, whoever, anybody wants to take it. I don't want to do anything that would put in peril 30A. So I'm trying to be very mindful of that. What I'm just trying to get across is that we have, when there's, according to our regulations, it's incumbent upon the ITL as well as the product manufacturer or the cultivator to notify the commission within 72 hours of a failure. So I guess I'm just trying to stress that.
Sure. No, understood. ED.
Through the acting chair, and if it would please the board, certainly happy to look at that and determine sort of the last time that we've express those sentiments and look for an appropriate mechanism to do so at some point here in the future. I don't know, quite honestly, the answer to whether that needs to be done immediately, if we'll have other communications that we can build that into, but happy to look at that if that satisfies the question, or if there's follow-up, I can we can try to kind of come up with something else to review at the moment.
Commissioner, is that satisfactory?
Yeah, it is. Thank you, Executive Director. I appreciate that. Thank you very much.
Absolutely. Thank you for that point.
Thank you. Just a couple of quick questions, and I also want to compliment the staff, not only the investigative team that worked on this, but our data team, which I understand poured over lots of information. So appreciate that. Again, it always speaks to, you know, my awareness that not every investigation is the same. Enforcement counsel, as you were going through it, I'm not sure, I might have missed it, but touching on the suspension of the license for the CEO, could you talk a little bit more about the interim CEO stipulations in this agreement?
Thank you, Acting Chair. I can, summarize what is contained within the proposed agreement briefly here. So there will be a 12-month suspension of the current CEO, and there will be an appointment of an interim or potentially other permanent CEO during that time period. The interim or new CEO will be subject to regular registration requirements through our regulations, including potential suitability review, et cetera. The appointment must occur no later than 90 days after the license suspension is lifted. And during that time, the current CEO will not serve as CEO or retain any decision-making capacity or authority with the licensee. We have included one particular condition here to limit that interim CEO from being a relative of the current CEO or his spouse or domestic partner as applicable. And there will be, they will also be providing us with that individual's CV or resume as applicable as well.
Okay, just to follow up on that, in this potentially this intervening period before consideration of this stipulated agreement and an interim or new permanent CEO being hired, how do we operationalize this in terms of understanding who's running the organization? If again the previous CEO would be under that 12-month suspension.
Thank you, Acting Chair. And I through the appointment of an interim or new permanent CEO, that would follow our standard regulatory process, which has many controls on individuals, including those would be persons with direct or indirect control, in particular, which a CEO as somebody that can actually direct the company would fall under those definitions as well.
Okay. I'm again just trying to be mindful of if there is a gap in this intervening period, who has responsibility or who would be in that position and responsibility.
The agreement, Acting Chair, does allow a certain period of 90 days for that interim CEO to be appointed, and after that point, there will be the suspension for the current CEO would begin.
Okay. All right. Thank you. Any other questions for Enforcement Counsel or staff on the proposed stipulated agreement? Commissioner Concepcion, you look like you're pondering.
I am. It was based on that last response. I'm just wondering, we said that there's a 90-day time frame in which they have to name who that person will be. I guess I'm just wondering about, are we then sort of, what action is the commission taking? Are we reviewing that individual, so on and so forth? Just flesh that out a little bit more. I just want to make sure I'm solid in my understanding.
Enforcement
Thank you, Chair.
Counsel, go ahead.
Thank you. Thank you, Commissioner. So yes, we did incorporate a 90-day period in which the current CEO and the licensee can identify somebody who is qualified and suitable to serve in that interim or now permanent role. So we need to, or we wanted to, recognize the practical realities here, where this is an independent testing laboratory. This is a highly regulated industry, and we want to ensure that the work that is being performed is compliant and also benefits the public health, safety, and welfare. So just given all of those factors, rather than pushing or rushing for an immediate appointment, we did want to incorporate some time for them to find a suitable and appropriate individual. But again, to the point of our regulations do have a robust registration system, particularly for folks that are in positions of direct authority over licensees. So they will go through that process. Other than the specific notation that this person cannot be a direct relative, specifically within the 4th degree of consanguinity. So to decipher that slightly for the public, that essentially goes out to first cousins, up to great grandparents, etc. They will go through the regular registration and review process as an agent, and in particular as a person with direct control over the license. I hope that helps to answer.
Go ahead,
I believe so. And that's what so 90 days to identify the individual, and then the commission will do our review to determine suitability and appropriateness of that individual. Okay, thank you.
That is correct, yes. And it's the appointment must be no later than 90 days and registration. So just want to clarify that it ought to be done before that period of time, and we will be performing that review during that period.
All set, Commissioner Concepcion.
You know what, Attorney Gooden, you just said something at the tail end that made my antennas go up, because you said that within that period, because technically speaking, the way that it sounds is this process of having an interim person there extends beyond the 90 days. 90 days is only when we need to have a response of an individual identified, but then we have our process internally that can go beyond that 90-day time frame.
Yeah,
Enforcement Counsel, go ahead.
Thank you. And so I don't want to get too far into the technical details of it, because I know the licensing team does handle that process primarily too. But yes, generally, I think you're correct here, Commissioner. So we would follow that. I will say in the interim CEO will be serving, at least according to these terms, throughout the suspension of the current CEO, which will be 12 months beginning on the day that the interim CEO is appointed there.
Okay. And if I'm looking at the language correctly under 67, it does say the respondent appoints an interim or permanent CEO who shall be registered in accordance with the commission regulations, which in no case shall be later than 90 days. So it does sound through the language that the registration and the appointment all have to happen within that 90-day period. Okay. Commissioner Roy, you had your hand up.
I did. Thank you, Acting Chair. My question is not just for this stipulated agreement, but for the public listening, applies to all stipulated agreements that we have boilerplate language or safeguards, if you will. And I will read it. Any substantial non-compliance with this order or any commission laws by not just this respondent, any respondent, or any person having direct or indirect control of respondent shall constitute full and adequate grounds for further administrative or disciplinary action up to and including revocation of the license. And the reason I read this is because we've had many stipulated agreements, and it's important for the public and folks listening to know that we are monitoring these for compliance, and these safeguards are built in. And and I want to thank the team and Chief Jones for not only assessing a monetary penalty, but this affirmative relief, which in some ways can be more painful than the monetary side of the equation. So I want to thank them for this, but we put in language so that we are monitoring for substantial compliance, and it's important for folks to know that.
Thank you, Commissioner. Appreciate that. Any other questions from my colleagues? All right. Seeing none, I would entertain a motion to approve the stipulated agreement as recommended by Enforcement Counsel for Assured Testing Laboratories, LLC. Do I have such a motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy?
Second.
Motion made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye, 3 in favor, none opposed. Again, thanks to Enforcement Counsel and members of your team and the entire team that worked on this effort. Greatly appreciate that. Again, thank you for the good work. And again, as I'm reminded, I'll say this, proves to me again that no investigation is the same. All right. Commissioner Roy, go ahead.
Yeah, and just to wrap this up, thank you, Acting Chair. Will this be posted like other enforcement actions to the Commission's website?
I see Attorney Nielsen shaking his head, but Enforcement Counsel, do you want to confirm that, or did the head shake from Attorney Nielsen do that?
I don't know. He's off camera, so folks, perhaps a verbal.
Sorry.
Oops.
Mr. Acting Chair.
Go ahead, Edie.
I looked at this as well. Obviously, as soon as appropriate, we'll get this executed and up on the website for the public use. I've looked at the last few. It seems like about 3 business days is what we average. Not committing to that, but that will put us into probably early next week. Happy to keep the board updated as soon as that is available online. And I assume that we'll also be getting some questions about it. But ultimately, the answer is the stipulated agreement will be online, yes. Most likely early next week.
Thank you.
Okay. Thank you, Commissioner. All right. We'll move down to the next agenda items. These are under commission discussion and votes. We are talking about a tier relegation update. I'll invite Director Enos in to join us for this part of the conversation.
Thank you very much, Acting Chair. Good afternoon, Commissioners. Acting Chair, I just want to echo Commissioner Concepcion's previous sentiments. Congratulations on your reappointment. Very well deserved. Thank you. So last month, during my presentation about the tier relegations, the board came back with the request for some proposed motion language. So I want to give a big thank you to General Counsel who worked with me on that proposed motion language. So I can read it first and then happy to throw it in the chat. I will just state the motion language has 2 placeholders for time components. That will be for the board's discretion, but as we previously talked last month, giving some time obviously to notify licensees and then giving time for obviously our staff to build that up. So I'll read the motion language first and then can drop it in the chat. So the proposed language would be the motion to direct investigations and enforcement to begin enforcement of 935 CMR 500-050-2D and E and 935 CMR 501-050-2D and E with respect to tier relegations within X days after providing notice to licensees of this change in policy, at least Y days before the change takes effect. Some other pieces of information for the board's consideration regarding those time elements is Director Koval and I confirmed with JD Software they'll need 2 weeks on their end to implement their changes, for this process if the board wants to go that direction. So that was good to hear that we're not going to need that much lead up time for JD Software. But obviously to notify our licensees and obviously to prepare our staff for beginning these at renewal, we would need some additional time. So let me put this motion language in the chat so the board can see. I'll just give everyone a second if they want to review what I just put in the chat. And let me add, my discussions with General Counsel, the intent of kind of leaving this language more open-ended was the thought process is that would allow investigations and enforcement through the issuance of any future bulletins or additional guidance documents to kind of potentially fill in the gaps there. Yes, Commissioner Roy?
Thank you, Director Enos. My question is around the second placeholder, X days after providing notice. So you're looking for a ramp, like a ramp up to this. So do you have a recommendation to us? Is like 30-day ramp up, 60-day ramp up? Do you have a recommendation to the board?
I would defer to General Counsel, Chief Jones, and my other directors. From my perspective, at a minimum, we would need 2 months. But ideally, if you could give us maybe 3 months, that would put us in a better position. But I think 2 months at a minimum would be what we were looking for. Because obviously, once we get these processes updated with JD Software, there's going to be some internal training that we're going to need for our staff, obviously, to make sure they're ready to do these at renewal. Obviously with the other matters that are currently ongoing with the commission, a minimum of 2 months, I believe, would be needed there. But obviously, more time could be obviously a better utility. And I see Chief Jones has joined, so.
Chief, welcome. Go ahead and offer your thoughts.
Yeah, thank you, Acting Chair. Yeah, I think we need more than 2 months because I'm also thinking of other things too that are in addition to the training, even with our third-party vendor, we need to be able to give them time to ensure that they make certain configurations and things like that. So for if you could please just give us a little bit more time, more than 2 months, maybe 3 to 4 months, something like that, because we just want to make sure that we have certain things in place as adequately as possible so that we do not, encounter hiccups. And I'm not so sure if the CTIO is available here too. I think it would be helpful as well because we need to coordinate definitely with our third-party vendor as well on this front.
Yeah, I am here.
CTIO, you want to add anything? And then we'll
yes,
get back to questions.
Thank you. And also congratulations as well. I did put a quick comment in the chat. So the 2 weeks is literally their minimum amount of coding time that JD would need to write the code. We have a whole process that would need to be going into testing, test that, and then they would have to put that into production, which usually takes some downtime. So it's probably more realistically a 4-week from when we say go, and that would mean prioritizing this over other work that they're currently working on. Or from whatever the time slot is. So, 2 months would be an absolute bare minimum, in my opinion. I think 3 to 4 months in alignment with our Chief Investigation Enforcement time frame would be my recommendation.
All right. Thank you, CTIO. Commissioner Roy, go ahead.
Thank you. And that's why I asked for this feedback, because there's all these moving parts in the background that we're unaware of and that you need time. So I'm just wondering if you think 4 months makes sense, and does it make sense just to start it with the flip of the calendar, January 1, or is that too much of a ramp? And I know renewals happen all year around, so it's not really for that purpose, but I'm just throwing that out there. That would give you, I mean, we're, you know, just about in the middle of August. So maybe with a flip of the calendar, I don't know. I'm just throwing it out there. Sounds like 4 months would be what you kind of need to get everything in place.
Yeah, thank you, Commissioner Roy. As I was hearing the discussion, I was kind of looking at 4 months and where we might find ourselves in the calendar that, you know, possibly flipping into the new year might give everybody enough time. Also give our licensees enough time to understand, as well as, you know, we definitely have seen the opportunity, and I think some of that has been generated by our discussion over the past several meetings about this topic, that licensees are coming forward and making the decision to self-relegate down. Obviously, I hope they're intending to do that to, one, not only stay in compliance, but obviously there's also the benefit of, you know, a lower license fee at renewal time, that they may be trying to save themselves some money at the same time. But, you know, to pick up on that suggestion, Commissioner, Director Enos or Chief Jones, you know, do you have any thoughts or feedback to the suggestion of, you know, kicking this off on January 1?
Yeah, if I may, Acting Chair. So yeah, so January 1st would work out, and if at all, let's say by the December meeting, if we, you know, there's any updates that we need to give to the board related to all the steps that we're taking, if it turns out that we need more time, we'll be able to also update the board through the executive director in terms of how that's going, just in case if we did need more time. But January 1st does make sense. And then it would provide everybody time, not just internally, but also externally as well, to figure out, you know, to make that transition or make the adjustments. And also, too, if we need to draft some guidance documents or FAQs or anything related to this transition, that would give us time to be able to do that without having to rush it.
Commissioner Roy, go ahead.
And thank you. And before we vote, if I just may read the regulation, because last time we discussed, the first time we discussed tier relegation, folks that are, some of our indoor cultivators got a little nervous and they reached out to me. So I just want to read, because they're assessed differently. And I think it's, but before we vote, if I may just read from that. Tier relegation in connection with the license renewal process for marijuana cultivators. The commission will review the records of the marijuana cultivator during the 6 months prior to the application for renewal for an indoor cultivator, or during the harvest season prior to the application for renewal for an outdoor cultivator. The commission may reduce the licensee's maximum canopy to a lower tier if the licensee sold less than 70% of what is produced during the 6 months prior to the application for renewal for an indoor cultivator, or during the harvest season prior to the application for renewal for outdoor cultivator. I misspoke, it was outdoor cultivators that reached out to me. So I just wanted to get that on the record. It's assessed differently for outdoor cultivators. It's based on the harvest season. So I don't want folks to go into panic mode.
No, good point. Thank you, Commissioner. It's an important distinction for us to make. Thank you for bringing that point up. I guess, you know, another question, I want to go back and I want to thank our team for working on this issue. I know this started off with conversations with our Director of Licensing, and Director Enos, you have not only picked up the topic, but also done an extensive amount of homework with respect to what other jurisdictions do. And as you and I kind of engaged in those conversations, and I guess this is kind of the next policy question for us to think about. And Commissioner, you just reminded, you know, we may relegate down. I have an interest in kind of taking a little bit of the guesswork out of it, perhaps for our investigations and enforcement team. I think, Director Enos, when you and I were talking, some consideration around if you get relegated, and I think you saw this in the information you pulled from the other states, that folks automatically get relegated to the next tier down. So there isn't maybe what's in, you know, from the language in the statute or language in the regs, sorry. You know, for us to decide, okay, you're at a tier 10, we're going to relegate you down to a tier 4. I'm not quite sure how that process would take place, what factors you would consider to make kind of a jump like that. So I'd love to entertain some conversation or some thoughts about how, if, and maybe we can't do it because of what the regs say, or maybe what the regs are quiet on, but allowing that kind of interpretation, that if we find you need to be relegated down, we will drop you by a tier in subsequent reviews if we still see that you're not meeting the requirements, to kind of help the industry a little bit, and also help investigations enforcement staff to kind of have a clear path. Is that if we decide you need to be relegated down, we only relegate you down to the tier right below. So Director Enos, I throw that out for you, or Chief, if you want to offer your thoughts too.
Sure, Acting Chair. No, thank you for that. Yes, ultimately, I feel like that would be for the board to ultimately make that determination based off the current tier factors. As I stated during the last public meeting, when we were initially talking about that, I think the pathway you just outlined would give us the most clear way to do it, avoid being arbitrary. I could envision some challenges trying to drop down potential number of tiers, especially at the time of renewal for this. So I think just dropping that down by one tier at a time, I see the benefit and utility to that. But ultimately, this would be, for you and the other commissioners to pretty much, direct us on, that determination based off our current tier factors.
Okay, thank you, Director. Chief, do you have any thoughts on this?
If I may, Acting Chair, but I would also like to, mention that I would also like to defer to the legal department as far as advisement on the interpretation. But however, what we're envisioning is that the requirements of those tier factors is something that would bring to the board during renewal. And based on those factors and on the information provided to the board, then the board will make a determination of where they would fall. And there could be possibilities that through the metric audits, that at times it might be a situation where they have to go, it's not just a matter of automatically going down to the next tier. It might be, going down 2 more tiers and all that stuff. But I think the relevant information that we'll be providing to the board based on sales and whichever information that we've retrieved through, our metric audits and all that, it will help the board to make that determination, so that you would have something that you can be able to rely on based on the requirements that are prescribed in the regulations. So I'm not so sure if the GC has anything else that he wants to add to this, but I defer to him as well related to the interpretation of that specific reg.
Go ahead, GC.
Thank you, Acting Chair. I'll just say that, and I think Director Enos alluded to this during his presentation, the motion language here was drafted in such a way to allow for INE to subsequently issue some additional guidance on the approach, which obviously they would do in conjunction with the board's approach on this topic. So that I'll just leave it at this language here is not meant to be overly prescriptive. It is meant to allow for further guidance to be issued subsequent to any vote, and obviously to effectuate the intent of the board.
Okay, I appreciate that, and Chief, if I can, thank you for again reminding us of how you envision the process at renewal time. I was remiss in considering that in terms of what information we would see from you and your team at time of renewal. Again, we're kind of venturing into, I don't want to say, this is new considerations for us to have around this topic. I think there are some other ancillary issues that when we think about this topic that at some point in the future I'll want to bring up for discussion. Like somebody gets relegated down, then all of a sudden they want to expand, and that's a good thing. You know, how do we treat them as they want to go back, potentially back up? I think we need to consider that scenario as well. GC, when it comes to the motion, which talked about a number of days, and hearing from some of our discussion the fact that, you know, we might have consensus with respect to when a date might be to start this. Is there an opportunity to kind of recraft the motion to peg January 1st is, you know, 2026 is the date this will take effect, so that we don't have the 30 or 60, 90-day conversation in here? But again, I got to circle back here with my colleagues and see if there's consensus on whether the flip of the calendar is a good time to start this. But
if I may, I can share.
Yes.
To your question, yes. You know, I think substituting a date where the within X days falls right now in that proposed language is a perfectly acceptable and workable solution. So no issues there.
Okay, I'm sorry, I missed that part. Can you reiterate that?
Yeah, I was just saying, as the language now reads, so it says, you know, to begin enforcement with respect to tier relegation within blank days. I think you can take that within blank days out and insert starting January 1, 2026 after providing, and then you can insert the amount of notice that the board decides would be appropriate before the change takes effect.
Okay. Commissioners, Commissioner Concepcion and Commissioner Roy, I know you brought up this suggestion, but Commissioner Concepcion, any thoughts or comments or concerns about suggesting we insert a date of January 1st, 2026, as opposed to just considering time required, as we've heard here from our team?
It was helpful hearing, and thank you for calling on me. I can't wave my hand, so I appreciate this. I have to be off camera for a second. Because I was thinking through Chief Jones and her questions with the ED as well. I'm not opposed to the January 2026 timeframe. I had a question for Director Enos, though, because I know the last time we brought up this conversation, Director, you gave us a breakdown of sort of what other jurisdictions were doing, and I wanted to know if this language was pulled or is similar to one of the other jurisdictions that you highlighted in the last conversation.
Oh, thank you, Commissioner Concepcion. I'm going to defer to General Counsel on that. I worked with him on this. But again, he was kind of the driving force for the drafting of this initial language. So I would defer to GC regarding the origination of this language.
Okay.
General Counsel.
Thank you, Acting Chair. In response to the question, Commissioner Concepcion, what we did is we looked at and in discussion with Director Enos, what was the intent and what the team was trying to accomplish with this vote. So we didn't look at motion language from other states in coming up with our proposed language here. It was really focused on what are they trying to accomplish, and how do we get to that point. So that was really the focus in crafting this language.
I see. Okay. I was curious about that. Okay, thank you. Thank you.
Commissioner Roy, go ahead.
So I think we've all settled on the January 1 part. I think the question is, how much notice do we formally provide? And
Right.
so I don't know if there's precedent that's happened where we've provided notice, and is it 60 days? I don't know. So perhaps there's precedent here, and we can kind of look to that.
I would look to the enforcement team about whether they have any suggestions based on past practice. I'm thinking through this in my head because I'm also thinking, Chief, to your point about at some point providing the commission an update as to whether we had all systems ready to go to effectuate a January 1st date. You mentioned the opportunity might come in November, might come in December. So I'm weighing all that in terms of trying to answer the suggestion that Commissioner Roy has. But go ahead, Chief Jones, if you have any thoughts.
Thank you, Acting Chair. I think let's treat it the same way we did with administrative orders. I think that's the only example that comes to mind in terms when we're making changes and all that. We did provide them at some point we did 60 days. And at some point I think we did the 4 months. So it all depends. So I think we can utilize to figure out what we need to do here. That way it would give them ample notice in terms of, the next steps that we'll be taking related to tier relegation.
Okay. That's helpful. Thank you, Chief Jones. Commissioner Roy, do you have any thoughts after hearing that?
Yeah, no, thank you. That's super helpful. So I think what I'm hearing is it would take effect January 1, 2026, and we will provide licensees 60 days. I mean, technically this could be, one could argue this today could serve as a notice. One could argue that, but officially 60 days notice. So that's what I'm hearing, where we've landed.
I think that was just what 60 days was what Chief Jones had shared with us as past practice with respect to administrative bulletins.
Okay.
Commissioner,
Thank
go ahead.
you.
I was just about to call on you.
Okay, thank you. I just wanted to make sure I heard Chief Jones correctly in one of her comments. Was 60 days too limiting? Was that, I think you said something about the 2-month timeline not being adequate.
If I
Go
may,
ahead, Chief.
if I'm acting chair. Yeah, so I think the idea will be to give them, give the licensees prior to the January 1st date, is to provide them with some type of a notice through a bulletin 60 days before, and then also in December, or will be coming before the board, or it could be, we could also do monthly updates. That's another thing through the executive director. I don't know how the board feels about that, just to give you updates on how things are going. And then if we need to tweak or amend in terms of, what the notice should look like, I think maybe we can possibly do it that way. We need to be fluid because at this time we don't know what are the, how this would look like. But I feel as though whatever the effectuation date is, if it's January 1st or whether it's February 1st, we still need to provide them with 60 days notice in terms of, what the commission will be doing moving forward related to renewals. So I guess in this case, which will be what, November 2nd? Yeah, I think around that November 2nd, then we'll provide them, the 60 days notice related to this topic.
Commissioner Concepcion, did you have any follow-up after that?
That was helpful because I think what I heard that 60 days, it was not for this component. So thank you, Chief Jones. That helps me in my understanding.
Okay.
You're welcome.
Director Enos, go ahead. Your thoughts.
Oh, no, thank you, Acting Chair. No, fully in agreement with Chief Jones. So I just updated the motion language based on the conversation. So I just kind of wanted to read it in and then I can send it through the chat. So based on our discussion, the motion language will now read, motion to direct investigations and enforcement staff to begin enforcement of 935 CMR 500-050 2D&E and 501-050 2D&E with respect to tier relegation beginning January 1st, 2026, after providing notice to licensees of this change in policy at least 60 days before the change takes effect.
Thank you. Director, why don't you go ahead and drop that in the chat if you'd like.
Absolutely.
Here's a question, and again, Chief and Director, I'd welcome your this. Do you consider this is equal a lift is some of the other administrative bulletins that you've put out? I mean, is tier relegation such an important consideration that we should allow more time? I mean, how do you stack them up again? I'm reflecting what Commissioner Concepcion offered too, that is 60 the right, or should we offer, because of just the importance of this topic, because people have been talking about this for a while, that maybe we afford a little bit more time and bump it out to 90 days? Chief, go ahead.
Yeah, I think 60 days is adequate. I mean, this is already a regulatory requirement that already exists within our regs.
Right.
The thing is, it's just an adaptation thing, transitioning to that, because in the past, for all our renewals, we haven't had tier relegation has not been it is not something that has been factored into those discussions. So I think 60 days, is adequate for us to put the bulletin together. And then also too, I just something just dawned on me as I'm reflecting upon, some of that we experienced in the past. When we do release the bulletin or provide the notice, typically what would happen is that they will come up with questions. So that would help inform if we need to then have a frequently asked questions FAQ or have some additional guidance prior to January 1st. So I think this will all fall in place based on what I've seen in the past. So this is the way to go in terms of the 60 days, not 90 days. I don't think they need 90 days, they need 60 days. And also to additionally, through this public meeting and past discussions, I'm sure the industry at this point is in this topic.
Okay, thank you for that, Chief. Yeah, again, I would hang on just CTAO before I lose my thought, but I'll go to you. I do want to make sure that whatever we communicate out to the industry, it's not only speaking to, this is being now drawn into consideration at your time of renewal, but to, again, remind licensees, as we've already seen in a handful of cases, folks are voluntarily choosing to relegate down, and reinforcing, or again, restating that option is available to somebody. As we've heard, it saves them some money, and it may help them realize, where exactly their little sweet spot in their business is at a certain canopy. But CTIO, go ahead.
Sure, thank you. I just wanted to add one little piece of context I think was being missed, is that this is a little bit different than some of the other administrative orders which required the licensees to take specific actions, either programming to do the COA uploads or other activities. This is a little lesser. I think it's more on the commission side. So I think the 60 days makes sense, unless there's something I'm missing for Chief Jones' side, that the licensees could take some action where they would want a little bit more time to increase their production. But I think the numbers, the other component too I want to point out is some of the stuff on the workload is during this time period, we'd also be working with Metric and our data team on producing some automated reports to be able to do that analysis much more quickly. So my goal, this would not take a lot of manual effort to perform pull the data together. I certainly would set that as a goal of this project.
Challenge between pulling the data and actually understanding the data, right? There we go. Okay. Chief Jones, go ahead.
Yeah, so the other thing we need to keep in mind is that now the RFIs might look vastly different for renewals, and like before, we'll be asking for certain documentation that would help the staff to be able to make certain recommendations to the board, or to be able to present before the board. That's also part of it. That is part of the adjustment as well.
Absolutely. And Chief, I would suggest that, and this might fall under future ED and staff reports, that updates as to how you're preparing for this. I think, as you suggested, that at future public meetings, we get a quick update as to where you are and being able to effectuate this.
Yes, Acting Chair. We'll do so.
All right. To my colleagues, any questions about the motion that's been proposed with a definitive date of January 1st, 2020? A notice to licensees of this change in policy at least, 60 days out.
He should hit a blunt. I prefer cigars personally.
Acting Chair, I see Commissioner Roy's hand.
Sorry. Go ahead, Commissioner. I couldn't see it.
Take your time. I'll talk long, that way you can drink water. I gotta
Thank you.
throat drop. Poor thing, that's happened to me. My question is not so much the motion language, but the process of commissioners. And I think you guys touched on it, and you don't even have to answer today. But in our board books, we get executive summaries on the provisional licenses, which I read, and then we get like this spreadsheet for renewals. And so I'm wondering what that would look like in the board book. So we're aware when before we vote on a renewal that they have been relegated. And if you don't have an answer today, that's fine. I just, how do you get that information to us before public meetings? We have time to process it before we vote on an actual renewal.
Acting Chair. Oh, sorry, just before
Chief with their hand up first. Sorry.
Go
ahead, Chief.
No, that's fine.
Thank you, Acting Chair. So Commissioner Roy, because the board will be doing the relegation based on the documentation that we'll be providing to the board. So
Yes.
Part of the process now is that would ensure that any and all materials that the board needs to have in front of them in order for you all to make that determination, will be part of their board effect. And so we will work with the executive director and, Director John Call in terms of, ironing out that process because this will be the additional materials that we now need to add for the renewal processes. So that's the idea right now, which is why we also need sort of some time to develop internally to develop that process, and also develop our SOPs related to this. And
Go ahead, Commissioner, if you had any follow-up.
Yeah, Chief, that's really helpful. And I guess in the future, just thinking ahead, like I don't have the historical context of where they came up with the number for expansion 85% or relegation 75%. Maybe they got that from another jurisdiction, the original commissioners. I don't know the historical context, but I guess what would be helpful is we look for trends. So are people selling only 60% of their inventory, 50%? Like we'll look for quantification of how much of the 70% did they sell, moving forward. That would be helpful because maybe we have to tweak those numbers down the road, the 70 and the 85%, you see? So just having more data will help inform us in the long run moving forward on that.
It's a good point. Commissioner, Chief Jones, sorry.
Right, as part of, we already, because remember, this process exists in a way through the voluntary tier relegations expansions already. So what we have in that report is some of that data, right? We talk about the cells and everything else. And I think then what would happen, as you mentioned, is that once you have that information and you're seeing all the trends, then it'll be up to the boards, up to the board to contemplate or decide how they want this to look moving forward. Do you want to then do a regulatory amendment to change it from the current numbers that we have, or do you want to keep it as is? So that will be helpful to the board. And as you're seeing the information and you're seeing the data as we're presenting it to you through the public meetings related to tier relegations, then you'll be able to make informed decisions on how you want to move or address this moving forward.
That's helpful. Thank you.
Yeah, it's a good question, Commissioner, and appreciate your thoughts, Chief. is we look at how we do renewals now, right? We do them as a slate. Sometimes we pull somebody out if there's a condition we want to attach to their renewal. I certainly could see that kind of separation in renewals, like who's coming through that doesn't have a tier relegation. And obviously we're only talking about cultivators here, but they'd be, potentially a second grouping of renewals that we'd have to obviously walk through a little more carefully, especially considering a recommendation to relegate them down if that's included. Commissioners, any other thoughts before I seek a motion? Okay.
Acting Chair, if you don't mind, I just wanted to add one thing. I think that Chief Jones covered my response, and I think that was an excellent discussion with Commissioner Roy and yourself, kind of summarizing the process moving here, where this is now being added to the renewal process as we move forward, and on the timeline that you would approve. I just want to highlight again, because I think it came up earlier, the last update under ED report on self-identified tier relegation was at the May 8th meeting, where we had 2 that were reported that were self-identified by those cultivators, requested and approved by the ED, and then we reported those out at that public meeting. One was an indoor tier 11 that relegated to tier 2. One was an outdoor tier 6 that relegated to tier 2. So obviously, again, within all this process as well, we'll continue to make sure that the information on self-identified requests to tier relegate are also part of the information being shared with the board for your consideration. So I just wanted to highlight that was the May 8th, 25 meeting when we gave that update last.
All right. Thank you for that. And again, as we kind of move forward with this process, the opportunity to encourage a licensee to be that proactive if they so choose, based on what they see in their business. They can take that step. They're certainly allowed to take that step. Obviously, it saves them some money at license renewal time too. But as long as we can continue to communicate out to cultivators that option is available to them too, if they want to seek it, as those other 2 that you reported on did. If there's no other discussion, I would seek a motion to direct investigations and enforcement staff to begin enforcement of 935 CMR 500.0502D and E and 501.0502D and E with respect to tier relegation beginning January 1st, 2026, after providing notice to licensees of this change in policy at least 60 days before the changes take effect. Do I have such a motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy?
Second.
Okay, motion made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye. 3 in favor, none opposed. Thank you, Director Enos. Thank you, Chief Jones. Thank you, Director Coble and the INE team for your thoughtful in continued work on this topic. So greatly appreciate it.
No, thank you very much, everyone. Thank you.
Okay, GC back in to join us. General Counsel.
Yes, thank you, Madam Chair. Good afternoon. Could I actually request a 5-minute recess before we start?
Hello.
Certainly.
All right. Well,
perfect.
You know what's
All
useful?
right,
we were about 5 minutes behind. How convenient is that? We skipped the whole recess. I'm a towel. I'm a little towel. I'm a little towel. All right.
That's okay.
You good? Here we go.
I had word you were back, but just needed to confirm. Okay, and Commissioner Roy, you're back. So the next item on the agenda is legal intervention discussion. I'll hand it over to the GC, but certainly understand that if we didn't have it scheduled for today, but if there were any talks with respect to legal strategy, is probably something that we would need to convene an executive session for. But short of that, I think with the GC's presentation, that may not be necessary, but I will hand it over to the general counsel.
Thank you, Acting Chair, and good afternoon to everyone, commissioners. As you'll recall, a number of months ago, I had brought to the board, and we had discussed as a policy matter the merits of whether the commissions should seek to intervene in legal cases which presented issues relating to HCA compliance and challenges to the commission's authority to review and approve HCAs. And when I say HCAs, I mean host community agreements. And as part of that discussion, the board had voted as a matter of policy to entertain intervention in those matters, or in a particular matter. And as part of the vote at that time, the request was for me to come back and provide updates on the case. So this is partly as an update and partly as a sort of a follow-up to that initial, the policy vote that was taken earlier. So I wanted to first give an update on the status of our legal intervention in the Theory Wellness versus Great Barrington matter. You may know that we did consult with the AG's office on this and then filed a motion to intervene, which was heard recently, and the judge in the case heard the plaintiff's motion for judgment on the pleadings, as well as a motion to dismiss, together with our motion to intervene at the same time. The judge recently issued a decision in the matter in which he denied the plaintiff's motion for judgment on the pleadings, as well as a motion to dismiss the town's counterclaims, but at the same time did not take any action with respect to our motion to intervene. So he specifically highlighted or went on to say that he was not considering our motion and that he may consider it at a later time, should the case proceed and the motion be ripe for review later on down the road. That obviously is not the result that we were looking for and doesn't help us in getting clarity on the HCA compliance issue that the case has presented. And just by way of backdrop, a number of towns have taken the position that the Chapter 180 amendments do not apply to HCAs that were executed before the effective date of the amendments. And so there are a number of cases now pending that present that issue, and this issue has put many of our licensees in a legal limbo as they try to negotiate and work toward getting their licenses renewed, which requires our licensing division to review their applications, their renewal applications, and certify that their HCAs are compliant with the statute. So in any event, the decision was not affirmative or a denial one way or the other. So we're now in this position where we didn't get some more guidance that we were hoping to get through this case, and the case will now proceed to the discovery process and then ultimately to trial if the parties don't settle by then, which, as you know, can take quite a long time, and a matter of months or even years before a trial is reached and a trial is completed. So what we don't have, unfortunately, is the luxury of time. We have a number of licensees who are maxing out on their current 600 days of administrative extensions that the board has approved, and by informal count, in conjunction with the licensing division, there are 16 different licensees some of them have multiple licenses who are coming up for, they're bumping up against that 600-day extension maximum between later in this year and the first part of 2026. So unfortunately, just given the way the theory on this matter has played out, that is not going to solve our problem and give us the clarity that we were hoping for. So what I'd like to do is, at this point, just given the fact that we have numerous licensees that are approaching this administrative extension maximum, and that number will continue to grow as we proceed and get further into 26. I'd like to explore with the board here now with you all some more flexibility with respect to these matters. As we did last time, I presented the matter to you, and we had a policy discussion about it. The board did vote to authorize my actions in that particular case to seek to intervene, but the framework, if you will, of having to come back and seek approval on each and every situation that we might decide to seek to intervene is, just given the cadence of our meetings, not going to be in our best interest as we try to get some resolution from the courts on this matter. So what I would like to propose and suggest for the board's consideration is that, since we have established as a matter of policy that the board has decided that it is in the commission's interest to intervene in matters that present issues with respect to HCA compliance and with respect to our statutory authority, rather than coming back sort of individually or as cases come up. I'd like to seek a broader flexibility in terms of working with the Attorney General's office to identify cases that present the same issues with respect to HCA compliance, and take the appropriate action so that we can try to get that clarity from the courts in a time frame that will hopefully benefit some of the licensees that are stuck in this this legal quagmire right now, and just frankly to get clarity on the issue so that we as a commission can act accordingly, knowing what what the ultimate ruling is on with respect to Chapter 180's applicability. So I'll leave it at that and then turn it over to the board for questions and discussion.
Thank you, GC. Commissioner Concepcion.
Thank you, and thank you, GC. I had a question. Do we have an idea? I know that this will change, but currently, do we have an idea of the volume of cases that are currently pending that have the same issue?
Good, very good question. We are looking at the dockets. I'll say that there are at least a dozen municipalities that are involved in litigation on this issue. I couldn't give you an exact number of the cases off the top of my head, but we are, as a legal team, looking at all the cases that are pending, and we'll look at, we'll decide where it makes sense for us to intervene should the board allow that.
Okay, thank you.
Commissioner Roy, go ahead.
Thank you, General Counsel. I don't know if I'm 100% comfortable with broad language for your team to intervene without informing the commissioners. The first time, and we did discuss this publicly, like I read about it in the news clips that we had done that. And I was like, what's happening here? We weren't informed until after the fact. So is there a way we can have one-on-ones? I just think I would like to be aware of what's out there. And I think we in our meeting yesterday, we kind of discussed different options where we would get a memo or something about what cases are on the docket. I know a few off the top of mind, but I think we see it form now. Whether that's because of the cadence of public meeting, that's not feasible. But there are other ways to inform us as well. So I just feel better if we bake in a little bit of language where we still get informed prior to. It doesn't necessarily have to be at public meeting. And I understand your point, right? Because time could be of the essence, and sometimes we have one meeting a month, depending. It seems like we're more in the cadence of 2 meetings a month, but I still think there is a mechanism to inform us.
Thank you, thank you, Commissioner. You know, and to that point, it's a good one, and I certainly hear GC, your interest in the flexibility, and Commissioner Roy, here your point. I think to kind of smooth those concerns about cases and issues, I think that's easily solvable in terms of either the GC being in touch with each of us, or or through the ED. But to just kind of go back and recap the process for intervening in the first case, right? We had to go through the Attorney General's office. They had to get a sense of why we were intervening in that case, what arguments we were hoping to make. It's my understanding we still have to go back through the AGO, but in terms of the arguments we're trying to make, they're pretty consistent. They're pretty similar. I mean, we're trying to make the same argument and get a judge to make some type of declaratory judgment on with respect to our intervention. So in terms of what we're arguing, I don't think that has changed, but I think Commissioner Roy brings up a good point of, I think it's pretty easy for you or through the ED to just kind of notify each of us, when we're deciding in what case we're planning to intervene. But sorry, go ahead, GC, and then ED, if there's anything you want to
add. Thank you, Acting Chair. And I was going to suggest that we build in a regular reporting requirement, if you will, or a regular notice, and happy to do that on whatever cadence is, the board requests. I do just, want to caution that, to the extent that notice, you're looking for notice, before an action is taken, time is of the essence here, and I don't want to hamstring not only the Commission's position with respect to these cases, but also the difficult position that many of our licensees are in. So that is really that's driving the request here, is not since the result in this first case didn't go where we were hoping, at least not yet, and is not going to give us the clarity. I think the desire here is to broaden our approach and to look at some more cases that hopefully will present an opportunity to get a quicker answer. So trying to balance the board's need here with the legal department's need as well to act quickly where appropriate.
And just a second, Commissioner Roy, I think it's more not about taking the steps to give approval, but more to notification. Again, if we're looking at the legal arguments are pretty much the same. It's really just getting a heads up as to what cases you've picked out for us to intervene in, and then just notifying each of us. Commissioner Roy, and then to the ED.
Thank you. I just have a question on the process, and I know the AGO's office is involved. So you generally need the approval of the AGO before you can file the motion intervene, correct?
That is correct, yes.
So I'm wondering, in that window, I don't know what that turnaround time is. So we can't just run to court. We need the approval from the AGO. So I'm wondering, there's your window for the notification.
GC, go ahead.
Yeah, I was going to defer to Edie. I know you'd recognized him before me, so happy to wait.
Okay. Executive Director, go ahead.
No, I think that was, thank you, Mr. Acting Chair. I think that was basically going to be my point. I'm not overly concerned that we are not going to be able to get information in a reasonable timeline to update the commissioners if they're comfortable that the GC's office is prioritizing this for clarity for us in the industry, that we'd be working with the AGO, and that certainly I can work with the GC's office to ensure that you're informed as timely as possible. I think that obviously, to the GC's point, that should be worded carefully, but it's certainly the intent that I would have. So I think that ties together the conversation nicely from where I'm sitting.
Commissioner Roy, go ahead.
Yes, thank you. And thank you, Executive Director. And the reason I'm advocating for this is because it has broader implications. We get emails from stakeholders all the time, from licensees, from attorneys. And, you know, so it's important for us to know, so we don't make any missteps. If there is, you know, we're filing a motion to intervene here. So that's like the broader implication of why we need to know as well.
Good point. Thank you, Commissioner. Commissioner Concepcion, did you have? You look like you were going to lean on.
No, Kajal, General Counsel, I completely understand the request here. I'm in agreement with it. I'm sure we will be notified. I agree with us being notified, but not necessarily opining, because I don't want us to slow down anything that needs to happen in a timely fashion. But this makes sense. I like this direction because I agree with you. It makes sense for us to have more opportunities to get some sort of opinion from the courts. So I'm behind this completely. Thank you.
And I thank you, Commissioner. And I would just add to that. Obviously, we've been through the experience once. It's not that we didn't get the result we wanted. We just didn't get in this case, you know, definitive judgment as to what our request was. So if I can propose a motion, and I'll read it and drop it in the chat for my colleagues to look at, I'd move to direct the General Counsel in consultation with the Attorney General's office to take all steps necessary to identify and intervene in court cases involving licensees and municipalities which present issues relating to the Commission's statutory authority and oversight over host community agreements and community impact fees, and provide timely notifications to the commissioners. Questions on that? Commissioner Roy, if you want to take a look at that, if that is written to your satisfaction for your concerns.
I just have a question. Should it say in consultation with the Executive Director and the like the Executive Director signs off, right?
ED or GC, we can plug that in. I'm sure the GC would not want to risk his employment by doing something without his boss's notification, but we can add that in there.
If I may, I thank you for that.
I'm comfortable with that addition, certainly.
All right. All right. Any other questions? I can plug that in and I'll reread the motion. But any comments or questions? Seeing none, I would seek a motion to direct the General Counsel in consultation with the Executive Director and the Attorney General's office to take all steps necessary to identify and intervene in court cases involving licensees and municipalities which present issues relating to the Commission's statutory authority and oversight over host community agreements and community impact fees, and provide timely notifications to the commissioners. Do I have such a motion, Commissioner Roy?
Before I answer,
Yeah.
so anything out of that scope has to come before the board. So the scope is host community agreements and community impact fees. So anything out of that scope would come before us, correct?
That's my understanding. GC? You're on mute.
Sorry about that.
That's
Yes, the language here is limited to the matters that are taught in the motion language.
And I'm comfortable with that. So moved. I forgot what you asked me
Thank
to
you.
do.
No, we're good. We're good. Thank you. Do I have a second, Commissioner Concepcion?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, do a roll call vote. Commissioner Concepcion.
Aye.
Commissioner Roy.
Aye.
And Commissioner Stebbins votes aye, 3 in favor, none opposed. Thank you, GC. Appreciate that.
Thank you all.
All right.
Thank you.
All right. Next item we'll move down to is social consumption public comment period memo. I'll be tackling part of this presentation, also inviting in our Deputy General Counsel, Mike Baker, who obviously has been leading the drafting of the regulations with respect to social consumption. Commissioners, as we were going through our review of the draft right before we gave it approval, obviously we came across some issues related to cooling down spaces, some questions around prohibition of alcohol and tobacco sales, and some points that Commissioner Roy raised. Erica from our legal team, I think, came up with a thoughtful suggestion based on practices of another state agency to kind of call out opportunities and really a request for thoughtful comment on key topic areas that, again, might kind of get lost in all of the red line versions. But certainly, I think it was a helpful suggestion. What I did was I went back, I worked with the ED, the GC, and Deputy GC. I looked at what Erica from the legal department shared with us. I'll be honest with you, I thought it was, no disrespect to our lawyers, a little bit too legalese and didn't, for me, effectuate the intent of, how do we call out more directed comment and more intensive comment with respect to some issues that, were the subject of much discussion and much debate. So what is included in the packet, and happy to kind of wordsmith this with you, is something that I'm simply entitling a notification of comment submissions. It's a very short, simple document, certainly talks about our timeline, certainly talks about our efforts to encourage and really seek out comment on our social consumption regulations and the other regulatory changes that we're hoping to make. But it follows up on that. And in addition, the commission, based on public policy discussions in our public meeting, is looking for a specific comment on some key topics that, again, garnered a lot of discussion during our deliberations. I've tried to write these in a way that didn't necessarily try to direct or suggest comments go in one direction or the other. So I've tried to be as even-handed about the comments and what they're intended to, what the commission is intending or looking at. But you see in the document, talked about, I think this was a couple of topics, Commissioner Roy, that you brought up about the responsible vendor training requirements, shelf-stable, non-infused food sales, limitations on sales. Some of these we have already seen some comments and some questions back from stakeholders that have been watching our deliberations on these topics. Prohibitions, again, this speaks to making sure, whether language is sufficient, just using the terms alcohol and tobacco. Prohibitions with respect to promotions, seeking comment on ventilation requirements, as well as seeking additional comments with respect to cooling down areas for patrons at these establishments. So again, looking at this, this would, if having conversation with comms, this would kind of go out in their effort to disseminate as much information as possible for folks to comment on. This would go out as kind of another attachment or another document. And again, we're trying to invite some specific feedback on these key topics. That was my intention. That was kind of the takeaway that I had. And again, thank Erica from the legal department for her thoughts and suggestions. Hopefully kind of keeping aligned with what our intentions are when we talked about this at our last public meeting, and what we would hope to get out of this. And again, I've tried to write it in a way that has been as even-handed as possible so that we attract the widest array of comments on some of these key critical topics. But that's what you see culminating in the draft in front of you. I will invite our Deputy GC, Mike Baker, if he wants to join us and just offer thoughts on some of the edits and amendments that he made to this. Deputy GC.
Thank you, Mr. Acting Chair, and thank you, Board, for the conversation that we've had throughout the promulgation process thus far. The things that I particularly wanted to put into this draft with obviously the Acting Chair's guidance were the conversations that we had towards the end of the process here. So specifically looked at the limitations on sales section, which should be pretty familiar because we spent so much time on it the last day, of 500-141-3, and also the one above that, as it appears in the memo, is 500-143E as well. So that's the shelf stable language that we added for retail. Obviously, those are important items that we spend a lot of time on, and so further reflection and pointing the public to those items I thought was important. And the last one being the ventilation requirements. We have pulled best practices from other states regarding the ventilation system, but we know that it's really important to promote public health and safety that these ventilation systems are adequate, and so we're hoping to get additional public feedback on that as well. So thank you again for all the conversation that we had, both for the commissioners and the staff. It's really great getting to talk it out with you all. But yes, that's some of the amendments that we put into this memo.
Before I open it up for questions, I know the ED, you were helpful in starting to pull this document together and the wording for it. Anything you want to add?
Thank you, Mr. Acting Chair. No, I mean, I think obviously
like before, we'll be asking for certain documentation.
I know that we'll receive comments on a variety of different topics throughout the regulation. So I think this was an attempt to summarize some of the topics that had a lot of discussion from the commissioners, and some that came up towards the end that commissioners were looking for feedback on. And so, I think ultimately, again, what was discussed previously is this is not part of the package that goes to the Secretary of State. It's advice that you're providing or guidance you're providing to the public leading into the formal comment period, gives folks an understanding of some of the things that you're looking for feedback on, in addition to anything else that comes through formal comment period. So I like it as a sort of value add. Obviously, it's not a requirement of this process. And then just additionally, I think for folks looking at it as well, I think, the commission has used similar, a press release referring to public comment in the past, especially around the 2-driver rule, to sort of say we're looking for feedback. So I think it works if the commissioners are looking for it. Obviously, it's your all decision, and happy to sort of discuss anything within it. But I think it will hopefully, demonstrate to a number of our stakeholders some areas that you're looking for feedback on.
Thank you, ED. And let me just add, as in pulling this document together and thinking about listening sessions, public listening sessions that we've had, I think there is usefulness to a tool like this, that when we do future listening sessions, that it might give commissioners, it might give staff an opportunity to kind of lay some groundwork for testimony and comments that we might be looking for at a public listening session. So I'm thinking about the, you know, utility of this type of document and how we can use it going forward. But again, I want to thank Erica for kind of planning the idea with us. Again, this is not exactly what the agency that she referenced used, but I think it's in a form and format that will be helpful to folks as we begin to go out and solicit public comment. But obviously, you know, commissioners looking for your input or even wordsmithing, or we can also decide not to do this in the form that it's made, and we can use our comments and conversation here to highlight, you know, issues that we want to talk about or hear from folks on. But Commissioner Roy, I think you had your hand up. Go ahead.
I do. Thank you, Acting Chair. I echo the Executive Director, like it as a value add, and I'm going to echo you, Acting Chair Simmons, and thank Associate General Counsel Erica Bruno for recommending this, and Deputy General Counsel Baker for all the work he has done around social consumption, which is yeoman's work, and you, Acting Chair, for taking a neutral posture in this document. It's not to sway anyone, it's just to get input, which I think is critical for us as policymakers. So we may not agree as regulators, so it's so important to hear from stakeholders and licensees and patients and consumers. So I think, like you said, I think this might be a tool we'll be able to use in the future to get the information that we need. And, you know, I guess my two things, I think we should also share this with the CAB members, because it would be good to hear from the CAB on these issues. And secondly, I'm wondering if we can make it in a format that is a fillable PDF, so they can just type into it. Can we do a fillable PDF where there's space underneath the question for people to type in their answer?
I think both are great suggestions. I think when you know, if we get to a motion on this, I think it does kind of direct staff to publish it in a form is discussed by the board, and it will be part of, you know, the outreach that we are making to folks to encourage their comments and feedback. So two good suggestions, ED, and then to you, Commissioner Concepcion.
Sure. Just for that point, I just want to make sure, and obviously, I think certainly within Commissioner Roy's suggestion, I just want to make sure, right, there are formal processes for providing comment on the regs, and I just don't want to create a situation where we're creating an informal process with a formal process. So long as those things are being run through, you know, Deputy General Counsel, General Counsel, happy to look at all of those suggestions to maximize input.
Okay. Commissioner Concepcion.
Thank you. And thank you to you all for putting this together. I had one recommended change in the language.
Sure.
It was under the provision around the cool down areas, and I feel like the language, there's a finality to it that is not necessarily accurate. Right now it reads, licensees will be required to provide cooling down areas. And I think it's helpful to include language that says under the draft regulations, so that we note that this is what we're considering, but there's nothing that is final. I'm highlighting that because I've been receiving some input, some comments about sort of the implications around that, but I want it to be really clear that these are draft regulations and it's not something that will happen necessarily.
Thank you, Commissioner. I think that's a fine update. I know Mike probably has the document open right in front of him, but he turned on his camera, so.
Hi, Mike.
I'll invite you to offer any thoughts you have, Deputy GC.
Thank you, and thank you, Thank you, Mr. Acey, and you, Commissioner Concepcion, for the suggestion. I think that totally makes sense. And if the board agrees, I'll make that amendment in the document.
Thank you. Any other thoughts or questions? If there's none, I would seek a motion to direct ED to work with staff to publish this memorandum as discussed by the board on the commission's website and perform outreach to all stakeholders, including members of the Cannabis Advisory Board. Do I have such a motion, Commissioner Roy?
Before I do that, should we put a date published by? I think that we're doing that lately. I think it holds us all accountable when we put that in.
Okay. Attorney Baker, I would ask you, is there a date you thinking of our regulatory timeline? And if I believe obviously the draft regs are available now on our website. They get formally published tomorrow in the Secretary of State's registry. What would be a convenient date? And probably invite the ED in if he wants to speak on behalf of the comms team to get this out.
Mr. AC, I'm just happy to say we can get it up as soon as possible. Obviously, the comment period is open as of right now. We're accepting comments, so want to try to get this in front of the public as soon as possible. So I'll work with the ED, comms, and other relevant staff to get this up and out, as soon as we can.
Okay, ED, do you have any thoughts?
No, again,
Commissioner Roy is looking for, let's make sure this is all up by a certain date.
So just through the acting chair and to the DGC's point, if you want a date certain in the motion midweek next week, I could look at the calendar and give you an August date. Is fine. Ideally, I think to the DGC's point, we could ideally, once he's incorporated your changes, get this up ASAP before that. But if you'd like to have a date certain in there, next Wednesday is the 20th of August.
20th. Okay.
No later than.
All right. Since I didn't get I didn't have my first motion moved, I will step back and
that's the correct procedure.
Offer a new motion. I would move to seek a motion to direct the ED to work with staff to publish this memorandum as discussed by the board on the commission's website by August 20th, 2025, and perform outreach to all stakeholders and members of the Cannabis Advisory Board. Do I have such a motion, Commissioner Roy?
So moved.
Okay. Do I have a second, Commissioner Concepcion?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion.
Aye.
Commissioner Roy.
Aye.
And Commissioner Stebbins votes aye, 3 in favor, none opposed. Thank you, colleagues. Thank you, Deputy GC. All right. Bear with me. Next item is new business not anticipated at time of posting. I am not aware of any items that were not anticipated at time of posting. We'll post our next meeting date list. Obviously, our next public meeting is anticipated to be September 11th. Obviously, we're also mindful that we will need to add some dates to this once the comment period closes. Our team has an opportunity to review all of the comments on the social consumption regs and other regs that we're proposing changes to. So we'll try to get those dates squared away as soon as possible. That's September 11th, and a meeting on October 9th, possible listening session on October 23rd, and then November 13th and December 11th are the meetings we have scheduled that's anticipated at this point. Commissioner Concepcion, go ahead.
Thank you, Acting Chair. September 8th, can you clarify the, I know you referenced September 11th, but I know we also have something September 8th.
Yes, September 8th is our public hearing on the regulatory framework. That will be in person in our offices in Worcester. Doing things a little bit differently. Obviously, we are, as Deputy GC pointed out, folks are free to comment on the regs at this point and submit public comment to us. We're inviting folks to participate in the public hearing in person. We will not be offering a virtual component to this public hearing, but obviously written testimony, comments can be sent to us by email or to our address. And then obviously we're inviting folks to participate in the public hearing in person. Commissioner Roy, did you have your hand up? Go ahead.
Yeah, if you don't mind, can you go through I know September 11th is the hearing in person. can you just go through the rest of the dates, whether they're in person or virtual or hybrid, if you don't mind?
Sure. September 8th will be in person. September 11th, I expect this to be hybrid or remote, not hybrid, remote. And then, as I said, trying to look at what days we can set aside for review of the regs, review of the comments that we received, probably toward the end of September. But we'll try to work around folks' schedules, and obviously, depending on the amount of comment that we get, will drive, how quickly the working group can review all the comments and consider changes to bring back before the board. Okay. All right. I think that's it. Any other comments, questions? If not, I would seek a motion to adjourn. Do I have such a motion, Commissioner Concepcion?
So moved.
Okay. Do I have a second, Commissioner Roy?
Second.
Motion made and seconded. I'll do a roll call vote. Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye. 3 in favor, none opposed. We are adjourned. Thank you to my colleagues. Thank you to the entire team for a good meeting. Appreciate it. And we're adjourned. Thanks, everyone.
Thank you. Bye, everyone.
Thank you all. Thank you.
Oh, what a good meeting. I'm Adele. So, do you want to play some trivia? We can play if you want. I'm a little tired, but I said I would play around 3:30. It's 3:30. They must have heard me. Chair Stebbins was like, you know what? Grant wants to play towel trivia. We'll just end around 3:30 for him. Well, I'm a little towel. All right, so how you doing? My name's Grant Smith Ellis. Great to see so many of you. Hi, staff. I'm Towel. Did you see Pete Bunny Towel presiding over the motion to adjourn? Did everyone learn a lot about the governmental regulatory apparatus in Massachusetts? Are we all informed, erudite, and cogent towels? My name is Grant Smith Ellis. Let me do a quick recap of the CCC hearing just so I can upload it for the people who missed it. Not very much happened. Well, that assured thing was kind of a big deal, but let me just do it quickly. Hello! My name is Grant Smith Ellis, and if you missed today's Massachusetts CCC hearing, I'll give you the rundown very quickly. We had opening comments from commissioners in reverse order, Commissioner Concepcion, Commissioner Roy, and then Commissioner Stebbins. Commissioner Stebbins was newly reappointed as chair, the first commissioner ever to be reappointed to a position on the commission. Furthermore, Commissioner Roy opened her remarks by talking about the wonderful Alternative Compassion Center up in Hull. They're a wonderful family-owned business that just co-located and now offers both adult and medical use sales. Towel love, especially out to the wonderful folks out at ACS. We need more medical operators in this state helping patients like Little Towel, and otherwise, even if I don't live in Hull, I can drive out there if I want to. It's beautiful. Also, Chair Stebbins talked about a meeting with the Cannabis CBA Business Association involving David O'Brien during his opening comments. Then Assured Testing Lab was subject after a number of other discussions that the Commission undertook, Assured Testing Lab was subject to a discussion about its ongoing enforcement issues related to a July 4, 2025 enforcement order and summary suspension order. The Commission announced that Assured license will be unsuspended provisionally September 15th. It can be reinstated as early as August 22nd. This, of course, had to do with 522 samples across 6,800 or so batches of product between April of 2024 and April of 2025 that was potentially contaminated or at least potentially not correctly tested for the presence of total yeast and mold, which must be under 10,000 CFU colony forming units per gram. Now, I will say this, ladies and gentlemen, I think it is very, very interesting that we also found out during the overview before commissioners voted on the stipulated agreement between Assured and the Commission that we came to find out that Assured also had, in at least one case of a product with heavy metals, failed to appropriately test for the presence of arsenic, which is one of the big four heavy metals, as Commissioner Kimberly Roy talked about. Kimberly Roy, of course, was the first public official in the Commonwealth to bring up multiple years ago this issue of potentially contaminated or manipulated product due to the way in which total yeast and mold testing was being effectuated by various independent testing labs in the Commonwealth. So another thing we found out was that at least 6 to 8 pesticide tests operated by Assured were the Assured sent the pass results to the Commission before actually doing those tests. Now, the products in question did eventually pass for pesticides, but it goes to kind of a failure to engage in regulatory compliance. Now, the agreement entered into with the Commission by Assured says that their license will be reinstated sometime between August 22nd and September 15th. Furthermore, their CEO is prohibited from owning a license in the industry for up to 12 months. The company is on 12 months of auditor monitoring, and then 24 months of provisional, or 12 months of provisional suspension, or 12 months of probation, or 24 months of some type of other monitoring. And there was a $300,000 fine, which can be paid over 180 days in $100,000 installments. Furthermore, I do think it is a little bit interesting that the Commission noted that there were products that they tried to explain in a prior presentation in the beginning of the meeting, that there was a list on the Commission's website where consumers could go to identify products impacted by the recall. Well, Little Towel happened to take that data, render it into an Excel sheet, and I'll tell you can't identify where it was sold or who produced it. So I had to de-anonymize with a Python script all of it. It took me a long time last week. I did it. I wrote the script myself. It was a fun script to write. It was a little bit complicated. It was a good script, though. But anyway, I wrote this script, I de-anonymized the data, and then I promulgated the Excel sheet. Even that is not ideal. It doesn't say where the product was actually sold, but at least tells you roughly who cultivated it or what facility it passed through before it went to the retailer. So the Commission is all over the place on this because it fundamentally impacts the bottom line of the market, as I think a lot of people know. And I think this is just the beginning because, in my opinion, I really hope that the Commission continues to look at whether other testing labs, now that Assured has been reformed, quote unquote, are still potentially manipulating total yeast and mold results because they need to offer it to their clients. Otherwise, those clients would not be able to pass because a lot of product in the state could not get on the market with legitimate total yeast and mold testing. And furthermore, some of the people who use non-plating based, or even some people use plating but not for 72 hours as required to culture their samples for total yeast and mold testing. But the real big issue, ladies and gentlemen, let me just tell you right now, the biggest possible issue is that this contaminated total yeast and mold testing, there are kit manufacturers that aren't able to detect total yeast and mold. They can only detect specific pathogens. They want to eradicate the 10,000 CFUG limit entirely because they want to do pathogen-specific testing, but their kits aren't able to detect all of the pathogens that total yeast and mold testing currently captures. So that was the big deal with Assure. Then the CCC, so they voted 3-0 on that enforcement action. Then the CCC talked about how they are going to start enforcing tier regulation for cultivators who are not either using all of their canopy space per year or selling all of the product that they're growing, okay? And so they're going to start enforcing that after January 1st, 2026 with a 60-day notice window before the enforcement begins. Then the CCC talked about how it's going to start more actively intervening in host community agreements. Now this litigation, this has to do with, it's kind of like a corollary to the MBTA Communities Act, which we saw challenged up to the Supreme Judicial Court by Milton, all right? But it's more having to do with 94G3A, which has to do with the local licensing of adult use shops in cities and towns that permit them. And there are some cities and towns like Great Barrington and others who say that new provisions of Chapter 180 of the Acts of 2022 do not apply ex post facto to host community agreements that were negotiated prior to that time. However, the issue is that it's not the host community agreement being negotiated prior to 2022 when the Chapter 180 of the Acts of 2022 was passed and reformed how host community agreements are signed between local cities and towns and adult use companies in light of what happened in Fall River with the former mayor Giselle Correa. It's more about the fact that you have to submit the host community agreement for your license renewal every year. And as a result, you can't submit an out-of-compliance host community agreement, and these license operators are screwed because the cities and towns really want these old agreements because they're much more favorable to the cities and towns, whereas the new law makes it a lot more difficult for cities and towns to rent seek from these companies, okay? So, in turn, the cities and towns are saying, well, we already made the agreement with you. You're it's like a corollary to promissory estoppel. I'm not a lawyer. This is not legal advice. You're basically promissorily estopped from reneging on your contract with us. You're bound by it, even though it's going to cause you not to get your license renewed, and thus the CCC has to build a waiver program, even though they can't waive HCAs entirely because of the statute. They're going to have to build a waiver program because we just won't sign you a new HCA. So they have to keep paying HCAs that are not compliant with the law, and these towns have sued basically the state and the CCC tried to intervene as a party, and the judge hasn't heard their motion, as we heard today. The judge deferred hearing the CCC's motion to intervene between Great Barrington and I think a retailer, I forget who it was, related to these host community agreements. So this is a big deal. It's a bubbling up thing. It's going to become as big of a deal as the Host Community Agreement Act, the MBTA Community Agreement Act litigation. But the Attorney General, I think, sees a similar issue here, but it's much more pernicious when it comes to these cities and towns that don't want to ratify or update these agreements. Because in essence, what they're doing is they're flouting state law. They're using the provisions of contract law, basically, to undermine the intent of the statutory reforms, and then they're basically preventing these license holders from getting their licenses renewed because the CCC is saying your HCA is not compliant, and the towns won't sign a new HCA because it would result in less favorable terms. It's a pickle. It's a quagmire of the highest order, ladies and gentlemen. So then they discussed that, and then I think they wrapped up with a little bit of a discussion about social consumption. There'll be a public hearing, no virtual access for testimony. I'm going to give them an earful about that on September 8th. Let me tell you about that. How dare you say that disabled people can only submit written comment? How dare you? There are some people who are homebound. We literally amended the statute so that you could have hybrid public meetings. You're having one today that was all remote. You can only do that because of the open meeting law being amended to facilitate digital access, and then you want to flout the very people who worked on it, and you want to tell me that disabled people can't have virtual testimony? Oh, you're going to get an earful from me, and you're not going to like it, Cannabis Control Commission. How dare you? My name is Grant Smith Ellis, though. Thanks very much for listening to that recap. Next Cannabis Control Commission meeting, as I mentioned, the public hearing on social consumption with no digital testimony offered on September 8th. A disgrace and an insult to disabled people, and I'm offended. I'll be contacting the legislature. And September 11th will be the next public meeting. That will be virtual. I'll have coverage. My name is Grant Smith Ellis, and I'm going to go back to playing Tile Trivia. Thanks so much for tuning in today. Please also consider supporting Tile Stream. This is hard work. I spent all day recording clips, promulgating it. This is a public information service. This is more for the clip than you all listening in chat. But if you want to donate, you can see the information below. There's a Cash App at Grant Smith Ellis. There's a Venmo at Grant-E1 and a PayPal, paypal.me/@Grant Ellis. I don't know. I have to get through next month. Classes are starting up again for me. I need your help right now. I don't want to be a burden on Towel Mom. It was just her birthday. Let's help Towel get get through the next few months. I don't really want money. I don't do this for money. If I could have no money and walk around the countryside with people paying me in food for moral lectures, I would do that. But I don't think Towel Mom wants me to do that. I don't think anyone wants me to do that. So try to help Little Towel. And by the way, public information services are going to become few and far in between unless we support things like this. I'll do my best to honor the principles that have made this channel what it is, which are educate, inform, and entertain the public, such as to engender, coach, and public discourse, and ward off the usurpation of our representative forms of government. And God bless you for your support. YouTube.com/@GrantSmithEllis if you want to see more in the future. How was that? How was that, Little Towels? Did I do a good job? Thank you so much. Yes, Pete Bunny Towel. And then someone said, Grant, look into the connection between OBOC, broils, and others. It's dark. Yeah, so I don't know if you're still here, the person who made that comment. Thank you very much for your insight. Let me just tell you, thank you so much, Steph Towel. We'll see if we want to play trivia. We got to see who's here and if they want to play trivia. I'm a little bit tired, but I want to play trivia. If there are at least 4 or 5 people, we'll play. If it's like 20 people, I don't want to do it. If it's like 2 people, we can play trivia tomorrow. Saturday. I'm going to take tomorrow off. Hold on, let me add. All right. So to answer the question, so I don't know too much about this whole OBOC broils thing. What I know a little bit about it. Personally, I think both sides generally tend to leave me alone, which is fine. The only people who really don't like me are like Kate Peter people. And then like very, very like devotional Turtle Boy and Karen Reed people who are just so blinded they can't really see what's going on. So like there are 3 specific camps that don't like me, like blindly loyal people to Kate Peter, blindly loyal people to Karen Reed, and blindly loyal people to Turtle Boy. People who are like generally independent thinkers but have opinions on these cases but aren't blindly loyal to anyone tend to like me. All right, it doesn't matter what their views are, whether Republican, Democrat, pro Karen Reed, anti Karen Reed, pro Turtle Boy, anti Turtle Boy, pro Kate, anti Kate. I generally get along with most people as long as they're not like devotional loyalists to those people, to any of those 3. Okay. What I understand about this OBOC Miss Shorty situation, I don't know. I don't really want to get involved. I don't know too much about it. What I do understand, I tried to I think Dag Nabbit has the best handle on it, and Dag Nabbit, don't discount Dag Nabbit. And when Dag Nabbit's onto something, she's like an investigative reporter. Like the interview she did with Aiden, the reverse interview, was one of the greatest things I've ever seen in my entire life. My opinion is it's an international thing. Like somebody's Australian, and then OBOC, I think it's OBOC and the Germans. Somebody's involved with the Germans. Somebody's involved with the Russians. I'm not even fucking kidding you. Like one of these groups, I almost said cabal, I guess they're kind of cabals. One of these groups is involved with the Germans. Okay, I think it's OBOC and some Germans. We don't exactly know which Germans. I'm pretty sure it's the Germans. Okay, then there are some Russians. Now, I don't know if the Russians are involved with and Abby, Video Jesus, is somehow involved in this too. So it's Abby, the Video Jesus, OBOC and the Germans, somebody else and the Russians, Jason Broyles, I'm not fucking kidding you, Kate Peter, and then trolling people online. It basically explains it. But what I think I'm being told, the dark underbelly of it, you want to know what the damn dark underbelly of it is that they're all, listen, all right? You really want to talk about what those people do? I think they hunt bad people, okay? Now you want to look at Little Towel. All right, Little Towel. Little Towel doesn't like bad people. Little Towel doesn't like people who hurt women. Well, I'm not being misogynistic. I just don't like people who hurt women, and I don't like people who hurt children. I don't like that. I get very, very upset about that, okay? Now, there are some people who really, really don't like people who hurt children that want to stop predators. We talked about Schlepp in the Roblox situation earlier today. I'm just going to make a post about Schlepp now because I think he's a really good guy. Those people, some of them are really good, okay? They know how to get those dangerous people and then put them away in prison by referring the stuff to law enforcement. That's what they're supposed to do, okay? That's good. Now, some people who do that get into a really dark, seedy underworld, okay? Now, obviously, much like within the CIA, by example, I'm not in the CIA or any part of government, I'm just giving you an example. much like with the CIA, okay, you have to have mole hunters within the CIA because the CIA can get infiltrated. Okay, in predator hunter networks, you have predators who pretend to be victims advocates, such as people who pretend to be fake women online in order to get close to victims and then share naked pictures of them, who know Kate Peter and have since 2019. And in that sense, there's this PI firm run by a guy named Marty Kraft, you know what I'm saying? And I just think when you start really looking into it, you'll find that a lot of the online discourse related to the Karen Reed, John O'Keefe, Turtle Boy case, whether it be about Kate Peter, Turtle Boy, Brian Tully, Jen McCabe, or otherwise, is not artificial, but it traces back to overlapping concentric social circles of the most nefarious order. And this isn't a coincidence. Soft power functions that way, and that's why Harvard Finals clubs function the way they do. You train the aristocracy, whether on the local level, the state level, the national level, the international level, or otherwise, to behave a certain way. Think there's no American aristocracy? Of course there is. And they behave a certain way, they have certain friends, they have certain connections, and some stuff is never supposed to become public. Frankly, your name is supposed to be in the newspaper twice. Once when you're born, once when you die. A lot of these people already fucked that shit up. Alright? So now, you got this situation where everything is crashing down. I'll tell you, just as a preview for everyone, Jason Broyles and all these like internet channels and people, they all were just kind of side parties to the fray, okay? They were manipulated. A lot of them are emotionally vulnerable. Like Jason Broyles was definitely one of the manipulators, in my opinion. Like Kate Peter was one of the manipulators. Aidan Kearney was one of the manipulators. Karen Reed was one of the manipulators. This was all a big operation in different ways to advance different interests. All of these people online, some of them very vulnerable, okay, emotionally, were just taken advantage of, okay, by a lot of these core actors who are very, like, internet, like, savvy, okay? And what it really is going to trace back to when everything comes crashing down, mark my words, you're going to have Aidan Kearney and Karen Reed having committed misconduct in multiple different ways, okay, enabled by the old DOJ with Levy and Rollins. And then you're going to have Kate Peter and Brian Tully and Jen McCabe having done very bad things and either hid it from Michael Morrissey or he looked the other way, okay? Whether it was the Birchmore probe, the phone extraction, the lies about Colin Albert and Chris Albert selling drugs, and everybody else, okay? If you just cut through all the noise, it goes right back to Jen McCabe, Brian Tully, Kate Peter, Aidan Kearney, Karen Reed, okay? Alan Jackson, David Iannetti are kind of core players in this too, okay? But you understand, it was Tully's unit at the state police that did bad things to Sandra Birchmore and bad things to Lindsay Gattani, okay? It was Tully's unit at the state police that retained a private investigator named Marty Kraft who hired Kate Peter. That private investigator, Marty Kraft, used to date Christy Citroni's mom, okay? Which means Jason Broyles, in my opinion, and Christy Citroni and Kate Peter have been working together under Marty Kraft since the very beginning in November of 2023, or a little bit earlier, October. That is why Jason Broyles, and this is on record, bought a Free Karen Reed billboard in the fall of 2023 under his own name. He was clearly deployed originally to try to get close to the Free Karen Reed people, but he got pushed out for whatever reason, probably because he's a little creepy, in my opinion, okay? And his divorce documents from his first marriage are starting to come out, and I hear they're very bad. Okay, he did some bad things, allegedly. Broyles can't do that, okay? It doesn't work. It was clearly Kate and Kraft, in my opinion, sending Broyles out, pay for the billboard, try to get yourself close to Karen Reed people. Didn't work. Then Broyles appears again under a fake name, Haley Walbrecht, in the winter of 2024, and by the spring of 2024, he's directly involved with leaking Lindsay Gattani's unredacted phone extraction that Brian Tully leaked to Aidan Kearney's lawyer, Tim Bradel, with only messages from Tully to Lindsay and from Kate to Lindsay removed. And if you might be saying to yourself, are you saying that Brian Tully and Jen McCabe have been friends for a long time, and they talk regularly, like directly, as do Kate and Tully, as do Jen and Tully? Yeah, okay? Nobody did anything wrong with the investigation of John O'Keefe's death. It's just these people think that laws are suggestions, okay? A lot of them. It's ridiculous, especially the people who enforce the laws. I cannot believe some of this stuff happened. Fundamentally, all of the side actors aside, I feel very bad for some of those people who got, like, taken advantage of. Okay, I don't even think they knew what they were involved in. Setting all that aside, there was some real harm done, and these cases were compromised. Okay, it's horrifying to me that these cases were compromised. I still haven't come to terms with it fully. I'll talk about it a little bit. But I still can't come to terms with it. You know, like if you got a good case against Aidan Kearney, in my opinion. You don't need Kate Peter processing the evidence for you, bro. Like, what are you doing? You know, it's such a... It's just... That's where my fury comes from. I think a lot of people understand it now. It's not really an anger about necessarily any one thing that happened. It's just that they compromised these cases and undermined the voices of the vulnerable for very selfish reasons and gratuitously. They didn't need to involve Kate Peter in the handling of evidence in a criminal prosecution. Do you know why it's not a good idea to involve anyone in a criminal prosecution when you're the prosecution who's not trained in the handling of evidence? Well, there's something called bright line reasoning, okay, which is designed to make it easier for police to apply the standards. I'm not a lawyer, this is not legal advice, under like Carney for the automobile exception, et cetera, et cetera, et cetera. Okay, you see what I'm saying? Like, we make it easy for cops to apply the rules they have to apply during their beat, okay? You know what is not easy? Being a detective. You know why that's not easy? Because you have to apply the rules of evidence proactively in real time, and you have to know what's subject to the exclusionary rule. Have you ever read the exclusionary rule? Have you ever read the interpretation of the exclusionary rule and the progeny of the exclusionary rule? Not to mention, like, we're just talking exclusion of evidence, not to mention the progeny related to Odell, DiBenedetto, and McCarthy in the state of Massachusetts for motions to dismiss. Okay, so we have a serious problem when you have people who are not trained in the progeny going in and handling evidence. You cannot have that happen because you cannot do one thing wrong, or the penalty is not just exclusion under the Fourth Amendment. The penalty is Odell governmental misconduct dismissal. Now, it's very, very likely that this unit is gone for this reason, okay? All these emails just got released between Tuesday and Wednesday of this week between Tully and Kate, you know what I'm saying? So, now, my trivia quiz about Jason Frost and Kate Peter. But I'll tell you, all these emails are the reason why this is all crashing down right now, because Tully's, nothing made sense to me over the past 6 months. Why move Tully? Why move why move everyone but John Fanning out of that unit? Okay, first of all, John Fanning was Brian Tully's partner for like 20 years. Second of all, John Fanning was the person who used to work in Stoughton, along with Yuri Buchanan, with Matt Farwell, and John Fanning wrote the Matt Farwell report. Third of all, there's an email from Morrissey that NBC 10 released that shows Morrissey on the day Farwell got indicted by the feds being like, is this true? To Tully and Fanning. Bruh. All right? I think Morrissey got played a little bit. I think Cosgrove got played a little bit too. And I think the center of it was three people who are very good at staying out of the spotlight, but all of whom are about to become the Michael Proctor of the Turtle Boy case, but way worse. Michael Proctor got fired for telling, like, his family, his sister or something, about non-public investigatory details. Brian Tully, the list of charges against that person, when it comes out, is going to be like 4 pages long on this stuff. This is outrageous, what he did. Okay, and I'm not saying this because I'm pleased for anyone about this outcome. I'm furious. I really hope that it gets dismissed without prejudice, which I think allows it to be refiled. It should be dismissed without prejudice because the underlying charges, in my opinion, have merit. The underlying evidence is valid. The only error here, and remember, double jeopardy doesn't attach until jurors are impaneled. Maybe it doesn't even attach until deliberations begin. The only issue here is how the evidence was handled. All the evidence, I'm sure, exists, right, in pure form. It was just that Kate Peter was involved in the handling. The chain of custody being compromised means that the Odell motion can be renewed, in my opinion, by Kearney, and that's exactly what they're going to do. Do you know what Aidan Kearney's going to do? I already know because Bettero's going to figure it out, so I'll just tell him. What Bettero's probably going to do is he's going to get the... So what Kate did was she uploaded a bunch of Google Drive links, okay, that were files that she was processing for Tully so he could submit to the grand jury. Kate, after all this, like about 2 weeks ago, Kate made a post threatening the Norfolk DA on Twitter. That's how I knew shit was about to go down, okay? Now, these emails then got released like 2 weeks later, okay? All right. 24 hours later, Kate went after Marty Kraft by proxy, I'm pretty sure, because she, like, a leak came out about Kraft for the first time. But these emails are bad news. These emails are bad news, and it fundamentally reflects a series of events that I couldn't really understand, but that make a lot more sense now, which is that there was a core group on both sides, Karen Reed and Turtle Boy and Alan Jackson and David Yannetti on one side, and Jen McCabe and Brian Tully and Kate Peter on the other, in my opinion. That's the 6 people that were at the core of this. And they had people backing them. Like, I do think Morrissey was behind Tully on Kate on some stuff, like especially like the federal probe into his guys, okay, Morrissey's guys. Because I think they were trying to figure out that federal probe in the fall of 2023, remember, about Birchmore. I really do think they were trying to figure out what it was about. But you got to tie that in as well to the fact that behind Karen and Alan and Aiden was Josh Levy and Rachel Rollins for a while, okay? Now nobody has any support. I just want you all to understand, if you're trying to parse this all, I hate talking this stuff. I did 12 hours yesterday, but let's talk about it. If you really want to parse this all, the reason what's going on is nobody has any institutional support. Kate has no institutional support because Tully has no institutional support because I think Morrissey gave up Tully, and that's why he got moved, okay? Because Tully and Kate did some really bad things and fucked up this prosecution, like especially the October 2023 charges involving like Chris Albert, Colin Albert, whatever, all right? So, I see this very strange series of events playing out, and we're culminating here in this situation where now no one has any institutional support. Aiden and Karen don't have it. They're exposed, in my opinion, to federal liability for the Leslie leaks and other things. Maybe Levy's exposed, maybe Rollins exposed. They got people in the DOJ still who could help the DOJ investigate what Rollins and Levy and Leslie and Kearney and Reed and Jackson and Yannetti were doing, okay? And then you got the state apparatus, in particular Michael Morrissey, abandoning, for good reason, Kate Peter and Brian Tully, but at the expense of this prosecution. And the reality is this prosecution was compromised from the beginning, not because the evidence wasn't good, not because, in my opinion, Aiden Kearney didn't do bad things. I think he did do bad things and could have been held accountable and could be still held accountable. But because Kate Peter, Jen McCabe, and Brian Tully, in my opinion, compromised the prosecutions of Aiden Kearney for personal reasons. And that's not good enough of an explanation. I'm sorry. Sorry. And so the Obach stuff, the Abby stuff, the Miss Shorty stuff, they're all just collateral damage in this war of attrition between Kate Peter, Jen McCabe, and Brian Tully on one side, in my opinion, and between Karen Reed, Aiden Kearney, and Alan Jackson and David Yannetti on the other. All right? It was a vicious fucking proxy war. It was one of the most brutal, devastating proxy wars I've ever seen in my entire life. The amount of innocents who litter that fucking battlefield, the amount of screams, okay, that I have endured, okay, the agony, the pain. We're measuring in the thousands of hours of tears that I've seen. The agony, I think a lot of you, I think I do well at hiding it, and I don't speak for anyone, and I won't. But what I've seen with my own eyes would break most humans. And I'm not talking about what I have experienced while reporting on war around the world. No. What I have seen during the coverage of this case has broken me and has made me numb to the world in ways that I will never recover from. It has put me on a life trajectory where I have found some glimmers of happiness, let me just say that. But it has also made me realize that there is a very dark element to humanity, and that dark element manifests itself in particular in the discipline of public relations, private investigations, and the intelligence community. I like the intelligence community. I'm not part of it, but I study it. I like it on the whole. I think it does really good work. I think it protects the United States of America. But, much like with the Carter Page situation, if it runs a little bit of muck, especially to protect individual people, well, you can't really have unaccountable independence if even one bad apple pops up. Because one bad apple can pop up in any other area of government and we check and balance it. But you can't have one bad apple popping up in the intelligence community on the state, local, or federal level because it ruins everything. Oh, goodness. Somebody bought a puppy. I think puppies are good. But yes, I think that whole thing started because someone mentioned OBOC and this kind of chaos. And my message to them all, my message, and I've been saying it on Twitter, to Abby and OBOC and Dag Nabbit and the women in particular, I think, who got like preyed on by broils and whatever, and all the people who were in the orbit of Kate Peter and Kearney and this crazy chaos. I'm sorry that happened to you. If no one has said this to you, because I don't think anyone ever will, I'm sorry. That was what you went through was real. Your experiences are valid. Your trauma is valid. I'm so sorry this has happened. I've dedicated my life to try to expose this so these people will stop doing this to you. It wasn't just one vulnerable woman. It was multiple of you. I've spoken to so many people, and yes, I'm very good at protecting who I talk to, so you're never going to know. But come on, I know how many of you were harmed by this, and I know how agonizing it was, and I want to let you know I've always believed all of you. I never thought that any of you were being malicious or wrong. You were just reacting to being abused by a very tight-knit, veiled, hidden group that was actively psychologically profiling and manipulating you all for various devious purposes, sharing naked pictures, like getting close to you for like very odd sexual purposes. Like, I'm just saying, okay? And I just think that is the most disgraceful part of this. And that I don't care if you believe in Karen Reed being guilty or being innocent. Turtle Boy being guilty, being innocent. If you were victimized in that way, your experience was legitimate. I believe you. I absolutely am intent on preventing these people from continuing to do this to you. And I'm sorry that it happened to you. And that's the message I want to send, not to the Broyles of the world or the Kate Peters or the Tullys or the Alan Jacksons or the David Yanettis. That's going to sting him a little bit. Or the Karen Reeds or the Turtle Boys. No. That's the message I want to say to all these people who, unfortunately, because they were just looking for friends or looking for meaning in their life or just trying to find a network of support, were taken advantage of because that's the exact personality type that is the most susceptible to being manipulated. And it's unfortunate. And it's wrong, and I'm going to I don't care if it takes empowering people one at a time, which is generally what I've done in my life anyway. Just come in, empower people. They're free like little butterflies. I move about my life. It's a little tormenting, but, suffer. I don't mind suffering. You got to do what you got to do. If it helps people, suffering to help people is worth it. You know what I'm saying? Suffering isn't bad just because it's suffering. If you're helping people and suffering for it, that's fine, in my opinion. I like doing that. You don't go down a weird path with that. I try to keep it limited in scope, you know what I'm saying? But anyway, I'm sorry that happened to you. That's my message to you. I've been trying to monitor this 6 degrees of Chewbacca drama going on, somehow involving the damn commies and the Russians and the freaking, the Germans. I don't know how the Germans got involved in this. I'm a little baffled by that. But, the Germans and the Russians and the parking clerk who thinks he's a woman, and the woman who thinks she's Shrek, and the man who thinks he's an Oompa Loompa, and the other man who thinks he's a Stay Puft Marshmallow Man that gets reddened all the time, and then the woman who looks like Steven Tyler from Aerosmith. It's just chaos, you know what I'm saying? And unless you live it, I think a lot of people vicariously experience the trauma of this chaos as it splashes over on social media, but you're not actually, in my opinion, finding the actual truth to this chaos. The actual truth is somehow even more absurd than what's been going on and displayed on your screens and on your social media feeds. I'm just interpolating it all for you, and the bottom line is that no one has any. Forget about the people who were played. Try not to hold them accountable. For the love of God, stop going after Kate Peters' friends who are anonymous. They clearly pedo hunt. They're good people. They're anonymous for a reason. It kind of makes me furious at Aiden Kearney. I'm like, motherfucker, how can you not realize, even if you hate Kate Peter and some of the people that are around her, some of those people are anonymous because they're pedo hunting. Leave them the fuck alone. Are you fucking stupid? You know what I'm saying? That's what I think to myself sometimes. That's point one. Point two, please don't hold accountable the people on social media, even if they have strong views you might disagree with, just because they became proxies in this. It's very likely that some people were witting and some people were unwitting. I'm not saying you shouldn't try to find out, look at all the leaked messages. You will know who was a witting participant and is freaking the fuck out, and who was unwitting. Just watch for how people are acting, read the leaked messages, you'll figure it out. It's not that hard to figure out. The witting actors in this scheme should feel ashamed. And they're scared as fuck. You can tell they're running around social media like the world's fucking burning down. It's kind of funny. The people who are unwitting, leave them alone, please. Please leave them alone. You don't need to bother them. They didn't do it on purpose. They just thought they were being friends with people, and those friends had like someone they wanted, like had a problem with, and they thought they were being supportive. I promise you, most of those people were not acting maliciously. They might have done malicious things, but they were literally like in a cult on both sides. Try not to hold them accountable. Like, they're already emotionally vulnerable. Just try to be a support for them as they decondition, because this is going to be brutal for all sides. Like, it's going to break them, both sides. It's going to really break them when they have to look at the reality of the fact that their heroes also did bad things, and the people they thought were villains might have done good things. Likewise, the people on the other side who they thought were heroes might have done bad things, and the people they thought were villains might have done good things. Okay, it's going to break people, cognitive dissonance like that, over something you followed for years when you don't know the people and you develop parasocial relationships with them. It's like these, Disney teen stars that you grow up with. You think you know them, you don't. Okay, it really can have an impact on your psyche if something happens, right? And so that's why we're seeing this. It's a very early preview, but the documents are out there now. People know, like, there are certain people who were clearly involved in this, in my opinion. Kay Peter, Jason Broyles, Jen McCabe, Brian Tully, Aidan Kearney, Karen Reed, Alan Jackson, David Yannetti. All of them in different ways. I think Alan and Karen more on the federal side, and this other chaos, whatever you want to call it, Brian Tully's terrible triumvirate, they also know that that discovery got handed over to Kearney. All right. I mean, apoplectic levels of chaos are incoming, and that's why a lot of people are going to melt down. Now, the authentic people are also going to react pretty virulently to this, because this is going to destroy their very well-meaning foundational beliefs in people they cared about. That part does give me some sympathy, okay? And that's why I'm trying to be very careful about how I judge people based on how they process this. I'm never going to judge anyone because this is overwhelming. But this is where we're going with that case. So that, when people say it's dark, to look into Obach and Miss Shorty and the Broyles situation, yeah, it's dark because of where it spiders. And it's really dark because of the stereotyping and the profiling that gets done. There's a famous story, when I keep saying this word profiling, it's kind of like criminal profiling, but it's different when you're doing it for intelligence purposes. And I'm not in the government. I'm just going to analyze this for you. There's an apocryphal story about after 9/11, the U.S. government, some members of the National Security Council took a trip over to Israel. And they went to, I think, the main airport in Tel Aviv. Or it might have been Jerusalem, I don't remember. But either way, they went to the main airport, which I think is in Tel Aviv. Now, at the main airport in Israel, I hope you know, when you approach that airport, there are 4, at least back then, there were 4 different checkpoints, okay? 3 of them were soft, okay? You had to go past, like, barriers to slow down. There were cameras, license plate monitors. They had armed guards. But it wasn't a checkpoint. It was like a slow you down barrier and also verify who you were. And this was, like, in 2002. Okay? You get to the 4th checkpoint. You check in. By the time you get to the counter, they've already done a full comprehensive intelligence background profile on you in real time before you step through the door and get to the ticket counter. Okay, that's what Israel was doing in 2002. The apocryphal story that goes around to this day is that a U.S. government delegation went over there from the NSC, and they wanted to ask the Israelis how to ward off future attacks. And the response from the IDF was, or it might have been Mossad, probably both, profiling. Okay? The response from the U.S. was, oh, we can't do that. We don't want to be racist. Now, I'm not being light about that. I don't think anyone should be racist. This is the antithesis of the point I'm making. It was that the U.S. didn't get it. Israel wasn't saying you profile them based on their skin color. Israel was saying you do a comprehensive intelligence background and profile them based on their personal characteristics, not their skin color. And that's what's going on in this world, okay? A lot of these, this proxy war. It's people being profiled based on their psychological composition, not their skin color. We were using a completely different analogy. It's being profiled based on your psychological composition to find your weaknesses, to put people in your orbit so that you feel less trustful, and then you run to the people who are actually the most dangerous. That's what Kate Peter does, in my opinion. That's what Broyles does. That's what Aiden does. Okay. There are certain tactics I can give you. Those of you who are in that orbit, I know none of them are in the chat. Maybe they were, though, because they were here earlier. Someone was here early asking about this. I can give you a little bit of help trying to decipher this and pick up on this. But the most difficult part is no one who's involved in this is, one, going to tell you about these tactics, or two, tell you how to identify them, because then they wouldn't work. So the most important thing is, much like the distinction between the form and content of Hegel's philosophy that we talk about that met at Stalingrad on the Volga in 41, okay? Hegel's form inspired radical Marxism, and his content, the content of his philosophy, inspired the Third Reich. Okay, they met at Stalingrad on the Volga. Ironically, they emerged into post-industrial capitalism, and that was the synthesis. But we're not going to talk about the dialectic right now. You have to tease out the form of these tactics versus their content. If you constantly see the tactics as they're approaching, right? If you constantly can pick up on what a Kate Peter or a Jason Broyles or an Aidan Kearney is doing, whether they send proxies to you, whether they come to you directly, it's never going to work, because you're always going to be very hyper aware of what they're trying to accomplish, what tactics they use, and in particular why they're using those tactics at that moment. So it's a perpetual exercise that does require a certain level of heightened analytical attention, but it's well worth it. It doesn't pay off in money, because that's not the point. The point is knowledge enables you to see the sort of I'd say 8-sided chessboard, and make sure that the way you are moving is not putting yourself in a position where you're going to get checkmated. And that's how you avoid being manipulated. And no one who is manipulating you is ever going to tell you that. Like that's the only way you can cut through it. It's much like critical theory, which breaks down propaganda. Propaganda doesn't work on a critical theorist, because a critical theorist understands what Edward Bernays was doing when he invented the discipline of propaganda. So every advertising campaign is not working on the critical theorist. The critical theorist is seeing it as the embodiment of psychological manipulation and the weaponization of Freud's mass psychology of mind. Similar concept when you're dealing with these very dangerous, very predatory intelligence community forces. I'm not saying that these people are like in the CIA. They are not. We're talking like this intelligence community is nothing more than an inter-association between state and local police and the federal government. That's what the JTTF is. That's what the Boston Regional Intelligence Center is. I'm not going to talk about some of the other task forces. You don't need to know about them. The point is, I don't know about them. I'm not in the government. I'm just a towel. The point is, that's what the intelligence community is. So Kate Peter, lowest rung possible. PI working for Marty Kraft. Marty Kraft works for Brian Tully. Kearney, from the summer of 2023 at least for 3 months, was very high level intelligence community. He was 10 levels above Kate. Karen Reed, I have my concerns that her and her dad have been IC the whole time, and they're very high level. Okay, regardless of whether they were IC pre-November 2022, Karen made some friends in the IC post-November 2022. That's why she looks me in the eye and she's just like, "You brilliant little fucking towel," and I'm like, "You evil little witch." That's the look I give her. Like, get out of my soul, you like soul-eating witch. Get out of there. I don't want you in there. Karen Reed, get out of my damn soul. Kate Peter, you know how so here's the difference between Kate Peter and Karen Reed, and this is how I knew. I'll never forget this. So Kate Peter does like a lot of bad stuff, but I don't really give a fuck. I just don't care about the personal stuff. I don't care about her like calling religion bullshit. I don't care about that stuff. But like Kate Peter weaponizing the justice system, okay, now like you have my attention. She wouldn't look me in the eye. After all this shit started coming out, I've only seen her like once or twice. Motherfucker wouldn't look me in the eye. And I knew at that moment she was not playing on a high level. And I was like, oh, nah, she doesn't got it. She doesn't got the makings of a varsity athlete. You know who's got the fucking makings of a varsity athlete? Karen fucking Reed. Okay? That woman looked me right in the fucking eye and was basically like, game recognized game. And I was like, oh yeah, all right. I was like, I'm not going to sleep with you, but all right, okay. I was like, you're not eating my soul alive, devil woman. You stay out of there, Karen Reed. But anyway, my point is, that's the difference between Karen Reed and Kate Peter. Karen Reed's a player, like serious player. You have to have balls to do that. And I'm not being gratuitous. I'm not like glorifying myself. You just have to have balls to look me in the eye with all I know about her. And she did it. Like just straight fucking balls, which means she could do counter interrogation like her fucking life depended on it, and she'd have no problem with it. That's why I want to interview her, because she's trained in counter interrogation. It would be really fun. You know who else is trained in counter interrogation? Sean McDonough. That's why interviewing him was really fun. Two people who are good at that, it's very fun. I'm not trained in anything though, but I'm a towel. All right, who wants to play trivia? Oh yeah, and you can definitely assume the best in everyone. Don't. Oh my goodness, Allie and Rue here. Let's play trivia. I still can't believe without the government change, no Fed stuff would have happened. They did not plan for that, 100%. And Tanya, you ever think about, you think President Trump maybe wasn't meant to actually get elected, and all this nonsense people think about how he wasn't actually shot at, whatever? Nonsense. He was never meant to get elected. I see, in my opinion, at least some elements of it tried to take him out. Brah. I also heard rumors that, you remember that Vegas thing back in 2019 with Stephen Paddock? Guess who might have been meeting with Mohammed bin Salman in Vegas in 2019? President Trump. Okay? Salman was there undercover. MBS at the time and MBZ were fighting over King Salman's successor, like who was going to be King Salman's successor. And setting aside the whole Wahhabist sort of infrastructure out of Islamabad behind the Saudi throne post-1979, you got to think a little bit about whether President Trump was even supposed to get elected. I don't think he was supposed to get elected, Brett. I think they tried to kill him because what happened when he got elected was he went on a fucking warpath and like brutalized the intelligence community because they tried to brutalize him. I don't know if some of you understand. I don't mean to be pedantic, but like what they did with Carter Page, that was brutal. They lied to the FISA court. Like it was brutal what the liberals did. You want to know why President Trump and Pam Bondi, the Attorney General, are going so hard at all of this right now? It's because they're after the liberals who weaponized the DOJ. Guess who two of those liberals were? Josh Levy and Rachel Rollins. Guess why Karen Reed and Alan Jackson are so fucked, in my opinion? Not in that way, but you know what I'm saying? Because they were engaged with the liberals. Like, they're so ridiculous. You know what I'm saying? It was the most obvious way to get yourself brought down, and they still did it. Like, literally, like, I think no one anticipated President Trump getting elected, but anyone who was anyone, to understand, I got recruited by the DOJ, I'm sorry for saying that again, I got recruited by the DOJ antitrust section in the spring of 2023, directly, okay? I got locked in a room in Northeastern with a federal judge, a bunch of federal agents, one of my professors, 4 students, and me. And then they told us about the 75 sections of the DOJ. Then, without me doing anything, I got an email the next day, like when I became a student member of the Federal Bar Association. And then they were like, yeah, you should be in the antitrust division. Then they like recruited me. Do you understand? It was like the Sorting Hat at fucking Hogwarts. But like, motherfucker, they could not have known that I was interested in antitrust work unless they had a comprehensive fucking profile on me. And then they were like, oh, he does really good antitrust work. Let's bring him into that section. It was like going into the fucking Sorting Hat. Now, the antitrust section is kind of like Gryffindor, you know what I'm saying? I would have done it. But my point of the story is, in May of 2023, listen, I was one of the few Democrats, and I was a Democrat back then, now I am not. I was one of the few Democrats, and you can ask Towel Mom, in 2015, who was saying to a lot of people, listen, Donald Trump is going to get elected, okay? Donald Trump is going to get elected because he is going to win the most votes and the highest percentage of the Electoral College. Just watch. That's exactly what happened. Okay, the reason that I knew he was going to win is because I have a very keen understanding of the American electorate and its general trends. So I knew in the spring of 2023, President Trump was going to get elected in 2024. It wasn't even a question to me. So when I saw they tried to shoot him, I was like, oh, that was not fake. Like, that was not to get sympathy. That motherfucker was already going to win. They tried to kill him. Because what happened when he came into office? The world changed. I love that man. Now, listen, I haven't seen him in a while, and though I've said it before, if Towel Grampy likes you, and Towel Grampy and President Trump have spent hours together talking about golf, Towel Grampy was a fire chief. President Trump loves fire chiefs. He loves firemen. It's really actually endearing. A lot of people are like, there's no way President Trump like actually cares that much about first responders. Nope, you're wrong. You are wrong. I have seen a multi-billionaire in Donald Trump sit with my grandfather. Now, my grandfather's a man of means. He was a fire chief for a long time, but I wouldn't call him a multi-millionaire or anything. He's just like a modest man who lives in a World War II, like, suburban housing development. Like, you know, it's from the World War II era. He's lived there forever, and he worked as a fire chief. He worked his way up from a bricklayer to a fire chief, okay? So he's just a regular guy. I, in like 2008 or something, watched my grandfather and Donald Trump sit and talk for like 3 hours. There was no reason for Donald Trump to spend any time with my grandfather beyond saying thank you for being a firefighter. I like firefighters. They could have talked a little bit about golf. No, Donald Trump spent 3 hours of his time on just I think it was like a Friday too, on a random Friday night. He was not paying attention to the women around him I was watching. He was not paying attention to anything about that. He was sitting there with my grandfather talking about golf and the fact that like my grandfather had worked on some memorial after 9/11 or something. I don't really remember. My point is they sat there and talked, and that's how I knew 15 years ago that this man was going to be a political force. And I'm telling you, that's also why I knew when they tried to shoot him that it was not because like of all these theories about, oh, like he set it up to get sympathy. No, he's going to win the election. They shot him because he's a threat to the intelligence community as it existed under the liberals, and that's exactly why the whole Karen Reed case has come crumbling down, because one side effect of President Trump coming into office was that, thank God, Josh Levy and Rachel Rollins and their sphere of influence got out of that office. Now, it's still kind of there, but Leah Foley is a genius, in my opinion. She was there back in the day under Lelling, you know what I'm saying? And she's easily going to be able to just get those, like, liberal factions in line, and she'll be like, you want to work here? Okay, well, no more of that bullshit. And I trust her to do that. I don't know her, never talked to her, but I can just inductively interpret how she's running that office, and she's a boss. Right. Now, let us play Towel Trivia. You all get rewarded. I needed some time. We're playing 3 rounds, and I'm going for a walk. You all told me to drink more water. Did you know I drank 3 of those cups today? So I'm excited. Allie and Rue are here. Allie and Rue, you're kind of screwed, though, because you missed earlier. But let me just show you the scores. All right? I'm a little towel. I have a friend who, like, every time I see them, they're like, I'm a towel. You're adorable. I find you adorable. Don't trust a damn soul, but I find you. Actually, I do trust one soul, but I find you adorable. All right, let us play Towel Trivia. Allie's right. Now we don't have to deal with any nonsense. I don't know who the haters were, but I wasn't paying attention to them anyway. All right, here we go. It's kind of hard to hate a little towel that, like, literally just will not compromise on his principles. Literally, like, I don't do anything because it's popular. I don't do anything because it will help me. I just do it because I believe it. Sorry. I might, like, withhold information to protect my sources, but I will never in a million years take a position because it's popular. I will only do it because I believe it. I've never said anything I don't believe fully. I've had to follow up with things that I thought, for example, there was a picture the other day of the CDC shooter. By the way, that's a crazy story. Now, there was a picture that came out from 2018, okay? And now it looked just enough different, all right, from the 2012 driver's license photo where I pulled it immediately, all right? There's some stuff where that happens, and that is an example of, even if I really, really believe something and you show me information that makes me question it enough, I will follow up. But everything I've ever said, everything I've ever reported, I believe fully. I believe it based on the information I know at the time, and I follow up when I need to. So, there you go. A lot of you have been watching today. That was not what I wanted to put up, though. I didn't want to put 2 chats up. I wanted to get the Trivial Pursuit stream, please. Thank you very much. And ready for this? There we go. All right, we are ready for 3 rounds of towel trivia. Now, this is just a relaxed towel trivia day. This isn't one of our like big 10-round days. We will do a 10-round day on Saturday. But to get us ready for towel trivia, I figured out a way I can announce to people that we're going to start playing towel trivia. They're going to hear it. It'll like cue them in. So if you're excited to play, if your name is Allie and Rue, if you're a towel, let's do it. This is how we're going to start off the day. Allie was like, I know who the damn haters are. Well, you hold them accountable, Allie. You know who's not a hater, though? Allie and Rue and Steph and all the other wonderful towel friends. They are not haters. All right, let's listen to Towel's favorite song. So if you're ready to play towel trivia, we're going to not do it at the outro this time. All right, we're going to do it as an intro because that will tell people it's time for towel trivia. So if you'd like to play, just know that we're starting in 3 minutes.
Welcome to Grant's Towel Trivia. All you knowledge junkies, go grab your wrench and your towel. More fun than a barrel of monkeys. Grant and his cigar is on the screen with a smile. He's got lots of questions, so we'll be here a while. All of us contribute in our own special way, and it doesn't matter who wins at the end of the day. We're the top community and we won't stop. Steph is at the top, she never does flop. Ollie, Ruth, and Nancy are sprinting towards the finish line. Kitty's 1993 is not too far behind. Tater, Bug, and Dewdrops are smart and so kind. For one family, we're family. Ruth and Cap Dawn know their stuff. Jeff's waiting on the clue. Claudia's got the answers, but Bunny does too. Lydia's sharp as a tack. Deb Potter's on the ball. Sometimes we grumble when our scores get called. Now Harvard Yard keeps guessing answers that ain't up on the board. Don't ask me how, but she just scored. Bossy Texas Chick and Bell are in last place again. They're always at the bottom, but one day they will win. Ooh, that's alright. That's what they don't let you in. Every day's a new adventure in Towel Trivia Town. KR's not guilty, but that won't get us down. From the brightest to the struggling, we all play along in this corner of the internet where we all belong. So here's to all the players and the hosts so fine in this little slice of heaven where we all do shine. Towel Trivia time. Towel Trivia. Welcome to the Grant Smith Ellis Show. When you know you know. Ooh, 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 Towel Pride.
Love it. Who's ready for 3 rounds towel trivia? I love that song. That makes me a happy towel. All right. Let me show you the scores going into our final 3 rounds of the day. My name is Grant Smith Ellis. Thanks very much for being with me for the closeout of our stream today. Not going to go too long. I'm going to go for a walk, so apologize ahead of time for the fact that it will be a truncated ending today. We went 12 hours yesterday, 7 hours today. If you support this public information service, please consider liking the stream, subscribing. It costs you nothing, and it helps Little Towel. There's donation information as well, scrolling on the bottom of your screen and in the stream description. All right, here we go. Little Towel is in first place, ladies and gentlemen. Now, Nancy Towel, if you're out there. Oh, it's Colleen Henry, ladies and gentlemen. Hold on. Before we play trivia, we have one more thing we got to do. Hold on. Everybody hold your horses. Literally, I saw horses in the chat. Everyone hold them. Try not to lose them. Grab your towel, buddy. Don't worry. Everyone find a towel, buddy. It won't take too long. I just have to do this. It is tradition. It is illegal for me not to do this. If Colleen Henry and Buck show up and I don't do this, it's literally illegal. There's some towel law in the towel universe that if I don't show this video when Colleen Henry and Buck show up, I violate the towel law. All right? I'm not going to do that. That's illegal. I would feel terrible about that. So, hello, Colleen Henry and Buck. Have you considered that that is the Call Me Head clip? You as well, Mr. Brennan. Okay, sir, I will, Hank. Sure, Allie, why not? Yes, Colleen, no cash in my pocket. I'm going right from the... Okay, sir, I will, Hank. Oh, gotta love it. I said thank you. Oh, sorry, I muted my mic. Thank you, Colleen Henry. Trust me, no cash in my pocket today. If I go anywhere, I'm going right from the ATM to get to the store, whether it's for my medicine or a snack, and I'll use my debit card if I have to. I am not running around like a mad towel and losing $140 again. Let me just tell you, that was not a good time for Towel to do that. I just, you know, I don't really care that much, but it's going to be at least a year before anything happens that allows me to be self-sufficient. So the next year is going to be a little tough for Towel. We're going to get through it, though. Keep me fed with bread and keep me with my medicine, and I'll be happy. Oh, and coffees. I like my coffees in the morning. And I like my energy drinks. I had a Swedish Fish energy drink today. It was really good. My trash can's empty. All right, here we go. Let us play Towel Trivia. Hank is dreamy. I agree. Men or woman, you can agree. Hold on one sec.
Was made to prove that he does not
have an average.
And they spend them on like outfits and like various like Italian catch a few by personal fights. Sometimes they just talk. Okay, they present data. They just talk for hours, which is great because that means I can just listen and I don't have to talk. Anyway, that's going to start about 10 a.m. this morning. So thanks very much for tuning in. I know that I forgot to mention this yesterday because, in my defense, we went for 12 hours and I worked as hard as I possibly could while sitting in my chair. Got a little tired. So I forgot to announce that I was going to cover this today. So I announced it with an hour to go because I wanted to troll Mary Alice, because Mary Alice is the press secretary or the communications chief for the CCC. And trolling Mary Alice is one of my life passions. You don't understand. You want to troll me with an official government promulgation? Okay, I'm going to troll the fuck out of you. That's exactly what it's a form of petitioning the government. I don't know what to tell you. Like, I don't think the founders necessarily envisioned trolling as a form of participatory democracy. But I say to you, ladies and gentlemen, that trolling is an unenumerated right under the, and if I want to petition the government by trolling Mary Alice, that's what I'm going to do. Anyway, my name's Grant Smith Ellis. This woman, I'm certain I have just undermined her entire PR strategy. Well, it's kind of like Roblox going at that guy Schlepp. Roblox, if you haven't been following this Roblox drama, let me just tell you, they're going to find themselves under investigation by the federal department, or by the Department of Justice and other federal authorities. Let me tell you that right now, on a bipartisan basis. They banned this very nice guy, Schlepp. He was a victim of grooming on Roblox when he was a kid, and so he became this kind of like powerhouse of a force where now Roblox, for the parents out there, we're going to take a slight aside because I just really want to talk about this story, and I'm very proud of Schlepp for what he's been doing. So Schlepp is this guy on Roblox, and what he kind of does is, if you're a parent out there, you've probably heard of Roblox, and it's this platform used by a lot of children. It's kind of cool because you can develop your own games for it, so it encourages children to learn how to interface. Not really MySpace, like HTML style interface, but it's like a rudimentary GUI that allows people to both, it's like an app mostly on tablets, and if you don't know, kids like use tablets a lot these days, okay? So the kids go on the tablet, they like move the little character around, and it's your little, like, it's kind of like a Lego character, but it moves this little digital character around, and they have all this, have fun, and they collect coins, and it has something to do with, like, Italian, like this weird version of Italian language. They meme a lot on there, basically. They like to meme. They play these games where they collect coins, and then they spend them on, like, outfits and, like, various like Italian. Right now the big thing is like Italian speaking, like it's some like Italian language. I don't know. Anyway, that's not relevant. The point is I want to talk about this for 5 minutes because Roblox is a great platform in the sense that it encourages younger people to learn how to interface with a GUI that teaches them how to develop games. So you have to think of Roblox as kind of like, it's not like a game in and of itself. It is a platform where you can play games that are developed by people who use a preset sort of spectrum of resources or assets, as they're called, and they deploy them to facilitate like different types of games. The problem is that Roblox user base is very young, and it's very susceptible to exploitation, and the company has a profit motive to look the other way. So there are these people like Schlepp, and you'll see this all over the news. It's going to get bigger and bigger and bigger and bigger. There are these people like Schlepp who got groomed on Roblox as kids, okay, and were victims. And then as they got older, they know how Roblox works, and adults really don't understand how Roblox works. A lot of these platforms are very niche. They're very like meta in the sense that if adults understood how they worked, kids wouldn't be interested in them, because part of how kids hide in plain sight these days when doing bad stuff is they prey on the fact that adults have no idea what they're doing. So anyway, Schlepp is someone who goes on Roblox and kind of exposes all of this content. And let me just tell you right now that it is very impressive that Schlepp has managed to fight this company single-handedly. He's just a user on Twitter and other social media. Schlepp goes around on Roblox and exposes predators who set up games that violate Roblox's terms of service in order to facilitate preying on children. And you might be saying, oh my dear God, how is that even possible? Well, it's because it's like, it's a check by Roblox. Like you create the game and then it gets reported and then Roblox checks and balances it by reviewing it. Well, there's a bit of a problem here because there's examples, and I'm not going to put any of them up on the screen because they're disturbing, even though they're digital images, they're disturbing. There are games that are designed to facilitate the sharing of personal information, to like literally like kind of bring children into like sexualized situations and then get them off platform to abuse them, okay? That is very serious, and Schlepp is the kind of person who understands the nuances of this because they were preyed on as a child, and now he goes and hunts the people who do this, the predators, okay? Now what Schlepp does to do this is he has adults who, he's like 18 or 22 or something. He's an adult now, but he's a victim, and he's very sensitive to victims. He has adults who are over the age of 18 go onto Roblox and masquerade as children so that they can bait, it's called a honeypot, bait the predators, and then what Schlepp does is, because Roblox doesn't always necessarily promptly effectuate reporting to law enforcement, Schlepp brings in the FBI or the local law enforcement or whoever the fuck, and then they go in and arrest the predator. Schlepp's investigations have led to the arrest of no less than 6 child predators, okay? He's a boss. Okay, he's a fucking boss. Now, the really interesting thing about this is last week, Roblox banned him from the platform and sent him a cease and desist, and then started a PR campaign calling him a vigilante. What was really going on? Oh goodness. Well, what was really going on was that Roblox, according to some lawsuit documents, is aware of this problem. They try to work with the National Center for Missing and Exploited Children. They try to refer things to the FBI ostensibly, but they don't really action the content proactively because it would drive users from the platform. That's what is alleged in testimony from a former Roblox engineer in a civil lawsuit. Okay? So Schlepp gets banned from the platform. They send him a cease and desist. This one, he's only like 22 or something. He's like 18 to 22. This one kid goes on social media, and I was talking to him like 4 days ago, and he's like, fuck it. Like, these people are covering something up. He starts petitioning the Congress. He starts petitioning the Roblox channels. He starts petitioning like people like journalists like me. All of us start covering this thing. It gets into Wired. It's on the 2 congressmen, a Republican and a Democrat, Ro Khanna and another congressman. Hello, you have fun on your run, Faith. Well, I'm going to broadcast a regulatory hearing at 10, and I'm talking about this really inspiring guy, Schlepp. I don't want to put the images up on the screen because it's disturbing. Rightfully so, though. Like, parents should understand that if you put your children on Roblox without knowing what you're doing, you're exposing them to the potential of being able to access some of the games that Schlepp is trying to bring to public attention. So anyway, Schlepp starts this campaign, okay? It's like, this is a multi-billion-dollar company with a CEO who, like, went to President Trump's inauguration. Not that that's commentary on President Trump. I'm just saying this is a heavy-hitter company. He took him on single-handedly. Their PR department starts labeling him a vigilante. That causes a Streisand effect, wherein all these national publications and half the internet burns down Roblox, basically, and that's what's happening this morning. Okay, so Roblox tried to put, like, a crisis statement out yesterday, doubling down on the vigilante claims, and now the whole internet is just upset at Roblox, rightfully so. But a byproduct of this, which is why I think we're moving into a better era of humanity, a byproduct of this is the reason parents weren't actively monitoring Roblox is it's hard to understand what it is. It's kind of like talking to parents about, let me use an example, like your children who are 9 years old may be really interested, or 15 or whatever, in like Fulio versus like Young E. Nace, okay, down in Jacksonville. They may be really interested in Tukaville in O-Block out in Chicago, okay? They may be really interested in the Bloods and the Crips into the GDs and the BDs. They may know everything about like King Von's ops or whatever, like specific social media posts. The reason this is happening is the same reason that Roblox is being able to permeate in the national consciousness, which is parents would rather their children just be passively consuming content that they don't understand, even if it's harmful, as long as they're quiet. Now, I'm not speaking about any parents. Listen, I have seen my own cousins. I've seen them fall victim to this. This is how I know about this. I was just at my father's funeral, celebration of life a few months ago, and this came up. I watched them, like, talking about this stuff and playing on Roblox. This is why I got so concerned. And so, anyway, we have this situation where it's very easy to let children consume content that looks ostensibly okay. Like, it looks like just music, or it looks like just a game on a tablet. But really, it's pernicious, okay? It's either gang culture in the music scene, or like murder-based gang culture. Like people who have bodies on them that make songs about it, that then children want to learn about because there's interesting sort of socio-political dynamics behind the songs, where if you like learn about Parkway Gardens and O-Block and all that stuff, you'll find out that it's not just a song, it's a whole culture represented in a motif that is a song, and these people have bodies on them and they brag about it. It's a little weird. I think it's all a federal op, personally. I think that a lot of those hip-hop artists, even though they're hitters, are just federal agents or federal CIs, like 6ix9ine's a good example. But Roblox is just by analogy. I don't mean to get off topic here, and I'm just waiting for the meeting to start anyway. Roblox, and I don't want to talk about the testing lab fraud. You can listen to them talk about it. I'm so tired of talking about it. I don't know how much more you want me to say about it. The testing lab fraud, it's cascading across the country. But anyway, Roblox is really dangerous, and Schlepp got banned because he started bringing this attention to how the platform was exploiting parents' inability to understand the nuances of this game and the way it works. So Schlepp gets banned, starts this movement. It's now in every national publication. It's started to get to Congress. I'm sure the DOJ is going to investigate them. You know what the DOJ is going to find? They're going to find that this company made a conscious choice to not proactively use algorithmic filtering to target this kind of behavior, and instead enabled it because it was a passive way, negligence by omission, in my opinion, to facilitate shareholder profits. Okay, it's very simple. It's not really hard to understand. What's hard to understand is why they Streisand affected it. What you do is you shut the fuck up, and you say nothing about Schlepp doing that and let him keep reporting shit to the cops, and everybody's happy. He gets to report things to the cops and prevent these people from abusing your platform. The cops develop better processing mechanisms for dealing with these reports. The NEIMC can then liaise with you to develop proactive monitoring. Everybody wins, which means the only reason that Roblox did this, in my opinion, is because Schlepp was going to bring to the national attention, and now it's really happening, which is a rightfully deserved fate for Roblox, the fact that their platform is very susceptible to abuse because parents don't really understand it. Hello, Jesse. It's great to see you. I'm covering a regulatory hearing today, and I'm also talking about this guy, Schlepp. You should check out this story. You'll see it in Wired, New York Times. You'll see it everywhere right now. Roblox is burning down. If you're a parent and your children use Roblox, please pay attention to Schlepp, S-C-E-H-L-E-P. He's in literally every news article. It doesn't even matter. Democratic supporting, Republican supporting. There's going to be chaos for Roblox because of what Schlepp has uncovered. And it didn't have to go down this way. And the only reason I think Roblox targeted him is because Schlepp was not just getting these predators held accountable, he was starting to raise awareness to parents that Roblox is a platform that can be exploited. Any platform can be exploited, by the way. I don't want to make it like you could exploit Google. If you were a predator, you could exploit Twitter. It's not whether, if there's a predator out there, they're going to exploit any platform they can. But the issue is what the platform does to respond to it when they're made aware of how it's being done. Platforms understand their back-end software better than anyone else and the way the code functions. So you can make a conscious choice to drive people away from your platform by proactively monitoring for this. Habbo Hotel's a good example. Club Penguin's a good example. If you want to create a game that's going to attract a younger audience, you have a duty. I would say, I'm not a lawyer, this is not legal advice, I would say you have a common law and a statutory duty to the children, okay, under multiple different federal and state statutes. You have a common law duty to protect them. And if you're going to run, like Disney, as much as I don't really like their Mouseketeer Club thing and how that all played out and Diddy's involvement, whatever, that's scary. I think Disney does a far better job like developing these online web-based games for children than Roblox right now. And we need to have regulation of children's access to these platforms, and you can't expect children to regulate themselves. I don't want to go down the path of requiring people to upload IDs, okay? That's very dangerous. I don't like how it worked out in Britain. But I'm very concerned that these companies are not going to regulate themselves. Just like in the cannabis industry, they're not going to regulate themselves. Some of them will. But one bad apple spoils the whole bunch. One bad platform like Roblox is going to attract so many children that if you have flaws in it that facilitate exploitation, and then your company's reaction to it is that you double down on preventing reform, you have to be regulated. I'm sorry. You potentially should be investigated by the Department of Justice. I'm sure they're already under investigation, in my opinion, based on the congressional referrals. But more so than anything else, you're going to get regulated, and you should be regulated. Our laws and our regulatory frameworks are not adapting to the developments in digital technology, and setting aside whether we think there's too much government regulation, whether the bureaucracy is corrupt, whatever. Fundamentally, we cannot just abandon the project of regulating companies because there's emergent technology that absolutely must be subject to regulatory oversight, and we'll talk about it in the context of testing lab fraud today, and it makes a perfect corollary. That are going to do whatever they want to drive up their profits unless we actively intervene as a society in different countries, different states, and regulate them. Okay, companies don't do things to protect vulnerable people unless you force them to. That's not big government. That's making sure that companies are accountable. And you might say, well, it's a free market. It's not a free market. Read Adam Smith, read The Wealth of Nations, in particular his analysis of wheat prices in the 1700s, and read the commentary afterwards. You will see that we have never been a free market. We are a regulated market. A free market would literally lead to oligopolies and monopolization in the name of market freedom. That's not what we have. We've never allowed one company to own the entire country. We've never allowed companies to kill people in the name of profits. We've never allowed people to sell tuberculotic beef in the name of profits. That's not big government. That's the foundational pillars of the safety net in our society to prevent corporate greed from undermining in this case, the safety of vulnerable children. So we must regulate this. And I'll go to Congress myself. I don't really want to, but I will go into government myself, if you really want me to fix some of this, because we must develop cogent and rapidly dynamic forms of legal and regulatory oversight related to these platforms. There's billions of children using this around the world. Okay, they're not really being watched. You cannot defer to the parents. It's not the 1980s. Okay, they have unfettered access to technology. The devices don't provide sufficient parental controls to ward off this happening. And in fact, no matter what parental controls you put in place, if you have a GUI client that the child is running as a piece of software on their computer or their tablet, you could have all the parental controls that you want. They're just going to bootstrap in the content that you're trying to prevent them from getting access to. The predators, that is, are going to bootstrap in the content that the children aren't supposed to be accessing by way of the files. Once you have a executable that has permission to run in the graphical user or in the operating environment, which is the tablet, for example, in this case, once the software has permission, it doesn't matter what parental controls you have in place. It's not going to check and balance the code of the software. The software, people like Roblox, the companies deploying them, have to proactively deploy parental controls. We must regulate them. We must force them to do it. If we do not do that, they're going to continue to facilitate behavior that threatens the safety of all of the children of the world, frankly, because these apps are very prolific, okay? Because it makes them a lot of money, a lot of ads, whatever. We have to regulate this. We have to do it right away. And Schlepp is the perfect example. And if you haven't seen this Schlepp story, just Google it. SCHLEP. Every single news publication. It's everywhere. This company is burning to the ground because of one man who they very, very ill-advised, in my opinion. They took a very ill-advised approach to him by attacking him and labeling him a vigilante, which has caused half the internet to expose what Roblox was doing. And now the very parents who never would have found out what this platform was enabling know everything about it, and they're angry. All right? So that's some justice. How about that? We'll see, Peggy. Oh, Jesse, very good. I'm so glad you're going to look more into this. And again, I'm not putting the images on screen because there's no way I can cover what Schlepp uncovered on Roblox without putting they're not real people. They're like avatars, but everything that Schlepp uncovered is really, really messed up. Like, it's like children being targeted by adults using like the Roblox platform, and some of the text they put is really scary, okay? And some of these games that are still on Roblox have been up for like 1,000 days or more. Anyway, testing lab fraud. So, we've got a lot going on. I've talked about it before. I only had 20 minutes today. If you thought I was going to do a full overview of the testing lab fraud situation in 20 minutes, no. It's like an hour. But I'll tell you this. The Cannabis Control Commission is going to have a regulatory hearing today. You can see that live event hasn't started. Once it goes live, I'll just bring the coverage up. I have a screen ready to turn us over. And let me just tell you, this regulatory body, okay, and we'll play tile trivia at lunch. This regulatory body did a very similar thing with some companies, not related to child predation, but related to manipulated total yeast and mold testing. There was a release, okay, in the last few weeks of 7,000 or 6,800 or so batches of product that were tested by a laboratory called Assured. Okay, now Assured got its license summarily suspended on July 4, 2025, because they were deploying a type of PCR methodology. It's actually called microarray hybridization. Now, normally to test for pathogenic total yeast and mold concentrations or presence, you would use plating, and in the cannabis industry, as opposed to the agricultural industry, you culture the sample on something like a 3M Petri film for 72 hours, and then you test for the presence of total yeast and mold. However, because there's a rapid turnaround time demanded by a lot of clients, and because there's an incentive to help clients pass product that would otherwise fail, there are also alternative methodologies. Some work, some don't work. Some work for certain pathogens,